For the one of them.
Thank you. That always throws people like, hey, what do I do with that?
Games.
All right, we are not on the record yet because the court reporter hasn't made it in. She is working her way through some traffic. Mr. Hiles, is there anything that you think we can discuss not on the record right now? Logistics, plans for today? Your two witnesses are here and ready to go?
Okay, yeah, they're sitting outside. There we go.
Hey, no problem.
And then, you know, I guess as far as it goes, Mr. Pritchett and I just had a discussion about the potential joint recommendation of Part 3. If he wants to do that, I think we need to do that now, or not do it at all.
Okay, well, I'll get to him in a sec as we go around, but we'll be able to be on the record in just a moment.
And then
All our jurors are here and are ready to go. We need to speak with one juror before we start. You ready? Great. All right. Let's get on the record. It is Monday, April 29th, a little after 9 o'clock. And this is day 6 of State versus Pritchett and Robinson. We have our prosecutors here. Ms. Mignot and Ms. Blake are here with Mr. Robinson, and Mr. Pritchett is here. Mr. Hiles, I'll start with the state. Anything we need to get on the record before we bring the one juror out who has something she needs to share, and then her 12 other colleagues?
Yes. I would like to go ahead and tender into evidence the certified conviction, as well as the original first offender sentence and revocation and entry of adjudication of guilt under 18 SC 158229 for State versus Maxx Pritchett, which was the 2015 incident, which resulted in the home invasion that resulted in the death of a Greer. The court has instructed that there be no mention of the death of Jose Greer in front of the jury. So I have redacted the what's been marked as State Exhibit 37, take away all mention of felony murder.
37 is?
37 is the redacted copy. 37A is the original certified copy.
But 37 would be the indictment, the plea, the sentence, the resentencing. It's the whole packet.
Both, yes.
Okay.
And yes, both 37 and 37A are presented as the indictment, the first offender sentence, and then the revocation and entry of adjudication of guilt. Got it.
37 is redacted, 37A unredacted.
Correct.
And you are tendering both right now. 37A will be made part of the record, but will not be shared with the jury.
That's correct.
Okay. And those are certified copies?
Well,
the only ones that could be certified would be 37A.
Yes, 37A is certified copy from the clerk, and the redaction, which has been completed in the defendants, or the exact copies minus the mention of felony murder.
I think it just shows a burglary.
That's it.
Okay, all right. Those are self-authenticating court documents if they're certified, which they are. Ms. Mignot, any objection to the admission of 37A? That's really what would be admitted. 37 is, they'll both be admitted, but 37A is the original evidence. Any objection to either?
And I believe 37 indicates certified convictions and revocations not pertaining to my client.
Both, correct. 37 and 37A, they're related documents. They're all Pritchett. 37A is the originals with nothing redacted. 37 is redacted. Your client's not even in the indictment, so he is nowhere on it. And before Mr. Hiles discusses any of that with the jury, I'll be giving a limiting instruction that anything and everything that comes in through Detective Velasquez relates, if it relates to anyone, it relates only to Mr. Pritchett.
Thank you, Your Honor. No objection to 37 or 37.
All right, Mr. Pritchett, any objection to states 37 or 37A?
What is the relevance? I know what is the relevance?
Well, I don't decide relevance, but if you're objecting on relevance, I will tell you that I've already ruled. We had a hearing a while back, and you were here. Ms. Williams represented you at that time on this 418 motion that the state filed, and they argued successfully, in my mind, under the state of the law, that evidence of the prior home invasion case ought to come in because it was their claim gang related. And even if it's not gang related, burglary and home invasion are crimes that come in under the rule of evidence 418 if there is a gang prosecution, because that is the type of offense covered by the Street Gang Terrorism and Prevention Act. So I've already ruled that it's admissible, it's probative as to potential connections to a gang. In theory, it would be the same gang, that's what the state would argue, but it's also probative, I've found relevant, because the state is going to use it to attempt to explain why, in their mind, if you were involved with this home invasion, you elected to leave your phone at Voss Coleman's residence. It's kind of strange talking to you about this because I'm not making any findings at all. I don't know what the jury is going to decide, but the state's theory is, one, it connects you to gang activity. It comes in under 418 that way. Anyway, it has additional relevance in that it explains why you would think, hey, let's leave our phones, Tyrone and Maxx, at Voss's place and just use the girls' phones for the ladies' phones for the home invasion. So I want to be real clear. I'm not pinning any of that on you at all. That's what the state's arguing, but that's why I found that it was relevant. And these convictions are simply proof that, well, conviction, and then it was a first offender finding, which is not a conviction. And then, as you know better than I, that first offender conviction was revoked, and a different judge entered a guilty conviction for burglary at that probation revocation. And all of that is just proof that you were involved with that first home invasion. So there's a whole lot of words. It's actually not that complicated, but you ask a fair question, and I wanted to give a thorough answer.
Yes, I would just object to the relevance and the fact that I wasn't present in that hearing when that motion was ruled upon or argued about, and just for the other side of why that was admitted, I would object to just speculation.
Okay. I will overrule, but I understand your objection as to relevance. I'll overrule the objection as to speculation. I don't think that one is as well placed as the relevance objection. And I want the record to be clear that while you may have chosen not to be present for the hearing, your then lawyer argued very effectively, opposed the state's motion. I ruled against her, not because she had a bad or weak or insufficient argument, but the law is very, very accommodating to the state in Georgia when it comes to admitting other acts evidence through Rule 418. So your objections are noted and preserved and overruled. Mr. Hiles, anything else from the state? Ms. Mignot, anything we should talk about before we start the jury process for today?
Just one brief moment.
Sure.
No, Your Honor.
All right. I hesitate to go near this can of worms, but I couldn't help but overhear wait, I didn't get to the PowerPoint yet. Have you had an opportunity to look over the changes that I required Mr. Hiles to make, or that he volunteered in certain areas to make, to what we've been calling the Miller PowerPoint? And if you did have an opportunity, even though it may have been just now, are there any concerns? You've preserved all sorts of objections. And when Mr. Hiles tenders that as a demonstrative aid, all you'll need to do is say, I renew my objections. I'm just wondering if there are any new ones so that they don't cause us to have to send the jurors out when Investigator Miller takes the stand and Mr. Hiles tenders whatever exhibit number that's going to be.
Yes, Your Honor. I am glad the court brought that to my attention.
I'm not, but I needed
It
to.
would have happened before the jury. And we had this in the back.
Yeah.
In efficiency, Mr. Hiles, we had a long discussion with the court that Mr. Hiles was going to send the redacted PowerPoint presentation, so I would have an opportunity to look over it. I think I remember saying, not at 7 a.m. on Monday morning. However, I didn't get it at all. And Mr. Hiles has replaced it, and I object to the one he replaced it with. And he also, instead of removing one, modified it. And that was not the agreement that we were going to modify it. When the court said 15 is out, 20 is out, 21 is out, and if you want to replace 20, you can replace it with something, and whatever you replace it with, you show it to Ms. Mignot, get her the PowerPoint presentation so she can address that. That did not happen. So I object to what he replaced it with, and I object to the modification of the one he kept in.
Okay, I'm gonna add a little bit to the record you're making. I have the same recollection as you, that you and I were told that we would get the PowerPoint far in advance. I didn't get anything. So apparently it went to a different defense attorney and a different judge. I kept some pretty clear notes, so I'd love to see what we've got now. There were certain things that I directed needed to come out, not modify, but come out. It was really, I think, only slide 21, which had the gravestone of a rival gang founder or something that had been defaced. That needed to come out, but I may be misremembering. My notes say these other slides needed to come out. Where there's only going to be one hybrid slide, not two. I don't remember what slide 20 was, but I have there that it was coming out. But I'm going to turn to you, Mr. Hiles, and why don't you, because I don't have the new one, I can't look at it to say, yep, that complies with what we talked about.
I thought it was sent in court, forwarded from Mr. Abate, like he would have done before that. So if you want, I replaced the slide with the person holding the exotic, talking about exotic snake.
Oh, right. You were going to replace that with, we did discuss that, but what number is that one?
I'm not sure what number it is now.
Well, here, I have the old one. And so we're going to work through that. I'm pulling it up now. So slide 20. Okay, slide 20. I'm going to write reptiles. Slide 20, I had said needs to come out. There was one that just looks like you're in the jungle, and another, maybe some rebel in a country, and then a guy with two serious looking guns and a snake. And you said, you know what? I'd like to replace all those with a still from whichever of the two videos that that are coming in against Mr. Robinson. And what you represented was you were going to get a still from that. Is that what you did?
Well, yes, but it was a still that was posted through Instagram.
Okay.
So, but yes, I did.
Posted through Instagram by?
It was posted by Slim Santana, but it was taken off of Mr. Robinson's phone.
So it was found on his phone?
Screenshot.
On his phone?
Yes.
Okay. And what's that? Oh, something just came.
I don't, well, we can shorten to make it easier. I'll just take it out. It's not, I don't think it adds anything necessary, and that way there's no objection to preserve.
Okay. I see it. Yes. So it is now 19 in your revised one, and you're going to take 19 out. Okay. It looks like you took out 15. That was the second of the two hybrids. So now we just have hybrid vehicles. So that's consistent. On what is now 20, was 21, that's labeled tagging. You complied with the request, not the request, the direction to remove the gravestone. And so we've got the house that is marked up and the fence. And I understand Ms. Mignot has lodged objections to that. It's a different address, it's an abandoned house. I overruled those. So Ms. Mignot, any other slides? I think you had said there was some other new one. I'm not seeing other new ones in here. It doesn't mean there aren't. But tell me, using page numbers, to which you continue to, I'm sorry, not which you continue to, because you've preserved all your objections. If there are any new objections, now that we've addressed that, what in the new one is numbered 19 is coming out, and that's a different snake picture.
The only issue I had, Your Honor, is that number 21, I understood the court's instructions was that it was out, not that it was modified. The state was supposed to modify that.
You're talking about old 21 with the gravestone?
Yes. the
Okay.
regular one. That was my understanding when the court said 21 is out. It didn't say 21 is out unless it's modified. So now we have 21 being modified. I would still object to 21 based on the court's ruling that 21 was out. I think we're teetering on trial by ambush when the court issues an instruction that something is out. That we should not interpret that to mean as counsels of the court. Doesn't mean it's out if I change it, if I modify it.
Okay,
So 21 is still an issue for me because I was under the impression that 21 was out. I did know that the court instructed that 20 would be replaced. And the court made that explicitly clear that 20 was gonna be replaced with something else. And before I objected, I should wait and see what it was being replaced with.
Got it.
I know that issue's been resolved because Mr. Howes is saying he's removing it. But 21, I think in fairness, should also be out based on the court's ruling. Everything else is just the same general objection that I believe that this demonstrative is more prejudicial than probative as it pertains to the charges in this case, the facts of this case, and how this case went.
got it. Understood. So I have a different recollection than you. The record will show whatever was discussed last week. But my clear recollection is that I directed Mr. Hiles to modify what was 21 and is now 20 to remove the gravestone, because it started with a question of whose gravestone is that? And if it was just a random citizen, it was definitely coming out. He explained it wasn't, but I still decided that picture should come out. And so I find that Mr. Hiles hasn't ambushed anyone, but has complied with my directive. If for some reason I'm misremembering, I do find that what is now slide 20 was 21 is appropriate and can be part of the demonstrative aid that this PowerPoint is. The question about the reptile slide, which used to be 20 and is now 19, is moot because Mr. Hiles is going to remove 19, which was a replacement, which was the offer he made when I said none of the reptile pictures in what was 20 were acceptable. I misunderstood him and thought he was going to insert a photo from one of the videos in which Mr. Robinson appears, but it doesn't matter because you're going to take 19 out anyway. So I don't need to say anything more about that. And otherwise, I find that you complied with my directions. So you've made your record, Ms. Mignot, and you can renew it when this is tendered simply by saying we renew our earlier objections, and I'll make a clear record of that. Mr. Pritchett, anything you want to add beyond what Ms. Mignot had to say about the revised PowerPoint?
No, I would like to adopt her objections to it being more prejudice than probative. Yeah, just like you for 19, the hand signs, like there's no photos of me ever throwing a hand sign up, or I just feel like things like that are gonna be prejudice.
Okay.
Or the extra things surrounding whatever was shown in the photos that on me.
All right, got it. You've preserved those objections, and you previously adopted and added a few when we talked about this before. So all that is protected, and you've preserved those. I'm going to allow the presentation as it is, with a reminder to Mr. Hiles that I will be that annoying amusement park person moving the line along if we dilly-dally on slides that don't relate directly to this case for too long. And we'll see how that flows. Ms. Mignot, anything else on behalf of Mr. Robinson?
No, Your Honor, but I do have a separate matter that I'm gonna need the court's assistance with. I do have an emergency situation.
Uh-oh, you need to step out?
No, I need the court's assistance with it.
Okay. Let me see what's going on with Mr. Pritchett, and then you and I can, you believe we can talk ex parte?
Yes, sir.
Okay, we'll do that. Mr. Pritchett, is there anything you want to discuss before we bring jurors in? Okay, all right, Ms. Mignot, let's take a quick second, and then let's bring juror 39 in. Hey, all right, how are you? Thanks. Well, hello. 1 second. Everything's good. That actually didn't come from the court. It came from opposing counsel, who didn't handle it well. Apparently, it's been reset a couple times because people are busy and life is complicated, but it will be reset because you are unavailable as vouched for by the judge, in front of whom you're appearing right now. So you bet. Sorry to keep you waiting, just working through an issue. So you are juror 39. That's the way we're going to refer to you for this discussion. And Deputy Gordon mentioned there was something we needed to talk about.
Well, Your Honor, thank you so much for inviting me to discuss this. So it's a personal matter. On Wednesday, May the 1st, that's my putting ceremony for my master's degree.
Oh my gosh, you need to be there for that.
Yes.
Okay.
It starts at 9 a.m. So I was concerned if the trial does not end on Tuesday as we expect. So we need to just.
Could we all come if the trial's still going and we pause? Could we all watch you get hooded?
Yes.
Where does it happen?
GSU.
Okay. How long do you think that will go?
Well, I think maybe 2 or 3 hours. I'm not sure.
Okay. Know that you will be there. We'll figure out where we are. If we're not done and we need to pause and just start that afternoon, that's a once in a lifetime situation and would definitely qualify as one of those hardships that we had a chance to talk about. But Wednesday was far outside the window we were discussing. So don't worry about that anymore. You will be there for the hooding ceremony. Okay, thank you for flagging that. That is our alternate, so people know where she falls in the process. All right, unless something changed in the last few minutes, I think I can bring the jurors in now. So seeing no one react otherwise, all right, let me connect that. Hold on 1 sec. It's a lot of moving parts this morning. The judge was actually on the bench. I don't know why she answered her phone. She's like, hello, what is it? It's like, I have Ms. Mignot hostage. Okay, thank you. We had a rookie setting up the Zoom today, so that's probably what happened. What's on the screen? Is it like art? So it is art. It's like Michelangelo having sculpted something.
Did you?
It was done by someone else, so I will forward it in a moment.
That's what you want.
Let me find this here. Cool.
Oh, I see. Yeah, I see it now.
So you got the link?
Yes, we got an email from Ms.
Ms. Hansberry. Yes, she is substituting for Ms. Nelson today. So everyone got it?
We had it.
I just got it.
Okay, great. All right, let's bring those jurors in. They must miss us.
All right, the jurors.
Happy Monday, jurors. You look awfully perky for a Monday morning. This is our first Monday with this kind of relationship, because last Monday it was kind of anonymous. You were one of 51 or however many we had. So this is a different Monday. Hope you all had a good weekend doing something other than thinking about this case. I went to the Renaissance Festival with a couple of my kids. One of the new foods there was, it's always on a stick. That's how they do things. And it was s'mores on a stick. And we're intrigued by that. It turns out it's golden grams with like melted marshmallow and chocolate on a stick. It tasted all right, but I was a little underwhelmed. Like that would be like an actual s'more. But that was my way of taking a break from State versus Pritchett and Robinson. You all can be seated, but we're back. The state continues to have only 2 witnesses left. I asked Mr. Hiles this morning, any change in that? And he said, nope, 2 witnesses. So we will get through those witnesses. The state will rest, and then we'll see where that takes us. Mr. Hiles, call your next witness, please.
Call former detective Vincent Velasquez.
And as he is coming in, I need to share with you all that this witness is going to be presenting testimony that, if you credit it in any way, is relevant only to Mr. Pritchett, the accused. Whatever he shares with you should not be considered in any way as to Mr. Robinson. Morning, sir.
You swear affirm the testimony will give the truth, the whole truth, nothing but true self-love.
I do.
You ready? Can you say the spell your name for the record?
Vincent Velasquez, Velazquez.
Good morning, Detective Velasquez.
Morning, sir.
I direct your attention to what has already been admitted as State's Exhibit 2. Which listen to this, please.
Atlanta 911 operator 6561, what's the address of your emergency?
1325. Someone's trying to get into my place.
1325 what?
898 Oak Street.
What's the address?
898 Oak Street.
898 Oak Street?
Yes, Unit 13.
Is that 1 minute, is that northwest or
They're trying to
southwest?
kick my door down.
Northwest or southwest?
Southwest.
And it's unit 1325.
Yes.
Can you see the people?
Yeah, they're
How
kicking
many?
at my
How
door.
many? How many?
Looks like 2.
2 males?
Yeah.
What's your name?
Jose Greer.
Mr. Greer, what's the phone number you calling me from?
678-314-1245.
678-314-1245. Can you tell, do you have any clothing description of either one of the males?
No, black. They look black. I'm on the 3rd floor. I might jump off the balcony.
And they coming through the front door?
Yeah, it's an apartment complex.
And you're on the balcony, you said?
3rd floor. Please send someone. They kicking the door in, Pam. They just kicked it in.
Detective Velasquez, do you recognize that phone call?
I do.
I didn't recognize that phone call.
That's the 911 call from Mr. Jose Greer that I obtained during my investigation pertaining to a burglary that was occurring while he was in his house.
Okay. Where do you work right now?
I own my own private security consulting firm. I'm retired.
Okay. Where were you working on December 8th of 2015?
Atlanta Police Department,
Okay. And when you worked at the, how many years did you spend in the Atlanta Police Department?
22.
Were you ever part of the cold and complex case division?
I was.
Okay. Is that where you were assigned on December 8th of 2015?
Yes.
Did the 911 call that we just heard from Jose Greer, did that come to your desk as part of a complex case?
Yes, it did.
Okay. And what were the complexities of the evidence that required it to go to yourself?
So the date of this call, actually, I received the case the morning after, when I think first the precinct detectives were handling the case. And then the fact that the victim jumped off the balcony was unusual, and there were some complexities to that case. They transferred it over to our unit and then assigned it to me. And also the extent of the victim's injuries.
Okay. Was the data in which you used to solve this particular case complex in itself?
Some of it was, yes.
Okay. So let me go back to the date that you were assigned this case. How were you able to start your investigation?
The first thing I did was I went back to the scene and spoke to the manager of the apartment complex. I believe her name was Kimberly Mitchell. From that conversation with her.
Hold on 1 second. There's an objection. Yes, sir.
He's reading off or something.
Okay. Mr. Hiles, can you manage that, please?
So, Investigator Velasquez, if you need to refresh your recollection with your case file, you're welcome to do so at that time, but please don't read from it. And I would just ask that if you're not using it, you just close your file and set it to the side.
Okay.
Does Mr. Pritchett have a copy of whatever Detective Velasquez is looking at?
Served one in the motion, but I will give him an identical copy right now as well.
Great. Thank you. Does that leave you without one?
No.
Okay.
And after speaking with Ms. Mitchell, what were you able to determine?
I was able to get surveillance video of what she felt being the manager in relation to the time frame the incident happened with the 911 call that showed 3 black males entering a pedestrian gate, identifiable from the camera view. I was provided a copy of that video, and at that point I released that video to the media, asking for the public's assistance through Crime Stoppers to identify those people.
I'm going to show you what has been admitted as State's Exhibit 37. It is a conviction, a first offender plea for Maxx Pritchett, and then as well the sentencing for the actual adjudication of guilt. You recognize the name of that indictment?
I do.
Okay. And all of those subjects that you were able to develop as being involved with this burglary, home invasion style burglary of Mr. Greer's apartment?
Yes.
Okay. Will you please read to the jury the names that you identified as being part of this burglary?
Frederick Jamal Clark, Voss, VAS, Coleman, Maxx Pritchett, Mark Steven Spencer Jr., and Lil Shay, Lilche, Stafford.
How were you able to develop those names as suspects in this particular investigation?
Through Crime Stopper tips as well as social media.
Okay.
Sir?
On the admission of the exhibit, can there be a specification on what type of adjudication of guilt that was? What type of plea that was?
For you?
Yes.
So two things, it's in the record, so it will say. Two, you'll have an opportunity to cross-examine the witness. So if you feel like something wasn't sufficiently clarified, you'll be able to get this witness to read from the records in the same way he just did when he said, here are the people who were charged. Okay?
Sorry, so you said you first developed over social media. Now, the individuals that you were able to come across that are on that indictment, did any or multiple of those have nicknames that they went by?
Yes.
Okay. What are the names that you recall? Do you recall if Maxx Pritchett had a nickname?
I do. He had a social media handle. May I refer to my report?
Yes.
And for the record, this is my whole investigative file, my actual report.
We got another question. Did the name Rick Ware ever come up in your investigation?
Yes.
Okay. And how did that name come up in your investigation?
Rick Ware was the defendant's Instagram handle.
Okay. And the defendant being who?
Maxx Pritchett.
Okay. And do you see Maxx Pritchett in court today?
I do.
Okay. Would you please stand up and?
What's the objection?
That isn't in the investigation.
So why don't you, should you choose to cross-examine this witness, you'd be able to say, show me where it's in the investigation. But this witness has testified that he associates Rick Ware with, the jurors heard what he had to say about Rick Ware and you. So back to you, Mr. Hiles.
Okay. So you testified that Rick Ware was the Instagram handle. Did Maxx Pritchett have an actual different name for his Twitter? You recall?
He did.
Okay. And do you recall what the Twitter name was for Maxx Pritchett in this case?
It was Sartorial Savage.
Those were two separate social media accounts, correct?
Correct.
Okay. What about Voss Coleman? Do you recall any nicknames that Voss Coleman would have had?
Young Bands.
Young Bands?
BANS.
Okay.
Yes.
Now, were you able, at any point in time, did cell site location information or call detail records ever become a part of your investigation?
Yes.
Okay. And how did they become a part of your investigation?
I was able to get phone records for the defendant on trial today as well, and then transfer that information to one of our cell phone experts within the unit, was able to track those cell phone records using cell tower data and triangulate that location that coincided with the location of where the crime occurred around the time the crime occurred.
Okay. Now, did everybody that's on that indictment play the same role in this burglary of Jose Greer?
No.
Okay. Please tell the jurors what role, and if you need to look at the indictment that's in evidence, you're more than welcome to read from that. But tell the jurors by name and what role each individual played in this particular burglary.
This particular case, 5 suspects showed up at Mr. Greer's location. The 5 individuals that I named earlier: Mark Spencer, Frederick Clark, as well as Lachey Stafford, left the vehicle and actually went to the victim's door and were trying to get in and kick the door in eventually. The defendant, Maxx Pritchett, and Voss Coleman stayed in the car.
Okay. And through the course of your investigation, were you ever able to determine why Voss Coleman and Pritchett did not actually go into the apartment complex?
My investigation revealed that the group felt that Voss Coleman was too young. He was, I believe, 16 at the time. And the defendant, Maxx Pritchett, had an injured foot, and it was decided that he'd stay in the car because of that.
Okay. Was Mr. Pritchett determined to be the driver?
That's correct, he was.
So, Mr. Pritchett drove Voss Coleman as well as the other 3 individuals to the incident location. And is that your testimony?
That is correct, yes.
And as they got out and actually made entry, is that correct?
That is correct.
Now, was there ever any property taken from this incident that you were able to track down?
Yes.
Okay. How were you able to track down that property?
So what was taken in the burglary was the victim's wallet, a work laptop, a work iPad, and a work cell phone, an iPhone. Victim worked for Comcast. Through my investigation, I was able to recover the laptop and this iPhone. The wallet surfaced later through my investigation, where one of the defendants, Lachey Stafford, displayed the victim's ID, and the person they displayed the victim's ID to, and the wallet and credit cards, had seen the Crime Stopper story and recognized the photo of the victim, and then reached out to me.
Okay. Were you ever, what was the date of this crime again?
December 8th, 2015.
And did you ever, well, how central to the investigation was the call detail records and the cell site location information?
Very essential. It allowed me to actually look at the suspects' cell phones that they had in their possession and triangulate that and actually put them at the crime scene.
Okay. And were you able to do so for all of the defendants that were charged?
I believe so.
Okay.
I believe all 5.
Okay. And did that reinforce what you had uncovered and believed to be so from the rest of your investigation?
It certainly corroborated a lot of the other information that I received,
Yeah.
yes.
And there's call detail records and cell site location information. Is that something that you would have, or that you did compile and place in your investigative file?
Yes.
And is your investigative file more than just this 40-page report?
Oh, yes. It's 3-ring binder, probably that thick.
Okay. And was those records part of the file that would have been turned over to the district attorney's office for the prosecution of this case?
Yes.
I know there was a lot more that went into this, but is this the absolute abbreviated version of what's going on throughout the course of the investigation?
Very, very abbreviated, yes.
All right, I don't have any other questions for this detective.
All right. Ms. Mignot, do you have any questions for retired Detective Velasquez?
Very brief.
Good morning, Detective Velasquez.
Good morning.
As it pertains to your investigation and your involvement in the December 8th, 2015 case, my client, Mr. Tyrone Robinson, had absolutely no involvement in that case, correct?
Never heard his name mentioned.
Thank you. Nothing further.
And turning to the accused, sir, do you have questions for the witness?
Yes.
Great. Come to the podium, please.
Greetings, Mr. Velasquez. How are you doing today, sir?
Good, sir. Thank you.
With the exhibit that the state just handed you, I believe it was a plea agreement. Can you read on there, if you can find it, the specification of that plea, like what type of plea specified on there that was taken by me?
Okay, if you just allow me a minute to read through it.
So I think the question is, and I'm not in any way putting words in your mouth, but we call them final dispositions. So ultimately, the case was resolved, and part of what Mr. Hiles tendered as states 37, and I think it's going to be about the next document he's going to get to, is that initial final disposition, which it sounds like involved the plea, but we'll let the witness look at it. One more page, and there's a final disposition.
Understood.
All right. So if there's a part of, you've got it too, if he's looking at the same page, if there's part of it you want him to look at.
Actually, I don't have it.
Okay, it's in your stack.
Not in there. I don't have it. I don't have that copy or that final disposition.
Okay, how do we get one for the witness, for the questioner to look at, Mr. Hiles? So there can be one in front of the witness and one for Mr. Pritchett to have.
Would you like to look at the original certified?
Appreciate it.
And we're at the final disposition.
Okay. Okay, here it is. Okay. Looking at that final disposition, Mr. Velasquez, you should see that box in the middle of the page, correct?
Yes, sir.
Okay, now, next to count 2, if you go over to your right, past the OCGA numbers, what does that disposition say?
First offender, Alfred.
Do you know what an Alfred plea is?
I'm not an attorney, and I don't think I'm qualified to instruct the jury what an Alfred plea is. That would be for an attorney to explain to the jury, not me.
Mr. McBurney, can you instruct the jury what an Alfred plea is?
Should object. It's not a question.
Probably not my role right now, but there may be an opportunity for you to get that in front of the jury through different means. But this witness has said he's not the right one to talk about an Alfred plea.
Okay. So in all your years of experience, you don't know that Alfred plea means that you maintain your innocence. You don't know that.
So it would be improper for me as a non-lawyer to offer advice or an opinion on a legal conclusion of what an Alfred plea is. I'm a detective, not an attorney.
Now, on this case in 2016 that you investigated, well, first, let me go back. You said you've been a detective for 22 years, correct?
Well, I was a police officer for 22 and a detective for 17.
Now, when you go to the process of charging individuals or suspects to a crime, that's on your discretion, correct?
So charging and arresting are two different things.
Mm-hmm.
So my job is to look for what's called probable cause. And that's gathering enough evidence that's sufficient to support the arrest and the charge of, in this case, burglary. So the decision would be up to me once I feel that there is enough probable cause. And then I present that evidence to a judge, and the judge has to agree to sign the warrant.
Okay, so in specification, in that investigation of 2016, that led you to charge me as a party to a crime, correct?
Correct.
Okay. And according to your investigation, you charged me as a party of a crime specifically because you believed, according to your investigation, that I was the supposed getaway driver.
That was part of it. There were other aspects of your involvement that I have not testified to this jury about yet, but that's part of it, being the driver, yes.
So what was the main part of why you charged me with party to a crime?
So I would have to read the warrant to be specific, but my recollection right now, there was a piece of it where co-defendant testimony, co-defendant information, cooperating co-defendant, Frederick Clark, as you're aware of, provided information that you were part of the planning process of this at the house that you rented with Mark Spencer on Mitchell Street. You were part and parcel to the planning phase of this crime. That, along with physical evidence that put you at the crime scene, as well as just other evidence that shows that you were part of this as far as being present.
Okay, and you remember getting statements from Voss Coleman too, correct?
I do.
Okay. And you recall him stating in contradiction to Mr. Clark that there was no planning at that location?
I'd have to read the transcript from the statement from Mr. Coleman. I don't recall. I don't recall exactly what Mr. Coleman said.
Do you have that in front of you on your investigative notes?
No, sir, I did not.
Okay. So what did Mr. Clark state to you that I helped plan? Like what was he say was my involvement in the planning? What was said by me that suspected my help in planning? What was said by me in that plan?
I don't recall exactly, but the gist of the conversation was there was a guy named Cash who the target of the burglary that was a drug dealer, and that this conversation took place at your apartment where you and Mark Spencer lived, in either your room or Mr. Spencer's room, I can't recall which one, and that the plan was hatched that all five of you would participate in breaking into the drug dealer's home. Unfortunately, they got the wrong apartment. And that you were part and parcel to the conversation of where it was, the location of where the apartment was, the complex, I think it was called Skylofts, and that you willingly went with that group, waited in the car, knowing that they were going to go in and break into the apartment.
Okay. And I was the getaway driver.
Well, I don't know if the word getaway driver was used, but you were the driver.
You don't recall in your warrant you specifying that I was the supposed getaway driver?
I could have written that. I just don't recall.
Okay.
And if I did write that, then that was what was stated by Mr. Clark.
Okay. Now, do you recall, because you do recall a statement from Voss Coleman, correct? In part of your investigation.
I remember Voss Coleman gave a statement. I just don't recall exactly.
You don't have these papers in front of you?
I do. If you want to refer me to what page?
Believe doesn't have page numbers on it, but it is.
Should be at the bottom of the page number, right under the date.
36, yeah, you're right.
Okay.
36.
So you're asking the witness to read page 36 to refresh his recollection about what Voss Coleman said?
Yes.
Okay.
All right. And what was your question, sir?
Okay. Pardon me, please pardon me, please pardon me.
Certainly.
If we can actually just go back to 26 first,
26.
just so I can keep an order of things.
Okay, I'm there.
Now you see in that first sentence where Clark states in his statement that he transported Spencer, Pritchett, Stafford, and Coleman to the location in his black Honda car.
Objection. You can't read from the.
Right, so you don't read it,
Okay,
you just,
I'm sorry.
indicates, okay, indicate to the witness what section you want him to read. When he's done reading it, then we'll see if that has refreshed his recollection.
Can you read that second sentence? Starts off with the letter Clark. I mean, the word Clark. Second sentence.
Second says Clark transported Spencer, Pritchett, Stafford, and Coleman to the
Objection. You can refresh your.
You can't read.
Right, so I'm sorry, I thought this, we've done this, but it was with a different witness. So a lawyer questioning you can put anything he or she wants in front of you to read to yourself, not out loud. And then when you're done reading whatever part the questioner has said, hey, look at this, when you're done reading it to yourself, then look back up and then the questioner will say, all right, did that refresh your recollection? And you say, yes, it did. And this is what Voss said, or nope, I read those words, but I don't remember that having happened. So have you read the part that Mr. Pritchett wanted you to read?
I have.
All right, what's your question?
So after refreshing your memory, it's correct to say that Clark is the one that transported individuals to that location during that incident, correct?
He did in his
Okay.
car, correct.
Now, can we please go to page 36? Just want to refresh your memory.
Okay.
Um, Can you read that fourth sentence that starts off with Coleman said?
Read to yourself.
On page 36?
Yes, sir. Fourth sentence that says Coleman said that he.
Are you sure you're on page 36? 'Cause I don't see that.
What are the first two words at the top of the page? You can read those out loud.
To speak.
Yes, that's the page I'm on. So after that period right there at present, go down 1, 2, 3. So it'll be the third sentence from that period at the top. Where it starts off, it says Coleman said.
Okay, for the record, it's the sixth sentence down from the top.
That's okay, as long as you found one that fits that description.
Make sure we're on the same.
Yep, if you'll read it and then we'll see what Mr. Pritchett wants.
Sorry about that. I only saw 3 periods.
No worries, sir. I've read it.
Okay. Now, according to Coleman's statement, now that you refreshed your memory,
You don't want to read the statement.
Yeah, I don't want to read
So
the statement.
does that refresh your recollection about what Coleman said?
Does that refresh your recollection of what Coleman said after reading that?
Yes, sir, it does.
Okay. Now you can confirm that according to Coleman, once 3 individuals left that vehicle, him and Maxx went to Wendy's to get food?
Is the question, could I confirm that?
Can you confirm that?
No, that was not confirmed. In fact, there's a video that exists showing those defendants going to Mark Spencer, Frederick Clark, and Lachey Stafford going to a Krispy Kreme donut shop.
Yeah, but I'm not referring to them. According to Coleman, after the individuals left the vehicle, correct? according to Coleman, where did Coleman and Maxx go after they left that vehicle?
Well, I don't know. So the evidence of the entire investigation shows that Max Pritchett and Voss Coleman remained there, and then the other three defendants jumped the wall after the burglary and got in the car and they left. Voss Coleman, according to his statement, stated that you and he went to Wendy's.
Okay.
That was I was unable to corroborate that at all. There was
Okay.
no evidence to support that statement.
So in your investigation, Voss Coleman didn't show you a video, or I don't know if it was you specifically, but it was detectives in the interrogation room that he did get food from Wendy's and he happened to have a video showing that food.
So don't answer the question yet. Yes, sir.
It's not a question, he's talking about facts outside of evidence.
So make sure you're asking questions rather than trying to introduce evidence by saying, hey, isn't, there's this or that. So what's your question for Detective Velasquez?
So according to Coleman, Maxx and him went to Wendy's to get food, correct?
That's correct.
Okay. So we know, according to your investigation, that Maxx didn't drive anybody to the crime scene, correct?
That's correct.
Okay. And according to your investigation, after the incident occurred, the three individuals that were supposedly entered that apartment, once they exited that apartment, they ran to a Krispy Kreme, correct? According to your investigation?
So I don't recall whether they ran or were driven there. They ended up at the Krispy Kreme.
Can you go to page 27 to please refresh your memory?
What part of 27? And if you go by line number rather than sentence,
you're right.
that's easier. Just count down lines, then you don't have to worry about periods.
It starts on line 2, the end of line 2.
And how much do you want them to read? The whole page, or?
We can just read read all the way down to line 6.
I've read it.
Okay. So now, after your memory has been refreshed, how did Clark and the other individuals get to Krispy Kreme?
They ran on foot.
Okay. And now, after these individuals arrived at Krispy Kreme, what did Clark state that they did at Krispy Kreme?
I don't recall.
Okay. You don't recall Clark stating that I don't see it on this page either. You know what? Okay. Once at Krispy Kreme, according to Clark's statement, it was realized that he had to still get to his final destination, correct?
Who are you referring to?
Clark.
Yes.
And okay.
Answer is yes.
Now at Krispy Kreme, according to your investigation, how did Clark and the other individual with him get to their final destination?
They took an Uber on Clark's account.
So Clark didn't call me, the supposed getaway driver, and call me to pick him up from Krispy Kreme?
So while Mr. Greer is on the phone with 911,
That was a yes or no. It was yes or no. Did he call me to pick him up from Krispy Kreme and to take him to his final destination?
So witnesses can explain their answers. So at some point there'll be a yes or no, or I don't know, or maybe, but the witnesses are always allowed to explain their answers.
I didn't want any confusion. Continue on, sir.
so according to Clark, as the call went over 911. As they're running out, there's an Atlanta police officer entering the complex responding to the call. That was corroborated by a witness that was standing in the parking lot. And according to Clark, once that happened, the original plan was for this defendant to be the driver. But once that happened, they all scattered and their plans changed. Krispy Kreme was never in the plan to go there. So none of that happened, and there was no call to you. There was no record of a call from Mr. Clark to you, to answer your question, to pick you up. Whether there was or, I don't know what, if there was a call, what it would be for, but there was no record of a call immediately to you. I don't know if that answers your question.
I mean, if there was a call, the reason would for the call to me would be, since I was this planned supposed getaway driver.
Objection, speculation.
You can finish the question, but if it's asking this witness to say, yeah, maybe that's what you guys were thinking, he can't speculate as to what the plan may have been unless someone told him what the plan was.
So was it ever stated specifically in Clark's or Coleman's statement that I was the supposed getaway driver?
I believe not in Coleman's statement, but in Clark's statement, I believe, yes, that you were to remain in the car with Mr. Coleman and drive when he got back.
He said specifically that I was supposed to drive when he got back.
I'm not sure if the word getaway driver was used or driver, but there was conversation that encompassed that thought process.
Page 26. Have you read it?
The whole page or a certain line?
Line 6, 7, line 5, 6, 7.
Yes.
Okay, now I'm assuming, correct me if I'm wrong, are those the lines from Clark's statement that caused investigators to think that I was the supposed getaway driver?
So this report that you're reading doesn't encompass anybody's complete statement. I chose what to include in here, knowing that the statement itself is available for reference.
Okay.
So this doesn't encompass Mr. Clark's entire statement.
Okay.
It's not a verbatim recordation of what Mr. Clark said when you were talking with him.
That is correct. It is not.
So you chose to leave out that Clark told you or detectives that I was supposed to be the getaway driver. You chose to leave that information out of the investigation report.
There's a lot of what Mr. Clark said in his statement. Probably, in fact, he gave two statements. And I believe the first one is over an hour long. So it is not common for me or any other detective to verbatim write in my report what that witness or suspect says. It's referred to as a brief encounter. So my job is to document the encounter, the witness or the suspect statement. This one happened to be with his attorney. And then also indicate that that statement is available in the file for review. So it's not a matter of what I choose. It's more of documenting what I need to document that statement occurred. And then we have the affidavit for the warrant, which may be a little more specific as to the defendant's involvement based on what another witness or another suspect may have said.
So again, you chose not to document that Clark stated that Maxx was supposed to be the getaway driver.
Well, if it's not in here, then yes.
Okay. But you believe that in his statement that he said specifically that Maxx was supposed to be the getaway driver.
Again, as I testified to earlier, I don't recall if he actually said those words or the word getaway driver was used, but the gist of that conversation was that you were to drive away. But I can't tell you verbatim what he said without the statement in front of me, without looking at the entire statement.
I thought the gist of what he said was that I had a hurt leg or foot, so I decided to stay in the car.
Stop, don't read from the report. You can summarize it, but make sure you're not reading to the jury from the report.
Is the gist of what he said that I was supposed to be the getaway driver, or was the gist of what he said was that I was supposed to stay in the car because I had a hurt foot?
So I don't know what you mean by gist, first of all.
Gist, I mean,
Let me finish, sir. Let me finish.
Okay.
Let me finish my testimony. When I write my report, what I reference is that a statement was taken, and it's always, the statement itself is always available for everyone to review, knowing that the prosecutor is going to get it, and that in discovery, you would get it. So I'm not required, again, to write down everything that a suspect or a witness says verbatim. So I can't testify to what the gist is. I understand what gist means. I can't testify to what my intention was for the gist. I documented what I felt I needed to document on that particular statement. The rest is available for review in the actual statement itself.
Okay, and so it's correct to say that you felt that you shouldn't have documented that Clark stated that Maxx was the getaway driver.
Objection, asked and answered.
We've covered it. Let's go to a different area.
All right. Okay, so now, according to your investigation, Clark gets an Uber from Krispy Kreme to 836 Mitchell Street, correct?
Correct.
Okay. Now, once arriving at their final destination, Clark and another individual realized, did Clark and another individual realize that they had left stolen items stashed somewhere, according to your investigation?
Clark, I believe, and Spencer did, yes.
And they realized that once at their final destination, that they had actually left some stashed items that they have retrieved?
I'm not sure I understand the question.
According to your investigation, it's correct that, again, Clark and Spencer, once at the final destination of 836 Mitchell Street, realized that they had left stolen items that they needed to retrieve, correct?
They intentionally, according to Clark, stashed a book bag with the stolen items, yes.
Now, did they ever go back and get those stolen items?
Yes.
How did they go get those stolen items?
They were transported by a person, his first name was Corey. I don't recall his last name. It's in my report. If you need it, you can direct me to it. But he then arrived in his own vehicle and transported them back to the location, which is literally right near the crime scene, and retrieved the bag with the stolen items.
So Clark and Spencer didn't call Maxx? Didn't call me?
I don't recall what calls were taking place without the phone records in front of me, but as far as it being transported to pick up that bag of stolen property, it was a person named Corey that did that.
So it's safe to say that I didn't drive anybody from that crime scene to any other location, nor did I drive anybody after the fact to retrieve any stolen items that might have came from that crime scene location, correct?
Correct.
So according to your investigation, in Coleman's statement, the only driving that I did was after the alleged assailants leaving that vehicle. According to your investigation in Coleman's statement, the only driving that I did was go to Wendy's to get food, correct?
According to Coleman, that's what he stated. I was unable to verify whether that happened or not.
But was there any other evidence that I drove any of the assailants after the fact, during or before the fact, to any location having to do with the crime scene?
No.
Okay. So there is, according to your investigation, there was no evidence that I aided or abetted in this crime in any way, was there?
Oh, there was. That's why I arrested you.
What was that evidence?
It's in the affidavit, sir. I had signed an affidavit, swore to it in front of a judge.
You don't.
Let him finish his answer.
Okay,
You can follow up.
So, and again, I've testified the fact that co-defendant gave information that you were part of the planning phase of this. The fact that, and Judge, I'm trying to be careful what I say that's in because there is other evidence that supported your arrest that I don't think it would be proper for me to testify to. That was part of the affidavit that met the standard of probable cause for your arrest.
Does someone have a copy of the affidavit that I can look at? It's not, I guess that wouldn't be part of your file. As a result of your file, you get the affidavit.
The affidavit is part of the file.
You've got it there?
I do not have it with
Oh.
me, but it's part of the main file that I turned over.
Okay.
Again, it's a pretty
Okay.
big file.
No, I understand.
Again, I'm just trying to be careful with.
No, I appreciate that too. That's why if I could see the affidavit, I could help us navigate this.
Understood.
No affidavit?
I'm not the one with the evidence, so I don't know if you've got a copy of the affidavit. I'm looking to Mr. Hiles, and we'll see what happens. Why don't you ask a different question, if you've got any more? If not, I'm happy to wait to get my hands on the affidavit.
From what your recollections brings up to you, what other evidence are you referring to?
So that's where I don't want to be prejudicial towards you, and I'm trying to be careful with what I say. I don't think it would be.
So, Mr. Pritchett, remember, I made a ruling there. There's one part of this case that the burglary case that we're talking about that I've excluded, and the detective, I think, is wanting to make sure he doesn't get into that space, and I excluded it for your benefit, not the state's benefit.
You're right. I was just trying to see the evidence directly towards.
Your question is a perfectly appropriate one. I think the detective is just leery of, in saying something, it gets into the area that I concluded wasn't sufficiently relevant to this case for it to come in. But it would be great if I had a copy of that affidavit and I could help.
I know it's cross-exam. Can I just inquire if you're talking about the arrest warrants? Is that the affidavit?
Yes, and I want to be careful. I'd like to read it as well.
Sure, and that's what I'm assuming is the affidavit for the arrest warrant.
I may be able to help. I think I may have a copy of my Dropbox that I could maybe, if I'm allowed.
I can't tell from reading Mr. House's body language if he's found it or he's a good poker player. He's just looking at his screen. It's there, it's not there. So if he sends it to me, I'll print it out and I'll print 3 copies. So one for Mr. Hiles, one for the accused, and one for you to look at as a recollection refresher.
One PDF of all of the arrest warrants.
Okay, here it is.
I have a question in the meantime.
All right, just give me a second. I'm trying to find the right one.
I think affidavits are all gonna be
The same. I was just making sure of that. All right, it'll pop out on the printer in a minute. Do you have other questions, or really where you're wrapping up is with this affidavit?
Yeah, pretty much that affidavit. That's what
Okay.
I'm wrapping up.
You can hear it coming right now.
Okay.
Thank you, Mr. Hiles. Here's one for you.
Thank you, sir. Sure.
Hey, Gordon, here's one for Mr. Pritchett. Mr. Hiles.
Let me know when you refresh, Jeff.
Okay. I'm ready.
Okay.
I'm ready to, you can go.
Okay,
So repeat your question because we had a little bit of a break.
yeah, we did, wow, kind of forgot it myself. Let's go back to, because you, let me just restate this again. So the evidence that caused you and your department to charge me as a suspect to this crime is that I participated in the planning of the crime?
The planning of the crime, your presence at the crime scene, and then your actions after the crime occurred. From information received from Mr. Clark, as far as hiding out at a Motel 6. Some corroboration through Uber records supported that statement from Mr. Clark. Your Uber records in particular, that actually shows.
That I was hiding out at a Motel 6?
Well, it shows you taking a car from 836 Mitchell Street to the address where Motel 6 exists. So that's corroboration to what Mr. Clark says.
So was I hiding out at Motel 6? Did I get a?
I don't know if you were there or not. I know you ordered an Uber to that location the day after the homicide.
Okay.
I'm sorry, the day after the case.
Okay. Where was I arrested at?
In the Bronx, New York.
Now, where was Lachey Stafford arrested at?
Lachey Stafford was arrested, I believe, at the airport in Denver, Colorado. I think you were with him at the time.
And I wasn't arrested then, though, correct?
You were not. I didn't have an arrest warrant for you at that point.
Okay, so what was that specific evidence that you needed to get an arrest warrant?
In the time that Lachey Stafford was arrested, I'm not sure where I was in the investigation. And for the record, there was 5 defendants and I was piecing it together piece by piece. So obviously the evidence that I felt supported an arrest came after that. In fact, when Lachey Stafford was arrested, I had information that he was catching that flight. So I sent our fugitive unit to Denver airport to pick him up, not knowing you would be with him. And they called me to ask about you. And I specifically told them to let him go because I do not have a warrant for him. And I think it was shortly after that date that I obtained the warrant. And later we found you at your uncle's house in the Bronx, New York.
Okay. So just for clarification, the only thing that caused you to place charges on me as a suspect to this crime is because it is alleged by Clark that I was part of the planning process of this crime.
Well, part of what I was able to determine is that none of the 5 defendants, including yourself, had any relation to Skyloft Apartments, to the victim, Mr. Greer, anyone that lived there. You were there. You were at that location when this crime occurred, and co-defendants admitted their participation in it. Your phone record supported that. Testimony from your co-defendant, Mr. Clark, that you were part and parcel to the planning phase of this beforehand. And then part of what we consider evidence is flight after a crime occurs. And we were able to determine that you, through corroborating your Uber records, went to a motel, as Mr. Clark stated, to hide out. And at some point, ended up in New York City with your uncle. So that's the evidence. Your phone records, co-defendant testimony, and ultimately you pled guilty.
So under Alfred, which is what to maintain my innocence. But again, none of that flight information that you're suspecting me of is in this affidavit, correct? Because you said I was I
It's
was
in my
on, I was
report.
flight, but it wasn't in your affidavit though, correct?
No, it's
It
in my
wasn't in your affidavit for the arrest warrant.
It is not needed for that. My warrant, the probable cause that I presented was sufficient. And not everything goes into an affidavit. I put in what I need, what I feel is sufficient to support an arrest. And many times there's way more evidence that I put in than I put in the affidavit. A judge has to read it. I have to be mindful of a judge's time. So try to keep my affidavits to the point. So although it's not in the affidavit, it's still evidence.
But this is the affidavit that supported your arrest for me, correct?
Correct.
So on your affidavit that supported the arrest for me, what supported your arrest for me?
So we've covered that now.
And specifically on the affidavit, we have it.
So this witness has now testified every which way about what he thought supported probable cause, what was in the affidavit. You've highlighted some things that he indicated that weren't in the affidavit, but also supported your connection to the case. So I'm gonna ask you to move to a different area now, if you've got a different area.
I'm just trying to make a point, sir.
I understand the point you're making, and my point is you've made your point. So it's time to make a different point.
So is it possible, according to your investigation and the statements that you received from Clark and Coleman, is it possible that the plan that you say I participated in for this crime was that once the other three assailants got out that car that night, the plan was for me and Coleman to get food? Could that have possibly been the plan of what was supposed to happen that night?
According to the evidence that I've gathered, no.
Why is that a no, sir?
Well, sir, this case could have gone to trial, and I think that would have been for a different jury to make that decision. So I stand on what my evidence is, what my investigation revealed, and what the probable cause was for your arrest. That's all I can testify to.
But if the only evidence that you're relying on to say that is that you have phone records that put me in the scene of that crime, which corroborates what Clark and Coleman said. But what they also said is that I left that crime scene to go get food at Wendy's, which was right in that area of that crime scene.
So, Mr. Pritchett, we're again going around in a little bit of circles. You are going to have an opportunity to argue to the jury if you think it's relevant to, of course, the case we're here for, which is Wiley Street and not Oak Street. If you think there were some deficiencies in the Oak Street case, you can talk to the jury about that. But Detective Velasquez has now said 3 or 4 times what he's got to say about the work he did on that.
Are you familiar with this case, with this present case?
I am not.
Okay. No further questions, Judge.
Mr. Hiles, any redirect?
No, Your Honor.
Any questions from the jurors? Thank you. All right, ladies and gentlemen, I'm gonna have you take your morning break right now. I'll cover these with the parties. We'll bring you back out and we'll have Investigator Velasquez answer the proper questions. Don't talk about the case back in the jury room, no outside research. We'll see you in a moment.
All right, sir.
All right, Mr. Hiles, if you would grab these, share them with Ms. Mignot and Mr. Pritchett.
Judge, was this meant to be an exhibit or?
Nope, thanks.
Oh, yeah, I'll take it.
Thank you. So we'll discuss these real briefly, and then I'll give everyone a quick break before we bring the jurors back in. I will not ask question 69, which is an inquiry about the nature of the victim's injuries. I will explore with investigator what he knows or can tell from states 37, which may need to come back to him, about whether there was a trial and the outcome for Mr. Pritchett. I'll ask the question about Clark and his car and a firearm and what's the answer, if you know, Mr. Hiles, to the question about gang activity?
So I don't think I was gonna bring another person involved in the investigation to talk about some of the gang activity.
That would be a witness you didn't tell us about.
No, it was Liam Packer and Denisha both.
No, meaning you said you have two witnesses
I'm not
left.
gonna, well, what I'm saying is I opted not to do it because of the pace of the trial, and I didn't find it to be necessary, you know, with what
Okay, but is this someone who can answer that question?
I have to ask.
I guess we'll ask him. Do you have any objection to that question?
No, I mean.
Okay. Ms. Mignot, did you have any objection to any of the questions other than the one I'm not asking about the nature of the injuries?
No objection, Your Honor.
Okay. Hey, I need to talk to Mr. Pritchett first. Mr. Pritchett, did you have an objection to any of the questions other than the one about the nature of the injuries to the victim?
To the gang related question.
You have an objection to that? What's your objection?
That in the evidence of their case, that word gang never used.
Was it, I
think it's already an answer.
I don't have the indictment in front of me.
There was no gang charges alleged. It was stuff that was discovered post adjudication.
Okay, then I won't ask it. So there'll be two I don't ask, one nature of the injuries and then the thing about gang activity. Otherwise, I'll ask the questions. All right, let's take a quick break and then we'll wrap up with investigator.
We'd be happy to know that investigator Miller just texted me. He said he's trying to make this fast.
Your Honor, can we get a time on this break? Is it a 3 minute, 2 minute, 1 minute?
4.
4 minutes.
More than you asked for.
For the indictment question, what?
I will guide you.
Okay.
There will not be, you don't have to guess around.
Thanks.
All right, Ms. Rivers, are you ready? Mr. Hiles, anything before, well, let's get back on the record in State versus Pritchett and Robinson. Anything, Mr. Hiles, before we bring the jurors back in?
No, Your Honor.
Ms. Mignot?
No, Your Honor.
Mr. Pritchett?
I would just ask for a mistrial. I believe he said homicide.
He did, and then switched it, and wisely, no lawyer or you drew any attention to that. So I'm going to deny your motion for a mistrial. I am finding that to have been an inadvertent misstep by the witness, who otherwise was very scrupulously adhering to my ruling, to the point where he was unwilling to get into the contents of the affidavit without having it in front of him, because he was worried he might cross the line. So number one, I don't find it was anything prompted by the state. It was in response to one of your questions, not Mr. Hiles's. I don't think it was something that the witness held up his sleeve until an opportune moment in a narrative answer where he could slide that in, but that it was unintentional and quickly corrected, and no one drew any attention to it after it was quickly corrected. So I understand your motion, and it preserves your concern, so that if there is an appeal, you or someone arguing any appeal on your behalf will be able to challenge my ruling that denies the mistrial. Now, I'm going to offer up an alternative remedy, but think about it before you say, yes, that's what I want you to do. I would be willing to, I just don't think it's a good idea to tell the jurors, you may have heard the detective describe the crime in a certain way. I can even say, you heard him use the word homicide. You should disregard that. That's not what this case is about. The reason why I'm cautioning you is that will draw their attention back to it, insofar as any juror even remembers that he said those words. But if your concern is that the word homicide is going to linger on the minds of the jurors, then I'm happy to tell them that they should disregard the use of the word. It was used in error, that the witness quickly corrected himself, and it inaccurately describes the case as they are to consider it. So I can give that curative instruction, but you should just weigh whether you want that against that necessarily draws attention to something that I don't think was particularly remarkable during the course of Velasquez's many, many, many answers to your many, many questions. What are your thoughts on that? Okay, so I will not give a curative instruction. I gave you that opportunity and you're saying no, thank you. I understand why you'd say no, thank you. I need to include the other two lawyers in the conversation. Mr. Hiles, do you have anything you want to add about the motion for mistrial, which I've denied, and the offer for a curative instruction?
I don't have anything, well, what I would want to add, there was a simultaneous objection to that statement. Secondly, I would note, although I think you made a record of it, that those questions would have been brought out, if, essentially those answers, that was brought out by the questioning of the defendant himself, which I think, being what evidence you have, opens the door that he could have tied it in. I think he did a good job not to, but if some of that stuff that he was asking about was unexplainably tied to evidence of the homicide. And so, it was just inadvertent.
Okay. So I agree with you that it was inadvertent. I disagree with you that Mr. Pritchett in some way opened the door, but it was inadvertent. That's how I view this. You make a good point that I didn't. And that is that, and the record will show it, but there was no contemporaneous objection insofar as that might affect appeals later on. The first I am hearing of Mr. Pritchett's concern about the use of the word homicide is now after he had finished his cross-examination. Ms. Mignot, anything you want to add to this discussion?
No, Your Honor.
Okay, let's bring the jurors in, please.
All right, so jurors.
Thank you, Deputy Gordon. Everyone else can be seated. We're back from the morning break, and I've got a few questions based on juror questions for Detective Velasquez, and we'll go from there. Sir, was there any evidence you uncovered of a firearm being used in connection with the burglary home invasion that you investigated?
No.
How did Mr. Clark get his car back, if that makes sense? Because it seems like he was separated from his car at some point. Was that something your investigation revealed or one of the unsolved mysteries?
So his car made it back to 836 Mitchell Street, presumably driven by the defendant, and he was able to get his keys back and take back possession of his vehicle.
You should have States 37 in front of you. Are you able to tell from the final disposition, the first final disposition, if Mr. Pritchett went to trial or if he resolved his part of the case by way of a plea?
He pleaded to the case.
Okay, and we've heard this is an offered plea, whatever that means, but it's still a plea rather than a trial.
That is correct.
Okay. And does the final disposition, the first final disposition, indicate what he was sentenced to?
Yes. 10 years to serve, 2 years commuted to time served, balance of 8 years on probation.
Now, was there a second final disposition for Mr. Pritchett?
There is.
And when was that one, and what was that?
Perhaps you can help me, Judge. Am I looking at the?
So that's the first one. Is that the 10 served 2? So keep going. One more. There. So same case. Is that same case number for Mr. Pritchett?
Yes.
And then what's the date of that second final disposition?
Date of this final.
It's a big box that says received at the top.
February 10th. Oh, I'm looking at the wrong. Is that filed in office?
Yes.
February 10th, 2020.
Okay. And the disposition was changed. What was the new disposition?
For burglary in the first degree guilty, 20 years to serve.
All right. Mr. Hiles, do you have any questions for for Investigator Velasquez based on that exchange?
Yeah, so in reference to the question about the car, was it Mr. Clark's statement, that it was, Mr. Pritchett who took possession, of Mr. Clark's car, at the location of the burglary?
Yes,
Okay. And was Mr. Pritchett, supposed to drive everybody afterwards?
according to Mr. Clark, yes.
And I believe you said it was it also said by Mr. Clark that this plan was disrupted because of the quick response of police?
Yes,
And would that presumably be from the 911 call we heard of Mr. Greer as this was taking place?
it would, yes.
And did the cell site location information match up with what Mr. Clark told you about who was to take the car, where it started from, and where it ended up?
Yes, the cell site location tracked from 836 Mitchell Street to the incident location and then back to 836 Mitchell Street.
That's all the questions I have.
Ms. Mignot, anything more for Detective Velasquez?
No, Your Honor.
And sir, the accused, any questions based on the exchange that I just had with Detective Velasquez?
According to Mr. Clark's statement in your investigation, did I drive any of those assailants that went to that apartment from that crime scene?
No, they took an Uber.
And after the fact, when Clark was at Krispy Kreme and he had a chance to call the supposed getaway driver, who did he call to get to 836 Mitchell Street?
I can't testify who he had a chance to call. That would be a question for him.
How did he get to 836 Mitchell Street?
He used an Uber.
And once at 836 Mitchell Street, he realized he had to go back to the crime scene to retrieve stolen goods. Who did he call to retrieve those stolen goods?
I testified a person named Corey.
All right. Thank you, sir, for your time. Appreciate it. Mr. Hiles, you can leave that right there. If you'd get the exhibit off the witness stand and tell us who your next witness is, please.
Yes, the next witness is investigator James J.P. Miller.
Raise your hand. Do you swear affirm that the testimony you will give is the truth, the whole truth, nothing but the truth, so help you God? I can do it, MC. State and spell your name for the record.
James Miller, James Miller.
All right, investigator Miller, where are you currently employed?
Employed at the Fulton County District Attorney's Office.
How long have you been employed there?
Approximately 3 years, September 21.
Okay. What's your capacity at the Fulton County District Attorney's Office?
So I'm assigned to the Major Crimes Division, where I investigate primarily homicides, violent crimes, aggravated assaults on robberies. I also get tasked out with other cases such as high-profile cases, RICO cases, gang cases, or whatever else I may be investigating.
Okay. And how long have you been in law enforcement?
So I started my law enforcement career with Douglas County Sheriff's Office after I got out of the Marine Corps in 2009. I started out in corrections, working in the jail, started out in uniform patrol as well. Then I worked some crime suppression and gang investigations. I eventually went to DeKalb County Police Department, where I worked uniform patrol, crime suppression. I also investigated criminal street gangs. Then I was employed by Cherokee County District Attorney's Office in Blue Ridge, where I investigated homicides, aggravated assaults, violent crimes, gang cases, RICO cases, high profile cases as well. And then September here.
Okay. In your law enforcement career, Do you have any specific experience investigating gang crimes?
I do.
Please tell the jury what that experience is.
So I have been investigating criminal street gangs since my very first law enforcement career, starting out in corrections, interviewing individuals that were in the jail that I saw as, or they relayed that they were gang members, and whether they were showing me signs and symbols. I also took several different criminal street gang investigator courses, such as the basic gang investigator course with Georgia Gang Investigators Association. I also have my intermediate certification through Georgia Gang Investigators Association, as well as an advanced gang investigator course through DeKalb County Police Department. I have over 200 plus hours in different gang courses, whether it be from various law enforcement agencies across the states. I've also attended, host or had training received from like LAPD, different agencies from California, New York, and across the state.
Okay. Do you ever teach law enforcement on gang investigation?
I do. I regularly teach. Specifically, I usually get called to teach gang evidence, gang investigation courses, basic courses with Georgia Gang Investigators Association. I'm also a gang instructor for the Prosecuting Attorney Council of Georgia. So we host an advanced week-long course, usually once a year, that is taught alongside with me and other gang investigators, some prosecutors throughout the state. I also host intel meetings 2 times in specifically the Metro Atlanta region, one in Cobb County and one in Gwinnett County. With Georgia Gang Investigators Association, I hold a position specifically as the vice president of the Metro Atlanta region. So that county or that jurisdiction is Cobb County, Fulton County, DeKalb, Gwinnett, Rockdale, Henry County. So within that jurisdiction, I'm responsible for making sure the members of our organization have the most updated and best practices as far as prosecuting and investigating criminal street gangs.
Okay. And have you, in your course of investigating gangs, gang crimes, have you ever interviewed any gang members?
Yes, very regularly.
Okay.
Very what?
Very regularly.
Regularly.
Yes.
Okay. That's different from rarely.
No, regular, on the regular.
On the regular. All right, we'll get with that. All right. And over the course of your, how many gang members would you say you've interviewed?
Hundreds. Honestly, I can't give you an accurate number. It's part of my day-to-day job. Just last week, I interviewed, I believe one last week.
Okay. All right. And during the course of your training and experience, have you had the chance to investigate the gang Young Slime Life, or YSL?
Yes, I have investigated criminal street gang activity of Young Slime Life.
Okay. How many Young Slime Life cases would you say that you've investigated over the course of your, I guess, law enforcement history?
I know it's more than 10. I don't know an accurate number, but I've investigated homicides, armed robberies, burglaries, white collar crimes involving them, shootings, thefts, vehicle thefts.
And, well, Your Honor, at this time, the state would tender Investigator Miller as an expert in criminal street gang investigations, criminal street gang activity, as well as the criminal street gang Young Slime Life.
Ms. Mignot, do you want to voir dire Investigator Miller as to his qualifications, or do you want to wait till you cross-examine him on other issues?
I'll wait till I cross-examine.
Okay, so you don't have any objection for me qualifying him for purposes of these proceedings as an expert in those fields?
No,
All right, and sir, the accused, do you have any questions Do you want to question Investigator Miller as to his expert qualifications? Or do you have any objection to me qualifying him as an expert witness in the three fields Mr. Hiles mentioned? I want to be clear. If you say I don't have any questions now, you'll still be able to cross-examine this witness. It's just the threshold. I need to see if there are any objections to having Investigator Miller qualified as an expert.
I do object.
Okay. And what's your basis for objecting?
He's never been in the game.
Okay. All right. Have you ever been in a gang?
I have not, Your Honor.
All right. That may go to the weight of his testimony, but I do find that based on the testimony I've heard from Investigator Miller about his training, experience, and exposure, that for the purposes of this trial, he knows more than the layperson, which is the test for expert qualification. And you are qualified as an expert in the field of criminal street gangs, criminal street gang investigations, and in the nature and origins of YSL.
Did you put together, well, I'm showing you what's been marked as State Exhibit 38. Did you put together a demonstrative aid in the form of a PowerPoint for your presentation to the jury today?
I have.
And have you had a chance to look at State's Exhibit 38? I
have.
Okay, and it's a full and complete copy of the PowerPoint that you have provided today.
It is.
And Your Honor, at this time, the state would tender State's Exhibit 38, a demonstrative aid for the testimony of Investigator James Bell.
All right, Ms. Mignot, beyond the many objections you've made and preserved and that we've litigated outside the presence of the jury, do you have any additional objections? Because you would be renewing all your previous objections right now. Do you have any additional objections to State's 38 being introduced as a demonstrative aid only?
No objection to 38 other than the ones we struck.
Okay, they are preserved and renewed. Mr. Pritchett, the accused, do you have any additional objections to the admission of State's 38 as a demonstrative aid beyond the objections you've already made outside the presence of the jury that we've already litigated? Okay, you are preserving your objections as well. They are renewed here, and 38 is admitted subject to all those objections and changes that have been made to State's 38 as a result of some of those objections.
Now I am showing you what has been labeled as State's Exhibit 39. Okay. And as part of your investigation into this particular case, did you find related, I guess, music videos that you found pertinent to this particular case?
I did.
Okay. And were those two music videos entitled Play Nasty as well as Guns Up?
That is correct.
Okay. And do you recognize the thumb drive that is in front of you as containing those two particular videos?
It is.
Okay. Your Honor, at this time, the state would move State's Exhibit number 39, music videos, Play Nasty and Guns Up, into evidence.
All right. Before I turn to Ms. Mignot and the accused for any objections, State's Exhibit 39 is very much like State's Exhibit 37. It is evidence that you all should consider, if you consider it in any way, as to only one defendant, but it's the other defendant. State's Exhibit 39, two videos. Should the state publish them? Should you consider them? Are evidence, if they're evidence of anything, only as to Mr. Robinson and not as to the accused. So 37, Pritchett only, 39, Robinson only. Now, Ms. Mignot, these videos have been extensively litigated. You have filed written objections and you've made many objections, some of which were enacted. In fact, ladies and gentlemen, I should tell you one of the two videos may end up seeming a little choppy because there are parts of it that I ordered redacted. That is not the state keeping anything from you. It is Ms. Mignot being an effective advocate for Mr. Robinson and me deciding that's not relevant to what you all are working through. But there are still the two videos. Ms. Mignot, beyond the objections you've made and argued and preserved, anything additional as to states 39?
Nothing additional, Your Honor.
Okay, they are all renewed and preserved. And turning to the accused, this evidence is not to be used in any way against you, should the jury consider it at all. Do you have any objections to the admission of states 39?
None other than it still may be prejudiced.
Okay, and that's been argued before by someone on your behalf. I will allow, and so you've preserved it and renewed it. 39 is admitted.
Now, to clarify, 39 is just separate from evidence that will be contained, some of the evidence already admitted, correct? It's not, it's only the music videos that instruction applies to.
Correct. That's why I said 39.
All right, let's get it over. In preparations for this, what sort of statistics and facts do you review?
I review several things, whether it be updated news articles, current gang trends. I look at past gang trends. I look at past statistics. One of the statistics that I review is a 2015 study conducted by the FBI. In that study was a threat assessment. In that assessment, they indicated there was over 1.4 million active gang members across the nation, as well as over 30,000 gangs, and those are gang subsets throughout the nation. As part of that statistic, they advise that upwards to 90% of all violent crime can be attributed to gang members. Now, there's a difference between something that is gang motivated or gang related. This is just merely stating that something is attributed to being connected to gang members themselves.
And are you going to review the actual facts of this particular case in preparations for your testimony?
Yes.
Okay. Now, is it your job as the gang investigator reviewing this? Are you involved in the primary investigation as to the underlying charges?
Occasionally I am, but on this particular case, no.
So you were only investigating the gang aspect?
That is correct.
Okay. What is a criminal street gang?
So a criminal street gang is a group of 3 or more individuals, whether formal or informal, who engage in criminal street gang activity. This criminal street gang activity itself is specific crimes outlined by the code section. They're chargeable offenses, so predicate offenses. But what a criminal street gang is it's going to be a gang of 3 or more individuals, formal or informal, so at least 3 individuals connected to this organization. They're going to have a common name, sign, symbol. They don't have to have them all, but they have to have something that identifies themselves as what they're portraying. And then the last aspect is the criminal activity. So as an example, fraternities, sororities, different organizations, it's a group of 3 or more individuals, but they're not committing criminal street gang activity. So that's what separates themselves. Just an example, the Shriners International. That's a nonprofit organization, a fraternal organization that does good things around the community and across the globe, helping children. Criminal street gang, the Bloods, group of 3 or more, have an identifying sign, symbol, stuff like that, but they're committing crimes. So the real difference between them is if a crime is committed by, say, a Shriner, that crime doesn't benefit the Shriners International. It makes Shriners International looks bad. Where on the other side, of a criminal street gang, they commit a crime. It instills fear, intimidation throughout the community. It makes that gang more powerful, and they benefit from that crime.
What are the benefits from instilling fear in the community and committing a crime in an open way?
So there's could be several different benefits. One of the reasons is to portray that violence to suppress the community. For example, if someone is living in a community and they are oppressed in that area, that gang has control in that area, that community is less likely to cooperate with law enforcement. There's a word that they use is called snitching. So a community is less likely to cooperate with law enforcement or snitch for fear of retaliation. That's one way of how they control themselves or operate themselves within the community. Another way of why something would be public is because that notoriety not only is it for the community, but it's for outside of the community, whether it's rival criminal street gangs. So they, if it is a violent crime, rival criminal street gangs will know not to mess with them because they are also extremely violent. That's how we become, we get rivalries between several different gangs, and we have different gang wars essentially throughout Atlanta.
All right, got a little off topic. I'm gonna try and stick to the presentation. What is criminal street gang activity?
So criminal street gang activity is a list of several different crimes. How I remember it is violent crime, gun offenses, weapons offenses, theft offenses, racketeering offenses, which is a slew of hundreds of different charges, but credit card theft, entering autos, burglaries, but narrowly, it also does human trafficking as well.
All right, what are the elements of a criminal street gang?
So 3 or more individuals. So 3 actual individual members, whether formal or informal, they have a common name, sign, symbol, something identifying themselves as a group, and they engage in criminal street gang activity. Now, all 3 of these individuals do not have to go and commit the crime at once. That's just the 3 or more individuals is the gang. So the gang has to exist first.
Okay, and when you say engages in criminal activity, are those the violent offenses, the racketeering offenses, human trafficking, weapons offenses? Is that what you just testified to as the criminal gang activity?
Yes. So criminal street gang activity, just like homicide, aggravated assault, shootings, burglaries, armed robberies, those offenses. So they have to commit those type of offenses and a slew of others.
Briefly touch on if a gang exists, then of 3 or more people engaging in criminal activity, then was it just your testimony that it's not necessary that all 3 people be present for every gang crime? Is that correct?
That is correct. So the 3 or more individuals, that's just establishing that the gang exists. But one individual could go and commit a crime that benefits the gang, and it could be chargeable under the 1615-4 code section.
All right. All right. What is this document that is displayed on the screen in front of the jury?
So this is a foundational block of how I create a criminal street gang case. If I remove any single point of this triangle, this iron triangle, then I do not have a gang case. So for starters, if you look at the very top, gang. So 3 or more individuals, 4 more informal, who engage in criminal street gang activity, have some type of identifying sign. If you remove crime, for example, they have to commit this crime, but if you remove it and I just have gang and then the person identified of who committed this crime, say if I remove crime and I just have person and gang, well, it's not a gang crime because it's not illegal to be in a criminal street gang. So if you're just a gang member who are minding your own business, sitting at home, and you didn't commit any crimes, then I don't have a gang investigation. If I remove the gang aspect and I just have person and crime, then it's just a person who committed a crime. Gang's not connected. But the moment I have all 3, I'm looking for my foundational block of a gang investigation.
All right. What do you look to establish a criminal street gang?
So many different gangs have different common names. They'll call themselves, for example, Bloods, Crips, Gangster Disciples, Vice Lords. Specifically here in Atlanta, it could be something creative, something newly formed from a neighborhood, such as Simp Set or some type of a nickname for a neighborhood that they have. They could have a common color, such as red or blue, purple, black, green. It could also have certain numbers and other identifiers. Some of the more established criminal street gangs that we have, not only across the nation, but here locally in Georgia and in Atlanta, they have several different identifying signs. So different numbers they use, different terminology they use, different colors they use, specific to their criminal street gang.
What are the type of crimes that criminal street gangs commit?
So there's three different categories. You have intra, which is you're going to be your internal gang issues. So think of one gang member violating or disciplining another individual in his gang. You're going to have inter, which is just in broad sense, Bloods versus Crips, so gang on gang. And then you're going to have extra, which is what we see most commonly, which is a criminal street gang versus the general public, someone who's not affiliated with a criminal street gang.
All right. How do gangs get members?
So several different ways, but most typically they target youth or juveniles. So school, the communities, also in Department of Corrections, Fulton County Jail, any other jail across the nation. There's several different ways that individuals can join a criminal street gang.
Please tell the jury the different ways to join a criminal street gang.
So the three ways, one could be an individual is jumped in or beat in. So this varies from set to set across the state, across the nation. It could be 31 seconds for one gang. It could be individuals of what they call a 3-on-1, which is 3 individuals jumping on one person. It could be a 5-on-1, 5 individuals jumping on one person. It could be a 1-on-1. It really depends from the set to set, territory, location. A lot of things different matter with this. The time allowed also can vary. Someone who is blessed in is typically such as a family member, like that individual has a high-ranking family member or a brother or sister, uncle, dad, mom, and they kind of just get brought into the gang. They don't have to get beat in or anything like that. Another form of being beat or being blessed in would be if you are committing crimes that benefit that gang. So not all gang members are, let's say, armed robbers, for example, or murderers. Some of them are really good at white collar crime. So if that is your skill set and you would benefit a certain gang, you may just be blessed in to the organization to help them make money. The last form would be sexed in. That's more commonly for females. However, not all females are sexed in. Some are beat in or blessed in, just like the males. But a sexed in would just be gang members initiating the female by having sex with her.
What is the difference? Respect. How does respect differ in the context of a criminal street gang versus the civilian idea or definition of respect?
So respect is everything, and when it comes to criminal street gangs, and I look at it this way: if an individual who is a gang member loses respect, whether it's from a rival gang or the community or within his own organization, that could bring the reputation of his organization, his criminal street gang, down. So in order to increase respect within his organization or into the community, that individual is typically typically have to do something called putting in work, which is committing criminal street gang activity. So committing crimes, violent crimes. You can become more, your notoriety can grow from these violent crimes, not only within your criminal street gang, but for rival criminal street gangs or in your community. You could be feared. And that fear is what protects and grows with these criminal street gangs. Whereas respect as a civilian, if I'm committing crimes, I'm typically not a respectable person, or people don't just respect me at my workplace. If I was to commit a crime, I would be fired. So that's how typical civilian jobs work.
And then amongst the gang community, what is disrespect, both inside the gang and then outside towards other gangs?
So it's very common for gangs to disrespect rival criminal street gangs. Now, any type of perceived disrespect is usually met with extreme violence, whether that disrespect was as minimal as throwing or posting something online of disrespecting a rival criminal street gang member or that criminal street gang. It's usually met with retaliatory shootings, murders, aggravated assaults, robberies, and other disrespect. So it's ongoing, and that's why we have this bottle effect. One criminal street gang disrespects another, that disrespect goes back, and violence erupts back and forth until it's kind of in the situation that we're in right now.
Okay. Young Slime Life specifically. When was it founded?
So it was founded in approximately 2012. It is a formation of several different criminal street gangs. It has traditional criminal street gangs and something that I consider local hybrid criminal street gangs. So some of the formation of it stemmed from Rock Crew, which was raised on Cleveland. It eventually formed into YSL, also known as Young Slime Life, in the Cleveland Avenue corridor of South Atlanta. They do have territory across Metro Atlanta to include Jonesboro Road, up to some locations around Smith Street and Irish Street, some locations on different blocks on Cleveland Avenue as well. They have several different identifying signs and symbols. The leadership has gained notoriety throughout music and crimes throughout the state.
You said specifically Smith Street and Irish Street. Is that in the Pittsburgh community?
It is.
In the city of Atlanta?
It is.
Okay. And then particularly, I'd like to direct your attention to the 1100 block of Irish Street.
Okay.
What is the significance of, or influence or significance of YSL as it pertains to the 1100 block of Irish Street?
So, like I said, they have different territory across Atlanta. Some is on Cleveland Avenue, some is on, one location is on Irish Street. That specific location on Irish Street, they have been known to sell narcotics, and there has been trap houses located with an allied criminal street gang of YSL known as Duct Tape that operates out of Smith Street specifically.
So is the YSL, the area, is that primarily Irish Street then? In that community?
In the Pittsburgh community,
yes.
And some parts of McDaniel as well, which is like one street over.
Gonna breeze through this slide, but is this just depicting the original area where it was first founded?
Yes, and you can see Cleveland Avenue, the Browns Mill, Mount Zion Road area. There's different apartment complexes in that area. It's controlled by Young Slime Life.
What is a hybrid gang?
So a hybrid gang is, so first off, let me explain what a traditional gang is. So a traditional gang is something like Bloods, Crips, Gangster Disciples that has a current rank structure. They have rules, orders, books, Bibles. It can be traced back to the 60s. A local or neighborhood gang is something that has takes on different identifying signs. They use common names and different terminology to identify themselves. Maybe it hasn't been as established. And what we have seen is, especially specifically in Atlanta, and we see the formation of traditional gangs such as Sex, Money, Murder, 9 Trey, even Rolling 60s, combining with some of these local criminal street gangs and forming something new, specifically like YSL, where you have Sex, Money, Murder, 9 Trey, 5'9" Brims, Neighborhood Rolling 60s, all creating one gang to essentially control an area to control an area, to make money, and to commit crimes and gain notoriety for the criminal street gang. Now, a lot of people think, oh, well, like this is weird because they've seen on movies like in the 90s or something like that of like Bloods versus Crips. There's this huge rivalry, but the reality is like that is not existing. While that may be common in specific areas, that's not what is happening here in Atlanta. Now, there are some rivalries of Bloods versus Crips. There are some rivalries of internally with different Crip members or different Blood members of the same organization. But the reality is most of these gangs are forming together, creating their own individual hybrid gang, and then controlling a territory or multiple territories across the city.
What are some of the terminologies used by young slime lab?
So there's several different terms that they use. One of them is SLAT for SLATT for slime love all the time. For one of the symbols that they use the color green in snakes, so in slime. So if you see anything with that type of terminology, it could be an identifying sign for YSL. Some of their other acronyms they use is ESPN, every slime play nasty. Rob for some of the Blood members of YSL for representing Cleveland Avenue, which is raised on Cleveland. And if other members may say raised on Cleveland for Rock Crew. RG for Rudy Gang, which is one of the members that passed away as a juvenile. He was killed. SOS, Slime on Sights. These are just some of the terminologies that they utilize.
What would slime on sight mean?
To kill someone on site or do extreme violence to someone.
What are some of the common identifiers you see associated with the young slime life gang?
So the common identifying sign is the color green. So whether that is bandanas, the use of emojis on social media, such as green hearts, snake emojis, little emoji icons of the green throw up. There's several different things, but the color green is very specific to them. Another one of their signs is you can see depicted in this photo is an individual throwing up YSL. So it's
you tap the bottom portion of your monitor. Please circle the YSL symbol.
So right here, you can see that individual is throwing up a Y. The S is with these two fingers, and then you have the L. So that's what YSL will throw up. Some of the other identifying signs that you may see with this criminal street gang is specific to whatever subset they may be. So if I was a sex, money, murder YSL member, I would throw up sex, money, murder. If I was not Trey, I would throw up this with a YSL. So it varies for each individual person, but YSL as a whole, this is a common identifying sign is YSL. The color green. And if you go to the next slide, I think there's some more images.
You can erase that circle.
Okay. And this is just more depictions. You can see I made an outline of the YSL and a hand sign, so it's just more easily identifiable to see. It can be commonly misidentified as a rival criminal street gang of the Inglewood family, the Nine Deuce, which is also operates in Atlanta. But they throw a very similar hand sign, just a kind of a 1/4 of an inch. So for an IF would be a rival of YSL, but specifically YSL throws it as a specific, very abundant Y.
What other symbols do you often see them, or motions do you see them make?
So another common hand sign is a wiping the nose aspect. I'll sometimes see these individuals throw up the wipe under the nose and then also throw up YSL. It's not uncommon to see both of them at the same time. That terminology is to wipe someone's nose. So it's to essentially the reference of killing someone, causing serious injury, robbing, shooting an individual. They'll commonly refer to sliming someone out, which is a reference to committing extreme violence to that individual, and that's how they would identify it.
Are there any sort of animals, reptiles associated with YSL?
Yeah, so it's mainly snakes. They really like using snakes, and whether it's music videos, holding snakes, utilizing the snake emojis. They will also commonly use like lizards and other reptiles.
What is tagging?
So tagging is just essentially spray paint from a criminal street gang that identifies a territory owned or operated from that criminal street gang. It's a warning sign to rival gangs, like, hey, this is owned by us. It's also a warning sign to the community of who actually operates in an area.
What sort of common identifiers do you see on social media, often associated with YSL?
So there's several, but green heart emojis, green snake emojis. You can see several different postings, just kind of various descriptions of slime or slat for slime love all the time. There's a reference of blat for blood love all the time. The reference of slime, the reference of YSL. These are some of the common identifying signs that I see with investigating this criminal street gang.
And what is the significance that the music industry plays in the criminal street gang activity and criminal street gangs in general in Atlanta and across the country?
So it's very common for some of these commercial street gangs that may have a record label to be discussing types of violent crimes that this criminal street gang commits and is committed by the organization. It also can be used as a recruiting tool in some situations to the youth in our neighborhoods and in our communities, but oftentimes it's to show they're able to show disrespect to rival criminal street gangs or rival members. They're able to brag and boister their criminal street gang of how it's better by showing off money. They're also able to display guns, whether props or real, because they often will put disclaimers on their videos that say these are prop guns, but it's still portraying the same imagery of, hey, we have guns, we're armed, and we're willing to commit violence to a rival criminal street gang.
Have you seen a theme of real guns being used in videos with a message saying this is prop guns?
I have several times.
Why do you think that is? What are they trying to avoid?
They're trying to avoid incriminating themselves, typically, if that individual may be a convicted felon or something like that, and he's in a music video with his criminal street gang holding a gun. He would rather it's a prop, so he's not incriminating himself.
And I think this would be a good point to share music videos that you've identified as being relevant. I'm going to play each one only once, and in between, I'm going to ask you some questions of how they're connected to criminal street gang activity.
Okay.
And a reminder, ladies and gentlemen, these two videos are being admitted for your consideration, if you consider them in any way, as to defendant Robinson only.
So you're not going to be able to see it in front of your screen, Investigator Miller. You'll have to turn. But this is the first video you identified. It shows that it's Slim Santana, Ola Runt, and YSL Benji. Is it common for the artists in these videos to have or call out other prominent members of the gang to be part of their actual music video shoots and promotion of the game.
Yeah, so it's very common. So if one criminal street gang has an alliance with another criminal street gang, they would even invite them out to this, so to be part of this, to show others who they're aligned with and who they're not. Now, criminal street gang active rivalries and alliances, they change very, very commonly here in Atlanta. So this is just, one example of an alliance.
Guns up, fucking guns up, everybody's fucking guns up, guns up, guns up, guns up, fucking guns up, guns up, guns up, fucking guns up, guns up, guns up, yeah, guns up, guns up. Fucking with this, you get crazy. I got new cheese on everybody, no cash out. I'm in the trap, put this outside in some rain routes. Try to hold your gun up, double that you run it up. Once I get your guns up, hey, fucking guns up, guns up, guns up, hey, fucking guns up. Guns up. They don't like it, watch 12 hit me, twice you can breathe, just with me in my teeth, baby, look at I can be, got some flesh shit on my sleeve, brain is blinking to a green, and it's all train me, pull up, I no backseat, be strong, bitch, guns up, I don't give a fuck, I got a yellow bitch, she ate it, dick, ate it up, I said, oh, I don't give a fuck, guns up, cause I keep it tick, and I keep it $90, I'm a dollar, my respect, I'm a shot, I'm a rap, I'ma come and get that money, need it all right now. 20s, 50s, all those niggas on me now, right now. I got a tech on me, nigga, in the booth right now. Got that kissing in my fucking face, I can right now. Guns up, fucking guns up, guns up, guns up. Yeah, guns up, guns up. Fucking with this, you'll get cracked back. Put a number on this ass like a I got new cheese on everybody, no cash out. I'm in the trap, put this outside in some rain route. Guns up, try to hold your gun up, double that you run it up. Once up, get your guns up. Wipe the nigga stain, I can't get it back in number 2 and 12, grab the bump and I don't know. Check it out with an XD, we on like a small on cheese. I just got my alcohol, I just customize my car. Did a drive out on your block, finish like a fit right. You don't just like the kitchen. You catch a cat, the judge and fire your ass just like some chicken. Interrogation just inside of it, don't look suspicious. My household, man, I know something about that, but the breaches. Gotta keep a gun, tweaking white car, but call me. Don't say hold on, shine, independent, hold on, sign. Drive by, but I ain't drive. Take a bar, but I ain't crying. Bloodshed, but I ain't dying. Gotta stay up, cause I ain't tired. If you all you know, right now, if that bitch, you know you dying. Put on your phone, I'm very rich and drop out. I heard you in it from clout, heard you in it from fame. Blood on my shirt, that's a stain. Guns up, hey, fucking guns up, guns up, guns up, hey, fucking guns up, guns up, guns up, yeah, guns up, guns up, beep, beep, beep.
Recognize the location of that video shoot?
Yeah, so that is on Irish Street, the 1100 block.
Okay. And is it common for gang members to use the block numbers associated with their name and referring to themselves and or others?
Yes, it is very common for them to create music videos or social media postings in their territory that they control.
Okay. And I heard a couple terms that I want to ask you about. There was a reference to wiping someone's stain. What is stain and what does that mean in context of saying wiping someone's stain?
So stain is like, it is a rank or status, respectability has like multiple different meanings within a criminal street gang. So the only way to increase your stain would be to increase your status of that criminal street gang. So, for example, if I was a newly formed member of within a criminal street gang, I just got beaten and I hadn't committed any crimes for the gang, I would be known as someone that doesn't have any stain yet. Whereas someone who is a known shooter or a known robber or known for killing or disrespecting rivals, they would have more stain within the organization.
What does it mean to wipe someone's stain? If you wipe someone's stain, they can't get it back. What does that mean?
So wiping it would be to kill that individual, wiping them off, like it would be that context.
Well, one more music video. And this is this the date that you were able to retrieve this video? Play nasty.
Yes, it would be.
And where did you first come across this video, Play Nasty?
It would have been publicly broadcasted on YouTube.
And did you ever see it inside of? Did you review Tyrone Robinson's phone?
Yes, I did.
Okay. Did you see this video actually stored in his phone as well?
I did.
Now, what does the term false flag mean?
So false flagging would be if an individual was to false represent that he was part of an organization that he wasn't part of. Is very rare, and if it does happen, or anytime it would happen, and that individual would be met with a real individual of that gang, and they found or they knew that individual wasn't part, they would be met with some type of extreme violence, whether it's like beat up or robbed or shot or killed. But something would happen to that individual if they were caught false flagging.
Okay. Now, based off of those two music videos, do you have a determination of membership of the gang YSL of Tyrone Robinson in your expert opinion?
Yeah, so he's in the music videos. There's several different identifying signs that we saw in both videos. It was hand signs by individuals such as YSL, the different organizations that make the different national criminal street gangs that make up YSL, such as sex, money, murder hand signs, nine tray, the green bandanas, individuals wearing chains that say YSL. Some of the individuals in the music videos being charged with other YSL crimes and connected to other crimes of YSL. The collectively and totality of all these identifiers, yes, I confidently say that he is a member of YSL or Young Slime Life.
Okay. Now, these images that are included appear to be screenshots or images taken during the shooting of that music video.
That is correct.
And did you come across these on Tyrone Robinson's phone?
I did.
Now, especially considering that this was filmed on Iris Street in the city of Atlanta, what would be the ramifications in this city of false flagging or stating your membership without being a member?
You would be met with extreme violence if you were false flagging in their territory. You would not be invited to be a part of anything that they're doing.
Now, I understand that these are music videos. Are the music videos in and of themselves illegal?
No.
Okay. How does the crimes committed by these members, how does it promote, or does it promote the gang when they are sung about in these music videos?
It does. So, for example, in the first music video, they were talking about they gave threats to rival gangs, like "Don't mess with us." They also talked about selling za, which is marijuana. So they're talking about drug sales. In the second music video, they're talking about specifically how they will get individuals who are with them to pistol whip you and to rob you and to injure you with firearms. So that is boistering that they are a violent criminal street gang and willing to do those offenses, and that they do those offenses.
Now, I understand the dynamics here and the way, but all music, in particular rap music, not all rap music is considered gang associated, correct?
No, there's all kinds of rap that is not gang related. Some is, some isn't. Some's, making millions, some isn't. It just kind of depends. No, there's all types of music though.
And I want to also touch on that dynamic too. Do gangs themselves tend to be segregated based on race, whether it's white or black?
Yeah, so it can. So it's not all gangs, but some gangs are racially motivated, such as any type of white nationalist type criminal street gang is primarily white men. KKK is typically the Ku Klux Klan is typically white people. Gangster Disciples, which is a criminal street gang, is actually a mixture of both white and African Americans. Hispanic gangs are typically, for example, like Serenos are typically Hispanic or Latinos, or some white people. Nine Trey, Sex, Money, Murder, most Crips, predominantly African American, but occasionally there are some white members. Same Pyru can be predominantly African American, but there are some white members, some Hispanic members as well. But it really depends on the actual criminal street gang itself.
Now, what's the importance of fashion or clothing and colors inside of the criminal street gang?
So, it can be important to display or flag your colors and represent your criminal street gang through social media. So specifically though, it's not as boisterous as TV or movies makes it anymore. It can be, but it's typically not. Like, you don't typically have an individual who is wearing red shirt, red hat, red shoes, red pants, with the red bandana, walking down the sidewalk saying, "This is my hood." Typically is a little bit more discreet, because that would attract a lot of heat by law enforcement if we saw that. It's like kind of a red flag goes off, so to speak. So individuals will often, they'll still flag, but they will commonly reserve that for social media postings, for example. Occasionally the younger members can be caught with flags, like whether it's tied on their right side or left side, or in their pockets, in their front pockets, back pockets, tied through their belt loops, or tied on a firearm, can also be common. But it's not necessarily, you have to, wear green head to toe to be considered a member. Some members could, you can wear nothing that's green, but still represent your criminal street gang online or in the community by displaying the hand sides, tattoos. So that's why there's so many different identifying signs for these criminal street gangs.
And are these more, these photos that are here, are these more photos and screenshots that you obtained through Tyrone Robinson's site?
That is correct.
So what is the screenshot in the middle, Slim Santana? Who would that be? Would that be the artist we just saw?
That is.
Okay. And the individuals in that, do you notice any signs and identifiers of YSL?
I do. So right here, that individual is throwing up a YSL while holding a green bandana. Robinson right here is throwing up YSL while wearing a green bandana. This individual in the middle, he's throwing up a very common blood hand sign. It's this for blood love. This individual is Slim Santana. He's throwing up a double pistol, which is paying homage to Sex Money murder founder Peter Rolak, who went by the nickname Pistol Pete, just another criminal street gang that is part of YSL. And then you have the accused right here wearing holding a green bandana. Some of the other captions in this as well, in this posting, I can't really see it from mine, but it says, meet with the rap shit, 1100 snake pit. We're gonna take some. I had to tell my partner Jill because he was gonna whack some with a tornado emoji. So that tornado emoji is reference to like spinning, or like to spin the block. So shoot or rob or steal. The snake pit reference is a reference to they have several individuals and members in the 1100 block of IRA. Since they will reference themselves as snakes, they're referencing that territory as a snake pit.
In that last photo, keep moving, that last photo, can you please, that screenshot, who appears to have posted that screenshot?
So the Instagram vanity name is Rick Rare.
I think we've covered this. Oh, actually, I want to get back to one thing. Only on the far right picture, what does happy Slat Day? What does that mean?
So it could be multiple different meanings. It could be that individual's birthday. It could be different criminal street gangs have their own hood day. So it's like the birthday of the gang. So YSL does have their own hood day. They have a Cleveland Avenue Day that's hosted on Cleveland Avenue. That they have individuals that have cookouts, music, people usually drinking, maybe a little bit of marijuana use. But it's an event-based community event that they host.
Okay. And to be, based on what your testimony earlier is, if all these gang members were associated, in fact, hanging out, just drinking beers, having a good time, so long as they're not committing any crimes, there's nothing illegal about that, correct?
That's correct.
Now, this particular case, are you aware with the general facts of the case, the home invasion at Wiley Street?
Yes, I am.
Okay, now, what is it that connects, the person being Tyrone Robinson to the gang and to the crime itself?
So we saw, could you repeat your question one more time? Because there's like 3 parts.
Sorry, I should have, all right. Let me start with this. When it comes to criminal street gang activity, what is a nexus?
So a nexus is it's a word we don't typically use, but it is simply a connection. So how does that connection or that activity benefit the criminal street gang? And if something benefits the individual member, it in turn benefits the criminal street gang. So a good example of a nexus would be individuals committing a crime in public or with another individual that would increase both individuals' status because they had a witness with their gang essentially witnessed them commit a crime. So they would be able to tell other gang members of what they're capable of and what kind of crimes that they do, which in turn would increase the status of the gang because they commit violence.
Okay. Do all nexus, in a sense, do they all have to be a public commission of a crime?
No, I mean, it can be as simple as making money from drug sales. It can be as simple as stealing guns or stealing an item. It can be as simple as killing a rival criminal street gang member. That would benefit the gang. It could be multiple different aspects of how a nexus could benefit a criminal street gang.
And when you're dealing with nexus and looking at how it benefits a particular street gang, do you tend to, do you ever look to see if whether the proceeds of a crime are split between the members of the gang?
Yeah, so sometimes there's evidence of, or we get through, different interviews that I've done throughout several different investigations. Funds or proceeds from a crime can be distributed in a multitude of different ways. But yes, when the profit is shared, it's usually shared by those who commit it, and whether who else benefits from it from that criminal street gang, whether an individual member kind of gave them a heads up or kind of orchestrated this crime, would that individual benefit from proceeds, or if that individual kind of paid them to go handle something. It really depends it's totality based.
All right. We saw those pictures earlier of when it comes to defendant Pritchett. This one here, what do you see that indicates any reference to YSL or that specific set?
So
there's just a delay. It's really bad. Can you see on your?
It's medium bad.
I was looking at 3 different screens with different.
Yeah.
This one's.
So there's several different identifiers that I see. One is the accused depicted in a photo with his Instagram handle, but he's standing with individuals who are throwing common identifying signs. One individual's throwing up a double pistol. One individual's throwing up a big B for Bloods. This individual, his moniker is YSL Benji. So he's actually using the acronym for the criminal street gang YSL while throwing up different hand signs. Then the posting itself is reference to 1100 block with a green heart emoji. And although it's this geotag says Pittsburgh, Pennsylvania, this appears to be the same house that was shot off of Irish Street in the Pittsburgh community of Atlanta.
your screen changed?
It has.
So same question with this picture. One, where does this, what's the poster of this picture?
Yeah, so this is a posting from Rick Rare. You see an individual throwing up YSL for Young Slime Life. The utilization of a green bandana, which is a color used by YSL. I see the actual posting states, can't see because of the zoom aspect, but it tags two individuals, a Young Bands, which is a rapper, a YSL rapper, and then Rick Rare. And then they're also posing in a Rolls Royce, which is, I mean, a high dollar item.
The caption, can you read it from the here?
Okay. This is,
If I approach you.
I got you. I moved my face. The caption states, Red Dead was hard. So I'm assuming they saw a movie. There's a snake emoji. There's a acronym of SLAT. And then their Instagram vanity names.
So based off of what you've seen in your investigation into the gang aspect of this crime, would you consider Mr. Maxx Pritchett, or also known as Rick Rare, to be a member or an associate of the criminal street gang YSL?
Absolutely. With the several different postings using acronyms commonly used by them, holding the green bandanas, communication with them, posing in their territory. Absolutely. I would say he's a member of Young Slime Life, YSL.
And again, in the city of Atlanta, as it goes to Maxx Pritchett specifically, what would be the fallout of holding yourself or false flagging as a member of YSL if you were not?
Objection on ask and answer more than once.
Indeed. Next question. Maybe only once, but still asked and answered.
Okay. Now, I'm showing you what's been admitted is criminal street. I mean, what's been admitted as State's Exhibit 16. What about the cost and color of clothing? How does that come into effect or play a part in criminal street gangs?
So it's very common for criminal street gang members to pose with high dollar items, whether it's high profile shoes or like Balenciagas or Versace shoes, and posing and kind of flexing like how much money they have or how much money the gang is making. So that's very common.
Okay. And is it common for the members of those gangs to buy those high dollar clothing items in the colors associated with their gang?
It can be. It can be. So, for example, like what's depicted in this photo is looks like a very slime green color that they utilize. So it wouldn't be uncommon for a YSL member to purposefully kind of flaunt that color.
And then this last picture, and give this picture of a warrant. Was that warrant, that picture, is that another picture that you uncovered inside of Tyrone Robinson's phone?
It was.
Okay. And what about the other two pictures pertaining to those to the two defendants? Were those both recovered from Tyrone Robinson's phone as well?
That is true.
So all right, so as it pertains to your PowerPoint, I don't have any more questions. I just want to talk about the Instagram and how you utilize it in determining, specifically when it comes to differentiating between vanity name and username. And give me 1 second. I'm going to go through what's been State's Exhibit 29. What's the difference between a vanity name and an account name?
So a vanity name is your username. An account name would be, for example, like your common name, John Smith. Your vanity name has to be a unique identifying sign different from any other vanity name on Instagram. There's either one can be changed, but they are different.
Popping up now. All right, so I'm currently inside what's been identified as State's Exhibit 29.
Okay.
Okay, so this is the Instagram dump of Tyrone Robinson. So I want to talk about a few things too. So I see that there are a couple, the first three, one's an affidavit, one's a PDF, and one's a zip file, for the last three. Are those, when you get the records, is that what you see originally?
Yes. So essentially the PDF files is time, date stamp of all the integrated videos, pictures, and so forth in this file. You'll see a zip folder, and it will have different content such as audio, if someone sent like an audio voice message or something of that nature, such as a call. If there is a video posting or a story posting or any other type of social media posting, it'll be in that zip file, whether it's video, picture, or audio.
Okay, and so the zip file, as it's zipped, is that going to contain the date that it is turned over to you, or Instagram turns over the records?
That's typically whenever it was pulled. So whatever custodian, whether from Facebook, whenever they pull that record, it'll typically be in that format. However, if you go through the business records aspect of it, it'll have a date time stamp of when the items were essentially posted, uploaded, shared, transferred, whatever the action may have been through those records.
Next question is going to be, can you even access the linked media and the digital media until you unzip that original file provided by Instagram?
Well, so it varies because each time it can be unlocked from a different, or you might get a different format. You might not even get a zip file. So it really kind of depends on the volume of items you receive. But if you were to get a zip file, no, you wouldn't be able to look at it until you went into the format.
And then the date of the linked digital media, is that going to then reflect the updated file of the date that it was unzipped as to the file name, not the media itself?
Yeah, it could, as long as it's, done properly. Yeah.
Then now, after stop sharing, we'll show you this last. All right. The account name, and then account name right here. What does that say?
So the account number says 1100 baby slat.
The account name, the account, okay. And then the registered email, what does that say?
Says Robinson Tyrone 999@gmail.com.
Okay. And then the vanity name.
The vanity name is _the goat 1100.
Okay. Now, Are the account name and the vanity name going to be displayed simultaneously on the front of your profile?
It can. It depends on the user's account and how they have it set up. So some people don't even have anything under their account name. They could just have a vanity name. Some individuals could have it matching. So it could say, John Smith, 1100, John Smith, 1100. It could say 1100 Baby Slat or the GOAT 1100. It can be changed whenever the individual wants to change it. There's a specific record number that is associated with that vanity name and that Instagram records that never changes. So as long as that account was created, every content, no matter how many times someone changes a vanity name or an account name, the records can be still figured out.
Okay. And is that number that never changes the target number?
Yes, it is.
In the vanity name, is that generally what's used with the @ sign when you are tagging somebody?
Yes.
Okay.
And is most commonly referred to as a username. Instagram and Facebook, they call it a vanity name. So I just call it a vanity name.
But if there is an account name and there is a vanity name assigned to an account, at some point they'll both be displayed on the front of the profile.
Yes.
No further questions for this witness, Your Honor.
All right. Ms. Mignot, you have more than 5 questions for this witness?
Is that a trick question, Judge? Yes.
Okay, I'm gonna hold you to that then. We're gonna break for lunch, ladies and gentlemen. I think it'll make the cross-examinations flow a little more smoothly because the lawyers can work on them during lunch rather than jumping to. And we'll just ask Investigator Miller to return after the lunch break and not talk about his testimony during that lunch break. It is about 12:40, somewhere about that. 1:30, too quick to have you be back? Seeing no one say no, great. Let's try to be back at 1:30 to continue with Investigator Miller's testimony. And we'll pick it up there. Any logistical questions? Enjoy your lunch break. No outside research. Don't talk about the case. Everyone else can be seated. Mr. Hiles, this is still your final witness.
Yes.
Ms. Mignot, you've had the weekend plus a witness and a half to continue thinking about this. At this point, are you planning on calling any witnesses other than whatever Mr. Robinson decides, which we don't need to discuss yet, about testifying?
No, Your Honor.
Okay, and Mr. Robinson, not yet, but once the state rests, we'll be having that conversation I discussed on Friday about whether you choose to testify, okay? Great. Mr. Pritchett, same question. Do you plan on calling any witnesses other than yourself? And if so, will they be here this afternoon? Because it sounds like the case may be in your lap mid-afternoon.
I do, but the earliest I could get them to come here would be tomorrow.
Okay, well, we'll have to talk about that during the break after the state rests and see whether we're going to wait till tomorrow or not. Ms. Riley is here and you're here. So should you have a good faith basis to call her, that can happen. And should you choose to testify, that could always happen today as well. I don't know that we'll take the afternoon off for other witnesses, but we'll talk about that more when we are working through the break that will naturally occur when the state rests. All right. All right. That's it. Let's be back, all of us, a little before 1:30, so we're ready for the jurors. Thank you. I'll mute the microphone in here. Folks want to stay.
Was the case okay for you, Your Honor?
It's probably not a great question to ask in this case. There we go. All right, back on the record in State versus Pritchett and Robinson. We have a prosecutor here, but that's enough to fly. We have Mr. Robinson and his legal team. Mr. Pritchett is back and Investigator Miller is back on the stand. Mr. Hiles, anything before we bring the jurors in? And they're all here. I don't know if you checked, but Ms. Niles checked also. We're going behind you on the numbers.
Nothing from the state, Your Honor.
All right, Ms. Mignot, you ready for cross-examination?
Yes, Your Honor.
All right, Mr. Pritchett, anything we need to talk about before the jurors come in? Let's bring them in, please.
All right, jurors.
Thank you, sir. Everyone can be seated. Welcome back, ladies and gentlemen. Hope you had a good lunch. Thank you for being on time. We're on time. It's about 1:30. When we stopped, Investigator Williams and Miller had finished his direct examination, and it is now time for Ms. Mignot, if she has any cross-examination for Investigator Miller.
Thank you, Your Honor.
You're welcome.
Good afternoon, Investigator Miller.
Good afternoon.
All right, I'm going to be following up to some of your testimony this morning, and I wanted to start with your experience as an expert in gangs. Is in terms of the slideshow that we saw this morning that you presented, the information you got was you pulled it from Wikipedia, correct?
No.
You did not pull the slide, the information that you placed in the slide from Wikipedia?
No, I did not.
Okay. As it pertains to the information that spoke about 1.5 million active street, prison, and OMG gangs, the first slide that you had up that had 2011 on it, you got that information from Wikipedia?
No, I did not. So that last study is from 2015. The picture depicts 2011, but the actual last study from the FBI was done in 2015 that actually demonstrated 1.4 million active gang members throughout the nation. And the over 30,000 gangs operating across the nation as well. That came from the FBI.
Okay, so you got it from the FBI's webpage and their information that they publish?
No, I actually got that specific information and that specific threat assessment directly from the FBI.
Okay. If it's on Wikipedia exactly in the same format, would that just be a coincidence?
It would, because that's how it is in their actual security threat assessment.
All right. Now, in the National Gang, are you familiar with the National Gang Intelligence Center?
I am.
Do they have a website?
They do.
All right. And isn't it true that on their website, they have depicted that the four main gangs are National Street Gang, the Prison Gang, Motorcycle Gang, and Local Street Gang?
So those are different categories of criminal street gangs. National. So national would be your large traditional gangs such as Bloods, Crips, Gangster Disciples, Vice Lords, and so forth. Prison gangs are gangs that are operating primarily in the prison. Outlaw Motorcycle Gang, OMGs, those are 1% criminal street gangs. And sorry, what was the last one that you said?
Local Street Gang.
Local street gangs, and that would be that hybridization that I categorized.
All right, so let's talk about your expertise. I believe you stated that you've had, is it 20 years of experience?
No, I started my law enforcement career in 2016.
Okay. And since in 2016, did you play any roles in investigating YSL gang membership?
In 2016, I did actually interact with several YSL members. I also investigated or assisted in an investigation involving, obviously I wasn't the lead investigator because I was still fairly new to law enforcement, but I was documenting an individual who was associated with YSL and involved in a homicide investigation in Douglas County.
Okay. And as it pertains to your years of experience, how many would you say that you've been lead investigator or lead involved in an issue associated with the YSL gang?
Several times, over 10 for sure.
Okay. And was any of those 10 times or a little over 10 times associated with the Fulton County District Attorney's Office?
Yes, some of them have been, yes.
Okay. So it's a fair statement to say that the majority of your knowledge and expertise regarding YSL came from your employment with the Fulton County DA's office.
No, I investigated YSL when I worked for the DeKalb County Police Department, Douglas County, and Cherokee County District Attorney's Office. I actually worked several YSL cases in all of the jurisdictions, mainly because YSL members don't necessarily just operate and commit crimes in Fulton County. However, they do have territory in Fulton County. They do commit crimes throughout the state.
Now, as it pertains to the information you provided today, you testified that you can either be jumped in to YSL.
Yes.
All right. You don't have any information that Mr. Robinson was jumped into YSL, correct?
No, ma'am, I do not.
You also testified that you could be blessed into YSL.
Yes, I did testify to that.
And you don't have any evidence for this jury that Mr. Robinson, my client, was blessed into YSL.
That is correct.
And you also testified that one of the other ways that you can enter is to be sexed into YSL.
Yes, that was my testimony.
And you don't have any evidence that Mr. Tyrone Robinson was sexed into YSL, correct?
No, ma'am, I do not.
Now let's talk about the testimony as it pertains to your role in this case that we're here for regarding Wiley Street.
Okay.
You don't have any information that would support that the Wiley Street incident was orchestrated by YSL, correct?
I do. There's orchestrated.
Yes, this robbery was planned by YSL. It was YSL's idea.
No, that it was orchestrated by it, yes. So from the case summaries that I have received, it was planned with the individuals involved who were arrested, and they committed the crimes. Can you be more specific?
Okay.
Are you trying? I'm not really.
So let me rephrase my question. The plan, the idea to commit a robbery at the Wiley Street location in this case, you don't have any evidence that that plan was initiated by YSL, correct?
I would consider the other defendants in the case that are not YSL members, I would consider them actually associated with YSL. So in a degree, yes, it was orchestrated and planned with YSL.
Okay, so let's get specific since you said that.
Okay.
According to the evidence in this case, the idea to commit the Wiley Street robbery came from Lauren Riley. Are you familiar with Lauren Riley in this case?
I am familiar.
Okay, Lauren Riley, you don't have any evidence, is a member of YSL, correct?
She is associated with Young Slime Life, yes.
Okay, my question is Riley a member of YSL?
Not to my knowledge.
Okay. And you are making the connection to YSL based on the fact that she may have gone to parties with somebody involved with YSL, right?
No, commit crimes with YSL, that would be the association aspect.
Okay.
And hanging out with them, that would be the association aspect.
Okay, so let's be clear. You testified this morning that you can be a member of YSL, not commit any crimes, and it not be an issue, correct?
That is true.
And if I'm a member of YSL and I'm not committing any crimes, right?
Yes.
Are you testifying to this jury that you would still connect it to YSL just because Miss Lauren Riley was part of the initiation of it?
Connect what?
Connect the crime.
The crime, yes, YSL as a whole can benefit from a crime committed by members of YSL. May not be enough to charge that individual itself, but would the gang benefit? Absolutely.
Okay, what would be the gang benefit if Riley is the person initiating the robbery in this case?
So if we're just talking about Riley and she didn't have the hypothetical of being associated or committing this crime with other individuals?
We're talking about this case, Wiley Street robbery.
Yes.
Which is Lauren Riley's idea.
Okay.
What is the benefit to YSL that Lauren wants to rob someone?
That's not their benefit. Their benefit is YSL members committing the crime and then collecting proceeds from the crime. That would be the benefit.
Okay. So if Miss Riley and her friend Lauren Kallish are the two individuals that committed the crime, that would have nothing to do with YSL, correct?
If they were the only two that committed the crime?
Yes, sir.
And they just acted it out completely by themselves?
That's correct.
And they took proceeds and gave it to YSL members?
No, they took proceeds and gave it to themselves.
If they just committed crimes by themselves, I don't see how that would be. I'm sorry, I don't see how that would benefit the gang, no. If it was just them two and it was just them two alone, no.
Okay. And as it pertains to the Wiley Street robbery, you don't have any evidence whatsoever, based on your involvement in this case, that Mr. Robinson was present at Wiley Street when Lauren and Lyndsey robbed the Wiley Street location, correct?
No, just the communications that I've reviewed in the case summaries.
Okay. As it pertains to what you've reviewed phone records, right?
I have reviewed some of the phone records.
And isn't it true that the phone records you reviewed does not show Mr. Robinson as the subscriber of that phone?
I would have to reflect my memory, but if you say so, that's probably true.
Okay. And in fact, the documents you testified from earlier today, which showed an email address for Robinson, Tyrone Robinson 999@gmail. Do you remember testifying to that?
I do.
If there are two Tyrone Robinsons that have come up in this case, you don't know which one of them it belongs to, correct?
No, I do not have independent knowledge.
Now, let's talk about how you determine whether somebody's a member of a gang.
So I'm looking at.
Well,
No, she has to ask a question.
I apologize.
It's not like on direct where Mr. Hile said, hey, what else do
I
you
thought that
think?
was the question. I apologize.
That's okay. It's all right. It's a different mode. She's gonna zero you in.
Sounds good.
Thank you, Anna. Okay, so let's talk about your testimony this morning, that this case you investigated only as it pertains to the gang aspect. Is that accurate?
I was just looking at the gang evidence. That's
Okay.
correct.
And you're looking for gang evidence to say, hey, one, is this coming from a YSL gang member, right?
Yes.
Okay. And you're looking for, was a YSL gang member present at the scene of the crime?
Yes.
You're looking for, did a YSL member benefit from the proceeds of the crime?
Yes, that would be an indicator, yes.
And those things you are able to corroborate based on cell phone tower evidence, right?
I did not go through the cell phone tower evidence. I specifically just was reviewing identifiers as far as images, terminology used, just the actual aspect of gang identifiers in this case.
Okay. Isn't it true that there are people, especially young people, we're talking about 19-year-olds and 20-year-olds, that will change their vanity or their handle or their social media name to use what they've seen, either an artist or a gang member or somebody they idolize on their social media platform.
Yes, it is common.
And using it does not mean you are part of it, correct?
No, not necessarily. Context matters, totality matters.
Okay. And based on what we looked at this morning, you showed several slides of someone else's social media account, right?
Yes, in the first half of my PowerPoint presentation, most of that is just showing generalization. These are some of the identifying signs that they utilize. And then the other portion of my social media was specifically the accused in this case is of them and their identifying signs with the criminal street gang.
So the picture that we looked at where you alleged Mr. Robinson was in that photograph. We're going to see if we can help you out.
Yes, please.
Mr. Robinson is in the photograph. You are determining that Mr. Robinson is part of a gang based on him being in a photo, correct?
Not just one photo. I look at the totality. So if I see several photos of an individual throwing up YSL with a green bandana in their territory and with other known documented YSL members, I'm looking at the totality of all of that. If I just had one photo of an individual doing like this, depending on the context, it could be, yes, they're a YSL member, or it could just be they're a kid imitating something they saw on YouTube. So totality matters, context matters.
Permission to publish, Your Honor?
Yes, ma'am. This is, I'm assuming you're using pages from States 38.
That is correct.
Published whenever.
That is correct. Okay. So you just testified that context matters and totality matters, correct?
That is true.
So using this photograph that you testified from this morning, do you see my client in that photograph?
I do.
All right. And he's wearing the exact same shirt in all three shots, right?
Yes.
Isn't it true that that is the exact same photo cropped by you in three different ways?
Yeah, yes, ma'am. I pulled them from the records and I put them onto one slide.
Wait, how is that the exact same? I'm sorry. He's standing next to different people in two of the pictures and he's seated in a truck in the third. How is that all one photo?
So it's not one photo. These are three individual photos that I put on one PowerPoint slide presentation.
Okay, because your answer was yes, it's all the same photo. I cropped them differently.
I apologize. I thought she was asking if he was wearing the same outfit in all photos.
Okay.
He was wearing the same outfit. These are three individual photos placed onto one PowerPoint slide.
Okay. And isn't it true, sir? You got all three of these photos from the video that was played this morning.
I did not crop these individual photos from the YouTube video. These are individual pictures that are completely no, I did not collect them from the YouTube channel.
Okay, not the YouTube channel. We played a rap video this morning.
That is true.
You recall seeing it?
Yes.
And it was the first one we played, and it was called Guns Up. Remember that being played?
Yes, I do.
Isn't it true, sir, that what you did is took one day of a photograph of a video and placed it in three different places because there are three different angles from the video that created these three photos that made one slide?
So I didn't personally crop the photos. I just collected these photos and then pasted them onto this PowerPoint.
Collected them from where? Where did you find these three photos?
These were collected in Robinson's phone and his Instagram records. The actual video itself is a completely separate file that I publicly viewed on YouTube. I didn't take any individual crops of that YouTube besides the recording of the video.
Okay, so it's your testimony that it's a coincidence that he's wearing the exact same shirt in the video?
No, I'm saying that this likely occurred from the same time they recorded it, but I didn't obtain these photos from the video. You said I cropped.
Okay.
I personally did not crop photos from a YouTube video.
Okay. So let me ask a different question. if this is the exact same day, but 3 different shots of him on the exact same day, it would be fair to say, if context matters, it's one incident, correct?
That is accurate. This is, I would assume, the same day because of he's wearing the same outfit. The other individuals depicted in the YouTube video are wearing the same outfit as in the music video. Yes, I would assume that it would be from the same day.
Okay, and it would be unfair to take one music video that he's in and say, gang member, YSL, right?
Not necessarily, because I'm looking at the context of the individuals involved, specifically what is being shown to me. So I'm seeing several different identifiers on this day, as well as I have seen and observed on other days the same terminology, same identifying signs.
Okay, and you've seen them from actual members, right?
Sorry, say again?
You've seen those same identifiers from actual members of YSL, correct?
Yes, multiple members of YSL.
Okay, and if I am not a member of YSL, and I'm just a young, impressionable teenager that showed up for a video shoot, you would have me in that video, correct?
If you were depicted and captured on that video, I mean, there were several people there at that event that I have other pictures from that weren't necessarily in the music video, but yes, you could be depicted in the music video if you were there.
And based on your standards, you would say I'm a member of YSL gang, right?
If you were just present?
Correct.
That's not really enough identifying signs for me to say someone is associated or a member if they were just seen there. I'm looking for the totality. So hand signs, what are you wearing? What are you saying? What are your actions? What are you doing? The context and totality matter.
Looking at the 3 different shots with him wearing the exact same clothing, there's nothing unlawful about this shot that we're looking at, correct?
No, ma'am.
Okay. All right, so I'm showing you what you had identified this morning as your triangle to show or depict the connection as to how you determine whether a group is a gang or not, right?
That's true.
All right, and what you have here is the word gang, and you used a green, what I thought was a magic carpet, but it's supposed to be a bandana, right?
That is correct.
All right, so you used a green
Could be a magic bandana.
and the word crime and person, right?
That's true.
So this person you're saying is a member if they're using a green color, right?
No, so I'm not ever looking for one identifying sign. I'm looking for a totality. So hand signs, colors, clothing, terminology, several things. If one person has a tattoo that is an identifying sign of a criminal street gang, that doesn't necessarily mean that they are a member or associated of a criminal street gang. I'm always looking at the totality. There isn't an exact number, but I'm looking at multiple things. So if someone's just wearing green, that doesn't necessarily mean that they're a member of YSL. That's not enough for me to say and comfortably say. Individuals can be mislabeled, so I'm looking at several identifiers.
Okay, so let's use this slide. You took a picture of my client and you threw it up on your slide, right? You created this. Is this your PowerPoint?
I did create this PowerPoint.
Okay, and you took a picture of my client and you put it in your triangle as person, correct?
I have.
And it has to be 3 or more persons in that area, correct?
In that era?
In order to determine a gang, your definition this morning was that you needed 3 or more persons. Am I accurate?
Yeah, that is accurate.
Okay. And you have in this depiction only one person, right?
That is correct.
So this is not truly an accurate definition of what is required for us to close this triangle as it pertains to definitions of a gang, right?
So it is. So the three aspect is three or more members, whether formal or informal. That's the top part of my triangle. So the gang aspect. So I have to establish that the gang exists. So three or more individuals, whether formal or informal, who engage in criminal street gang activity.
Don't talk too fast,
Yes, Your Honor.
please.
They have to have an identifying sign, symbol, or some type of characterization that they go by. So Young Slime Life, YSL, they use the color green. They have more than three members. They do commit crimes such as murder, armed robberies, aggravated assaults, home invasions, burglaries, drug offenses, a slew of offenses over the years. And then I'm showing the person, so the person who is charged with the crime, how he is connected to the criminal street gang.
Okay, so let's talk about the definition. What you were just testifying to this jury is this definition you showed this morning, three or more persons associated in fact, right?
That is correct.
And then it's formal or informal, and then they engage in a criminal gang activity.
That's correct.
Is selling drugs a criminal gang activity?
It is.
Does it matter if it's marijuana gummies or marijuana wax or ketamine?
No, all drug offenses, including misdemeanor marijuana.
All right. So if I have a party and there's three or more of us at that party, and say, for example, my gang is the Models Gang, right?
Okay.
And we put on an informal event because we don't have bylaws or anything like that. We're just informally meeting. And this is what we do. We just keep meeting. And what we do is we sell drugs. That would be engaging in criminal gang activity, correct?
If the model gang has three or more members, they have a identifying name, such as the model gang as described, and they sell drugs, that would be considered under the definition of the gang act would be a criminal street gang.
Okay. Now let's talk about this case.
Okay.
You don't have any evidence that places my client, Mr. Robinson, at the Wiley Street robbery that was constructed by Miss Lauren Riley, correct?
Not outside of tests or statements.
Okay. Let's talk about electronics then.
Okay.
Do you have any cell phone that puts my client at the Wiley Street robbery?
Not that I have reviewed.
Okay. Do you have any cell phone tower that puts my client at Young Band's house?
I didn't review any of that.
Okay. And it would be important to review it because you're trying to connect this to a gang, right?
No, so that would be connecting the crime and proving the predicate offenses. The lead investigator, whoever did that, handled that aspect. I reviewed case summaries and I'm looking for the gang evidence, not the actual investigation, the literal predicate crime.
But the predicate crime cannot be bifurcated from the gang if you're saying that this is gang related, right?
That is correct. That's why I'm reviewing case summaries like that. If I was the lead investigator handling the case, sometimes I would do it all. But in this specific case, I didn't do the entire investigation by myself. All I did was review the gang evidence and case summaries. Okay.
But you are required to corroborate or work with or cooperate with the lead investigator on this case, right?
I don't know if I'm like required by law. I know I'm not.
Well, it makes sense if you all are working together on the same case, right?
Yes, but some investigators have retired and moved to other units and so forth. So typically, if a published final case report is established, then sometimes I will do my work on the back end. Best practices is typically working on the front end, but the evidence is the evidence. So I just reviewed what the investigators that conducted the investigation had done.
Okay, and did you review that in this case?
Yes, I reviewed case summary and the gang evidence and some cell phone records.
So you are aware that there's no evidence that places my client at Wiley Street, right?
So you've asked him maybe 5 times now about evidence at Wiley Street.
I'll move on from Wiley.
Okay.
Although that's the reason why we're here.
Okay, and he's answered every time, nope, I don't have that evidence.
Got it. As it pertains to Young Bands, the 14th Street location condo, you don't have any evidence that my client was at that condo on November the 8th of 2019, correct?
No, I do not.
You stated that the gangs are comprised of smaller hybrid gangs from Cleveland Avenue, right?
Yes, originally, yes.
You don't have any evidence that my client is from Cleveland Avenue, correct?
No, I do not.
You don't have any evidence that our client is from Creek City, correct?
I do not.
Don't have any evidence that our client is from or affiliated with Young Loyalty, correct?
No, I do not.
You don't have any evidence that our client is from the Browns Mill Road or Jonesboro Road area, correct?
I do not.
Now, you have to interpret a lot of what you would call terms used by groups that you refer to as gangs, correct?
Yes, yes, I interpret a lot of things that different criminal street gangs identify themselves with. I get a lot of this information from the gang members telling me, whether it be interviews, whether formal or informally interviews, such as custodial interviews or non-custodial interviews. But yes, I collaborate with several different reasons to base my opinion on how I interpret these identifying signs.
Are you aware that the term YSL stands for more than just a gang?
Yes, so the terminology it's commonly known as young slime life. However, there's also other terms such as young stoner life, or there's different creative measures of why they would change their name of YSL, but it is commonly known on the street, within the gang, and within rival gangs as young slime life.
Are you aware that Young Stoner Life is a record label company?
Yes, I am familiar that Young Stoner Life is a record label that also goes by YSL.
Okay. And if I am a rap artist that is signed with Young Stoner Life record label, it's not uncommon for me to use YSL to represent them, correct?
Yes, yes. If the individuals who are actually signed to Young Stoner Life, they're signed by Young Stoner Life and they're on their website and get paid to rap and record, and they're legitimate artists signed by that record label, which is a legitimate business.
Now, as it pertains to the social media played a large role in this case and in your decision to say for certain from that stand that you believe Mr. Robinson is involved in a gang that goes by the name YSL, right?
That is correct.
And isn't it true that all the social media, whether Instagram account, as you testified this morning, is controlled from that device that you saw depicted in the exhibit the state showed you by the subscriber, as you testified this morning?
Yes.
Okay. And if Mr. Robinson is not the subscriber, it's controlled by someone else other than Mr. Robinson, correct?
Yes, it could be.
And if I post on my social media and you comment on it, I cannot control your commenting, correct?
I mean, you can block someone, you can delete someone's comment if you wanted to, but it also depends if your account's public or private. So you can kind of control who comments on your stuff that way, in a way. So depending on how you're asking.
So let me clear it up. If the subscriber, which you know not to be Mr. Robinson, didn't block anyone from commenting on their post, Mr. Robinson doesn't have any control of that, correct?
If it's public, then it's public. So anyone can just comment whatever they want. If it's private, you can control that aspect as an account holder.
Okay. And if he's not the account number holder, he's not the person that can control it.
No, it would have to be whoever's in possession of that account.
Okay.
Do you have to be the account holder, or do you have to be someone who has the ability to manage the account? You've got let's pretend, an Instagram account you unwisely share with me. Here's my login information. I could get in there and make things private, block people, moderate, as long as I don't have to be Investigator Miller. It's not a thumbprint kind of thing.
That is correct.
Okay.
And based on the court's question, you don't have any evidence that Mr. Robinson accessed a third party or the subscribers account that we're talking about here?
Not to my knowledge.
Okay. Now, jumped in, blessed in, and sexed in. Isn't that also sometimes the way you get into a fraternity when you're in college?
I mean, that would be some extreme hazing, but you could consider it, I guess.
So are fraternities considered gangs?
No, so there's a huge different aspect of what a fraternity versus a criminal street gang. So fraternities do great things for the communities. They do community events. They're, it's a networking stuff. If they're committing crimes, that fraternity would look bad. Whereas criminal street gangs, their entire aspect of how they operate is through criminal street gang activity.
Isn't it true that if I'm a member of a fraternity and I go out and I rob the Burger King 12 burgers and bring them back and share them with the other people in my frat house, that's benefiting, correct?
But
is that a yes or a no first?
He can give his whole answer. The yes or no can be anywhere in there. So let him answer. If he doesn't answer, let's ask it again.
I would say no, because I don't personally think that crime would benefit your fraternity. I think your fraternity would look bad that you stole. I think that you'd probably be disciplined, probably kicked out of your fraternity for that, maybe even disciplinary arrested. The status of what type of fraternity matters as well. Like, are you a college student? Are you a philanthropist? I'm not really sure, but whatever type of fraternity you're committing crimes for, that would be a bad look. And most members of the community aren't members of a criminal street gang. If they are a member of a fraternity, they're a member of something positive for the community.
Okay, so could that be your position because of race?
Absolutely not.
Okay. Now, you testified this morning that there is racial components associated with the gangs. You remember that?
Depending on what gang, there are some that are strictly hate and racist, or race motivated. Some aren't. Some are just because of how they set up. It really depends on what gang specific. There are several white gangs, there are several Hispanic gangs, there are several African American gangs. There are some that don't have a rule or any preference to what race matters, or some that's their entire focus is you can't intertwine races and like supremacies.
Now, the majority of the street gangs that you have been involved in are associated with rap music, correct?
Not necessarily. I mean, I've investigated hundreds of criminal street gangs. Some have rap music, some don't.
And rap music in and of itself doesn't make you a member of a gang, right?
No.
And that's even if I do a video with somebody you believe is part of a gang and ask them to be in my video, correct?
I mean, if I've identified someone as a member of a gang and they're making a music video and then they invite other people to their music video and I'm seeing identifying signs of their gang, then yes, I would say that would be associated aspects of the gang. I mean, it really just depends on the specifics and the totality of that.
What if I only showed up because they were going to pay me $100 to come dance in the video and to hold weapons and act like I'm part of the group and wear certain colors? That wouldn't make them members of the gang, right?
Not necessarily, no.
Okay. And as it pertains to, I believe you talked about white supremacy gangs?
There are white supremacy gangs throughout Georgia and throughout the nation, and they're international as well.
How many have you connected to a genre of music?
So Ghostface Gangsters is a primarily white criminal street gang. It originated in Cobb County. They have common identifying signs such as 767 for GFG, Ghostface Gangster. There is a rapper who goes by the nickname Bam Bam. I cannot remember his government name off the top of my head because it's been a long time since I've investigated him. He was involved in a homicide with a hatchet. He's currently in Department of Corrections, but he frequently releases rap videos on Spotify and YouTube.
Have you ever had any gangs that you've investigated that you connected country music to?
gangs I've committed country music to. I can't honestly say that I have, no.
What about R&B music?
R&B, yes. So there is a R&B artist that goes by the name Jaquez. He's actually a member of YSL.
So as it pertains to any type of genre of music, the ones that you are familiar with prosecuting is either rap or R&B?
When you say no one's prosecuting music, I guess I don't understand.
Let me rephrase the question. The ones that you've been involved in investigating or testifying regarding making the connection to the gang using music as a form of part of the role that you would play in the gang have to do with rap music, correct?
When I have investigated a crime,
that would be.
Your question is very broad spectrum, so I'm trying to answer it properly.
Well, I just want to be careful if I'm not asking my question properly, because what I'm asking about is the genre of the music, not necessarily the broadness or the nationwide.
I don't investigate music genres. I investigate criminal street gangs and criminal street gang activity.
Okay. And based on your investigation of criminal street gang and criminal street gang activity, you've never had a case where country music was playing a role, right?
I don't believe so.
Okay. Now, there was a picture that was depicted this morning that you testified from where you stated that the sign that we saw where two fingers were being used in that picture is part of the identifiers that you use to determine that my client is involved in the YSL gang. You remember that testimony?
Before I answer this question, I just remembered I actually have investigated or been an assistant on an active investigation that involves a country artist, but not his music. So I don't know if that differs from the country genre, but the genre itself, since he does sing country, if that answers that. But it was a one time.
Okay, I moved on to another question.
I know. I apologize. I just recalled, and I just wanted to set the record straight on that.
Or twist it. No, I'm just kidding.
No, I did not want to twist. I just wanted to clarify because I mean, it's been a long time since I investigated that case.
Okay.
But could you ask your
So my question is about the signs that you said that are identifiers that you use, such as fingers and hand gestures, correct?
Okay.
And you testified this morning when you saw, it was shown to you by the state, a picture where there were hand signs in those photographs. You remember that?
Could you show me the picture?
We're having to be careful here because
You don't need to narrate, just pull up whatever slide you want to pull up.
Okay, so can you see this slide, sir?
I can't.
Okay. Now, can you see where the finger of the person you circled this morning as my client at the gas station in the center photo, the center one?
I can't.
First of all, that post is not from my client, correct?
No, this is posted from another individual that goes by the vanity names Slim Santana.
Okay. And this post, first of all, my client could not control unless he has Slim Santana's account and he goes in, logs in with his password and posts this picture, correct?
That's correct.
All right. And now looking at his pose in the picture, do you see where he has two fingers pointing at the camera?
So I see him holding up this identifying hand sign.
Okay. Now, have you ever seen individuals? You remember when, I guess I'm going to be aging myself. When you were younger, if you wanted to bomb somebody's photo, you would do like this behind their head in the photo. Do you remember that?
Like the bunny ears?
Like the bunny ears?
I have seen bunny ear
All right.
photos.
If I were, have you ever seen now recently too, where some people, in order to look fresh or to look young, when they're taking a picture, they might do both hands like this in the pose?
Yes.
All right. If I do this in my picture at a birthday party or something, it doesn't make me a member of YSL, right?
That is true. I'm looking at the totality. So This is not a YSL hand sign. I'm looking at this specific hand sign.
Okay, and if I did that specific hand sign, it still doesn't make me a member, right?
So that is actually, is this what you just did?
Whatever he's doing in that picture.
Pretend she's doing that. She didn't, but that's okay. Pretend she did that.
So if you were pretending to throw a YSL hand sign.
Yes.
And that is the only picture I've ever seen of you, and that's it.
Okay. What if you saw it and I was wearing a green bandana? Now I'm a member?
If I just see one picture of someone wearing a green bandana and just this, I would say those are strong identifiers, but I do not personally feel comfortable saying that individual is associated or a member of a criminal street gang.
Okay.
I like to look at it a little bit more than just one thing.
What if I did the finger, have on green, and I'm in the video? Does that make me a gang member?
No, it could, but once again, totality matters. There's a lot of different aspects that matters.
Okay.
But if it's just a one thing, the only thing that I've ever seen, I personally do not feel comfortable saying, just on this one day and at one time, this individual wore a green bandana and threw up a gang hand sign, because I don't know the context in this hypothetical. It could be you are a paid actor or shooting a movie in this music video. I truly don't know. So I'm looking at the totality of the aspect.
Now, as it pertains to what we're looking at depicted here that the state asked you about this morning, my client is wearing the same outfit in the slide in the center and the slide to the right, correct?
That appears to be so.
Okay. And it looks like it's the inside and outside of the same gas station, right?
It very well could be, but I do not know.
Okay. Did you investigate if it was the same day, a different day?
I don't even know what gas station it is.
Okay.
So no, I have no idea.
And context matters, right? Because if that's the same day, you wouldn't say, oh, there's two different occasions that I saw your client putting up signs, and because he's at more than one location, now he's a member of the gang.
No, I mean, I'm looking at the totality of aspects. So if I see several photos of the same individual wearing the same thing, throwing the same thing, even on different days, and with music videos, rapping about the same thing, I'm looking at the totality, not just one picture.
Okay, and the farthest one to the left is he's wearing the same outfit that you showed us in the other slide that we looked at earlier, correct?
That is correct.
Isn't it true that there are young people across Atlanta that are claiming to be members of gangs that they're not?
I'm sure it possibly exists. The reality is, though, when I have investigated crimes that involved individuals who are false claiming, it doesn't end well. Whether it's some type of extreme violence of a shooting or an assault of some sort, when it does happen. But does it happen? It does, and it can happen.
But it doesn't always happen, right?
I don't know.
Isn't it like trying to find out who's using your music? You literally almost have to hire somebody to make sure they're watching the internet to see if somebody's publishing it. Isn't it the same way as it pertains to if somebody is in high school and they're taking pictures or they're using our signs or they're wearing our colors? YSL is not going to high schools to look around to see, hey, is this kid pretending to be one of us?
So there's several YSL members who are juveniles and actually go to high school, and they're real members and commit real crimes. So if they encountered an individual who was falsely claiming to be YSL, yes, they would absolutely commit some type of violent act against them.
Okay, so let me ask my question again, because I must have confused you. Isn't it true, sir, that YSL is not going around to high schools throughout Atlanta, based on your knowledge of gangs and your expertise, looking for high school students that are falsely pretending to be members?
I must still be confused because there are YSL members who are in high school and who are actively seeing if someone is false claiming, and they will commit violence, and they have committed violence.
So you've answered her question. Next question.
All right, so as it pertains to music, music is an art, correct?
Yes.
And it's an art that I can use to express myself, correct?
That is true.
All right, and you testified this morning that some of the lyrics that we heard in the two videos that were played is an expression of, I will commit crimes as a gang member. You remember that?
Yes. Some of the lyrics specifically were talking about pistol whipping and robbing and selling of narcotics.
Okay, isn't it true that the majority of the theme, if you understood some of what they were saying, because some of it I did not understand, was talking about if you come for us, we'll come for you.
Yes, that's one of the aspects of in gang culture. If one gang has a rivalry with another criminal street gang, if one member is killed, there's a retaliation that occurs with that, and vice versa.
Okay, isn't it true that that is a sentiment even of families?
That is true. In domestic violence, that could happen as well.
And if I'm a mother and I say, if you come for my kid, I'm gonna hurt you. That's a normal saying, isn't it?
If that's what you're saying, that is what you're saying.
That wouldn't make me a member of a gang, right?
No, being a mom does not make you a member of a criminal street gang.
All right, so are you familiar with the artist Bob Marley?
Who?
I am familiar with
Bob Marley. You familiar with Bob Marley?
I am familiar with Bob Marley.
One of his famous songs were, I shot the sheriff, but I didn't shoot the deputy. Based on the standards that we're using now to determine who's a member of a gang or not, he would be arrested for that?
I don't believe Bob Marley is a member of a criminal street gang.
Okay, and that's based on what?
I don't have any evidence that Bob Marley is a member of a criminal street gang.
Okay, so you don't know that?
I have no evidence that Bob Marley is a member of a criminal street gang or ever formerly was.
Madam Mayor, I just have 1 second.
Yes, ma'am.
No further questions, Your Honor.
Turning to the accused, sir, do you have any questions for Investigator Miller?
How you doing today, Mr. Miller, correct?
Good afternoon. How are you doing?
I'm good. Can you just refresh my memory on how long you've been a gang expert?
As soon as the Honorable Judge McBurney qualified me as such.
Okay. Have you ever been in the gang?
I have never been a member of a criminal street gang.
Have you ever been harmed directly or indirectly by or threatened by any street gang?
Yes, so I have been shot and stabbed twice by a white criminal street gang member, a member of the Ghostface Gangsters. I have also been in physical altercations with several different criminal street gangs, such as Sex, Money, Murder, Neighborhood Rolling 60 Crips, Gangster Disciples, and several other criminal street gangs that while working in my law enforcement career.
So could these harmful interactions with these individuals, could that have caused a bias on your opinion towards people you consider to be in gangs?
I don't believe so. I'm looking at the totality of everything. that's just kind of part of the job. What happens at me as far as injury, I didn't take it personal. It happened. I have moved on. It's not my first time being shot or stabbed. So no, I don't have any bias opinion. And each and every single one was different gangs, different people, different races, different circumstances. So no.
Now, according to your ways to join a gang, do you have any evidence that I was ever jumped in YSL?
I do not.
Do you have any evidence that I was ever blessed in YSL?
I do not.
Do you have any evidence that I was ever sexed in YSL?
I do not.
So you know that I've joined YSL off of your assessment of the totality of what you have seen?
That is correct.
If LeBron James had a picture of him throwing up a YSL hand sign in one picture, another picture with him wearing the color lime green, and another picture supporting a friendly artist, let's say for this instance, Gunna, would he be a YSL member?
I would be looking at the totality, but I would not say LeBron James is a member of YSL based off any evidence that I have personally seen. But if he was supporting Sergio Kitchens, aka Gunna, who is a known individual of YSL, while also throwing the hand sign and wearing the same colors and was pictured with Sergio Kitchens, then yes, he could be associated with YSL based off of that information.
So that would definitely make him a member.
No, he could be associated if he was seen with Sergio Kitchens, Gunna, or someone else and doing those things. But I look at the totality aspect, not just one thing.
Okay. Now, you said that you are aware that there are individuals signed to YSL as artists and rappers and creatives.
That is true.
Can they be incorrectly identified as gang members?
Most of the rappers that are signed to Young Stoner Life are active members of Young Slime Life. They're commonly displayed in their social media and music videos. Some of them have been arrested for violent crimes or have been associated with violent crimes. But could they? Yes, there could be someone on there that I'm not familiar with that is not involved in criminal activity.
So it's possible that an artist signed to YSL can be mistakenly taken as a gang member of YSL. The possibility exists.
It's a possibility, but I would have to see that individual myself without, to actually say yes. It's just it's just a hypothetical that I'm not familiar with, as far as I haven't looked at that specific individual of a possible. I just don't know.
So you can be an associate of a gang and not a member, correct?
That's correct. So under the Gang Act 1615-4, you can be charged under the criminal street gang activity for being associated and not a member.
Okay. And what differentiates the two? Like, what's your main basis of what differentiates the two from an associate and a member?
So associate, associate could be someone that may be employed or is connected to the crime somehow, some way with the individual, another individual involved who is a member or also an associate of the gang. So as an example, if I have a defendant who I have no identifying signs that they're or any type of evidence that they are a member of a criminal street gang, but I have evidence that they committed a crime that directly or if they were even employed to commit a crime by the gang or a gang member who I do have identifying signs and evidence on, that could be an association of a criminal street gang that benefits the criminal street gang itself by not being a member.
Okay. And according to your assessment, have you ever seen me throw up the YSL sign?
No, I have not.
According to your assessment, have you ever seen me use any of the YSL verbiage?
I can't recall at this time now.
Okay. Okay. So your totality of your assessment of me being a gang member was based off 3 photos.
So I'm looking at the photos, specifically green bandanas, posing in photos with other individuals who are claiming to be YSL with hand signs such as this, and wiping the nose, other individual signs such as media captions on social media, you posing with individuals who are part of, in those photos specifically, as well as sharing information and communication with other individuals documented as membership with Young Slime Life.
So someone posing in 2 photos with a green bandana, that makes them a member of YSL?
Not necessarily, but the totality of it all. If you're sharing communications with an individual who is documented Young Slime Life, and you're also posing in pictures with individuals who are throwing up YSL in their known territory or around it, and posing with other individuals who are documented as such, yes.
Okay. According to your assessment, was there any physical evidence that I was at 1040 Wiley Street the night of that incident?
I have not reviewed that.
Okay.
Excuse me.
No further questions, sir.
Mr. Hiles, do you have any redirect, excuse me, for Investigator Miller?
Your Honor, is it okay if I said there's just gonna be some toggling back?
As long as Ms. Rivers can hear you, that's fine. I'll note you've got a trial partner who could help with the technical stuff, but if Ms. Rivers can hear you, it doesn't bother me. If you, probably lying down would be a little too much, but sitting down is okay.
Thank you. Just while we go through some of this Instagram stuff.
Okay.
Just for you, Ms. Rivers. Okay. All right. Through the course of this investigation, did you go through Mr. Robinson's phone?
I have.
Okay. And did you and I sit down and pull pictures that were on his phone and put them in a specific file?
We did.
Okay. And did we?
I would object to this line of questioning. I don't think council gets to open a whole new line of subject matters, and we didn't cover anything about council sitting down with this witness.
Okay, but we did cover a whole lot about how are you associating my client with the gang and who controlled the Instagram. It's a different registered user, et cetera. I see Mr. Howes right now traveling in that lane in a responsive way, but let's have a few more questions. And if you feel either it's novel territory, renew your objection. And if I agree, I'll sustain it. Or if it's repetitive of what's already happened, you can certainly make that objection.
Thank you.
You bet. Mr. Hiles, you may proceed.
Yeah, thank you. Okay. And were there other photographs outside of what was put in your PowerPoint presentation that demonstrated on different days Mr. Robinson posing with or other gang members or displaying the YSL signs himself?
Yes, there were several.
Okay. And would you say that there was, in the photographs we went through, several hundred photos, correct?
That is correct.
Okay. So I'm going to turn and the screenshots that were up there that said posts of Slim Santana, were those screenshots that were taken directly out of the phone that has been admitted as being recovered from Mr. Robinson?
That is also correct.
Okay. I'd like to go through some of those. And for the record, all of these photos are part of what's previously been admitted as no phone.
Are we dealing with Instagram?
No, we're dealing with
phone.
Phone. I'm sorry, State's Exhibit 36.
Okay.
Oh my goodness. No, I'm having a, no, the Zoom just logged out, but we'll be okay.
Can you narrate a little bit?
I'm sorry, the Zoom, I apologize. The Zoom logged me out when I tried to share it. So I'm just logged back in and yeah, we're going to do that. Huh?
So you listen to what he's saying.
Okay. All right. This was in your, but was this the screenshot inside of the Instagram dump? I mean, inside of the phone dump. I apologize.
This was in the phone dump.
Okay. And does this appear to be a photograph, or was this from the phone dump as well?
It was.
And does this appear to be of a different day than the other photographs that was discussed?
Yes.
And what does it say?
It says happy slap day.
Okay. And at the bottom, what does the @ say?
It's a vending name at 1100 block, or sorry, at 1100 baby slap.
Okay. Does this particular picture come from the phone dump?
Yes, it does.
Okay. And this was used earlier, so I'm going to skip that. All right. This particular screenshot, does that appear in the phone dump?
It does.
Okay. And does this appear to be a different day from all of the other, at least by the article of clothing that the individuals are wearing, different from the what we were the days we were discussing earlier?
It does.
Okay. Okay. Is this photograph from the phone dump?
It is.
Okay. Does it appear to be a different day based off of the clothing that he's wearing than all of the photographs that you used in your PowerPoint presentation?
Yes.
Okay, this particular photo, was that photo contained in his phone dump?
It was.
Okay, and did you also see this particular photograph in his Instagram dump?
I did.
Okay. Now, was this screenshot taken from Mr. Robinson's phone dump?
Yes, it was.
Okay, and what's the significance of all the people that are posted that are in this particular screenshot?
Let's stand up just to see.
You can. Tell me why. I'm confused why this won't work through Zoom. What error did you encounter?
I'm gonna, as soon as we're done with these photographs, I'm gonna go back to Zoom, but I think it will. It just kept, every time I tried to share the screen, it kept popping me off.
So some of the individuals depicted in this are documented young Slime Life members, such as Little Got It, Slime Life Shoddy. These are other YSL members. I think the only person who was actually signed to YSL Records or Stone Life Records is Little Got It, and I'm not sure if he actually is, maybe. But these individuals do create rap music. These individuals have also been involved in several different crimes to range from homicide investigations, shootings, burglary, various other offenses.
Okay. All right. This particular photo, was that photo contained inside of the phone dump?
It was.
Okay. And does that appear to be on a different day from all of the photos we've discussed earlier today?
It does.
Okay. And what is significant about this particular photograph?
The photo the defendant is seen observed throwing YSL hand sign.
Okay. This particular photograph, does that appear to be from a different day?
Yes, it does.
Okay. And what is the significance of this particular photograph?
The defendant is throwing up young Slime Life.
All right. I think I've made my point with these photographs. I do want to go, I want to show you, do one exercise here. We discussed the photograph, the one particular photograph that was present in Mr. Robinson's. Right now I'm sharing my screen. Is this the photograph that you identified as being present in both Mr. Robinson's phone dump, phone extraction, as well as links to his Instagram media?
I have observed both.
Okay. Now, when we go to, I'm going to go to what has been admitted as State's Exhibit 29, which is the Instagram return of Mr. Robinson. For this portion, I'm going to display on the HDMI. So when you go to linked media, and this particular post, I believe, has audio with it. Is that the same photograph that was just displayed as being extracted from Mr. Tyrone Robinson's phone extraction?
Yes, that was in the metadata.
Okay, so if I were to copy the numbers associated with that linked media.
You say numbers, what?
So the inside of the linked media, the video that was just displayed said videos, and then it is followed by number 217-19764-528-6462-3581.
Those are the numbers you're talking about.
Those are the numbers that I'm talking about. Those numbers are those unique to the video posted internally in the Instagram records.
That is correct.
So if I were to copy these numbers associated with that video and then go to Mr. Robinson's PDF, would it show me the time and date that it was posted?
It should.
Okay.
What is Mr. Robinson's PDF?
The PDF associated with Mr. Robinson's Instagrams that are contained in these records.
Okay.
Would it show the associated time?
It should.
Okay. Let's see if I can. I'll try to. Now that we're not toggling between them, I'll go. I'm now going to share the PDF associated with Mr. Robinson's Instagram. Now I have copied and pasted the number associated with the video in question and what date does it appear that particular linked media was shared on the Instagram account of Tyrone Robinson.
So this video was posted on November or 11/7/2019, and you can tell there's a story because it has a taken time and an expiration time. So Instagram stories is a live broadcasted story onto the account. And it has a 24-hour long access before it expires. So that is how I'm able to make that determination that it is a story. And it was posted at 15:16 UTC time.
Okay. And going back to some of the questions Ms. Manu asked you, I'm going to stop sharing my screen. Has the music industry in this particular genre of, I guess, trap music, has that proven to be an effective recruiting tool in your investigation of criminal street gangs?
I don't know if I would necessarily generalization it as a trap music. There's like a drill genre of rap that specifically talks about this lifestyle and targeting different rival gangs that is alluring to a lot of the youth, essentially.
Okay. And when you say you look at things in context, not just the signs or the colors, do you also look at who the individuals are that they are posting these pictures with?
I do.
Okay. And someone like Slim Santana, does he have a large following around the metro Atlanta area?
He does.
Okay. And if those pictures were to be posted in a sense of false flagging through his account, what would be the effects of that?
There would be severe repercussions.
Most of the time when you're investigating gangs, are you investigating somebody after they have been initiated into the gang one way or another?
Sometimes it happens. Sometimes I've worked some juvenile cases where I knew that when the individual was jumped in, maybe not initially, but going through a cell phone extraction, I may have gotten a jumped in video or something like that. Worked human trafficking cases where I have seen girls being sexed in, and then that proof or evidence of that initial act of obtaining membership into the gang was then sent to leadership. But there's not like necessarily a database of files that these gangs are typically keeping on record of when this person joined or jumped in. Sometimes there's ledgers. It really depends on the gang itself, but it is very uncommon. I would say it's a small percentage of when I know someone was beaten, blessed in, or sexed in, but it happens.
Okay. In that last video that was played, it was previously been identified as Mr. Robinson with the Song of Young Bands playing. Is it common for members of a gang to promote the music of other members or associates through their Instagram channel?
Yes, it is very common.
That's all the questions I have.
Ms. Mignot, any recross for Investigator Miller?
Okay, so counsel just asked you about photographs that he's alleging depicts different days that you saw Mr. Robinson using hand signs that you consider YSL signs, correct?
That is correct. I don't know exactly what date each one's posted, but most of the photos do have metadata containing each different photo, but based off the different outfits and the several pictures I've observed, I believe they're different photos or they're different days.
Now, there's a difference between when I post a photo and when I took a photo, correct?
That is true.
And you don't know the date the photo was actually taken, right?
Of what photo?
Any photo that you just looked at and said, yep, that's a different day. Yep, that's a different day.
It is contained in the metadata of each of those photos, and I can review each one, but I would have to look at each photo and go through the metadata.
Are you telling this jury that the metadata, based on what the state just showed you, is going to tell you the day the photograph was actually taken if it's a screenshot?
If it's a screenshot, no, it's going to depict the metadata of the captured screenshot date. The photo taken, it depends on how the photo was obtained.
Okay, so if we're looking at a screenshot from the alleged phone that is supposed to belong to Mr. Robinson, you can't tell us when the photo of Mr. Robinson was taken, right?
I can tell you based off of a screenshot photo, I can tell you when the screenshot was captured as a screenshot, not when the original of the photo that was screenshotted was taken.
We saw a photo with Mr. Robinson standing at a door, a front door, looks like a home. Did you remember seeing that one?
I do.
You don't know how old Mr. Robinson was in that photo, correct?
No, I do not.
And that photo could have been taken when he was in elementary school?
I don't believe so.
Could have been taken when he was in middle school?
I would not. He looks of. I have no idea how old he is, but he looks like an adult. Doesn't look like a 12-year-old. Doesn't look like a 15-year-old in that photo. So I would say he's in adulthood in that photo.
How would he have to look in that photo for you to think he's a kid?
That he didn't go through puberty.
Yes.
And I would say he would look prepubescent, maybe shorter, depending on height. Like a child. I have children, so I guess I would assume him to be the stature of a 12-year-old if he was 12.
And sometimes young Black children can be taller or look older than they usually are, correct?
I mean, children are created by God in several different ways. But yes, people can look older, people can look younger. But in those photos that I observed, he looks to be at least in his late teens to early adulthood.
Okay. Now, if I'm in a picture, let's say 1.5 billion times in my life with a Shriner, does that make me a Shriner?
Not necessarily. I don't think, to my knowledge, I don't believe females can be Shriners. But with other sororities, for context purposes, no. Just being in a photo 1.5 billion times does not necessarily make you are something.
So it doesn't matter how many times you look at a photo where Mr. Robinson is holding up his hand in a particular fashion that you think depicts a gang sign, that does not make him a gang member, correct?
Based on my opinion, if I'm seeing several different photos of the individual throwing up hand signs or other identifying signs, to include the hand sign of Young Slime Life, to include wearing a green bandana and posing with other individuals who are members of the same criminal street gang, that is what I look for. Not if it was one photo of the same exact photo 1.5 billion times or million times. That would not be my base, in my opinion. I'm looking at multiple aspects.
What if it's 1.5 billion different times? Would that still make him
If I
a gang
saw
member?
1.5 billion different photos of one individual throwing up Young Slime Life, I would absolutely think they are a member of Young Slime Life.
Okay, and what if you saw me, a female who you don't believe can belong to a Shriner, throwing up a Shriner sign or wearing something Shriner 1.5 billion times? Would you have that same opinion?
What Shriner sign are you seeing?
Any one of them, pick one.
I don't know.
But pretend she is throwing up that Shriner sign, or they wear the fezzes.
Mhm.
She's got the fez on, but she can't. But she's female.
Being a Shriner myself, I cannot say that I would believe that she would be a Shriner just based on the rules that I know. So I don't believe I would.
You said you're a Shriner.
I am.
If somebody in that group commits a crime, does that make you a gang member?
No, it makes the organization, the Shriners International, look terrible.
Is it because you're a member of it? You think it would make them look terrible instead of making them look like a gang?
No, because Shriners International doesn't make criminal street gang activity. We don't.
But there are Shriner members that have committed crimes, all right?
I finished my answer.
Oh, I apologize. I didn't realize you were still in it. Go ahead, sir.
I apologize. Yes, I was still talking. If a Shriner commits a crime, that organization, we look bad. And that's something that doesn't make us look good. No one wants to contribute to our organization and do the good things that we're doing. So yes, that would make it look extremely bad.
Now, you are currently employed by the Fulton County District Attorney's Office, correct?
I am employed by Fulton County.
And you're being paid by the Fulton County District Attorney's Office as you sit here, correct?
I am. I'm a salary employer.
Isn't it true that that's the reason why you are willing to look at a photo of Mr. Robinson, and despite him looking like a kid, you're biased, so you're going to make him look like an adult?
I don't believe I am biased. I regularly get contacted from several different agencies across the states including defense attorneys, to look at individuals. I have no problem talking to anyone about anything that they may see as a criminal street gang. I also interact with the community, teach at different community outreach events for pastors, or have troubled youth come and speak with me. I also have the parents of these troubled youths ask me questions. So there's no premeditated bias or any perceived bias that I believe exists.
Are you finished?
Yes, I am.
Okay. The PDF numbers and subscriber numbers and identifiers that opposing counsel just showed you a few seconds ago, if those belong to the subscriber of the phone, and the subscriber of the phone is not Mr. Robinson, you have no idea who used those screenshots, correct? Or who made those screenshots, correct?
I don't know.
You also don't know who created the name or typed in the vanity at 1100 Baby Slat, correct?
Whoever the account of 1100 Baby Slat was at the time managing that account and posting for that account is who made that caption.
And you don't have any evidence that it's this gentleman sitting right here, correct?
I have no idea.
Counsel asked you about a Instagram story that you testified was date posted 11/7/19 on Instagram at 15/16/23. Do you remember testifying about that?
I do.
You don't know who put that story up, do you, sir?
I do not.
Counsel asked you about rap music. I believe you talked about trap music. Do you remember that line of questioning?
Yes, I think most of the rap that is kind of being attributed.
She hasn't asked a question yet, other than, do you remember? That's okay.
Yes.
And I believe you said you're not an expert in music, correct?
No, I clarified that I think most of the music being portrayed by criminal street gangs today is typically drill music, which is a kind of different variation than trap.
But you're no music expert, right?
I have not been tendered in as an expert in music.
Now, you talked about false flagging based on someone who has lots of followings. Do you remember opposing counsel asking you about a rap artist having lots of followers?
Yes.
Isn't it true that most artists have lots of followers?
Depends on what you classify as artist and what genre, and if they're, I guess, popular.
Okay, so the only genre the Fulton County DA's office is focused on now is rap?
No, you just specifically stated artists. There's painters, orchestra. I mean, there's singers. There's several different types of art. So I don't know if they're like bird watching is specifically an art, but I can imagine that has crazy followers, but it could. So I don't know.
Okay, counsel also threw up a picture of a black male with a long gun in his hand. Did you see that?
There were several photos of different guns.
There's one where somebody was standing. It's the last photo he showed you where somebody was standing with holding a gun in their hand in the air.
Do you mind showing it to me again? I apologize.
I don't want to depict it again.
Okay. No,
So you don't recall who's that male in there, correct?
I don't remember.
Okay, and you can't say that that male's my client.
No, I can't.
Okay, nothing further, Judge.
Finally, any recross from the accused?
As an artist manager, if I'm doing business with individuals, I would call my clients and artists who you have assessed are gang members. And my job is to overly support my artists by by means of taking pics with them, joining in their music videos, and even going to their hometown to visit their friends.
I object. It's not a question.
I was
It's
getting
gonna
to the
get,
question.
I hear a question mark coming soon.
Might have been a long question, but I do want to start over just so you understand it.
Well, he got it. So you're the artist producer, you're in pictures, you go to the hometown.
Pictures, going to the hometown, even, being acquainted with their friends and getting to know their friends in their life. Could I, with that, just with that support that individual, as an artist manager can put out toward artists like that, could I be mistakenly indicated as being a gang member just because of my support, my overly support of an artist?
I'm sure someone can mistakenly identify someone who's not in a criminal street gang as a criminal street gang by being associated in that kind of capacity. And that is why I think it's so important to understand why it's not illegal to be in a criminal street gang. It is illegal to be in a criminal street gang and commit criminal street gang activity.
Okay. Everybody that you have assessed to be in YSL, just based off of your knowledge right now, could you find at least one piece of evidence of each of them throwing up any type of YSL hand signs and or using any type of YSL verbiage?
Yes, I have worked several YSL cases involving several YSL members, of them throwing up YSL hand signs, them saying the terminology. Yes.
And you have no evidence that you've ever seen me throw up a YSL sign, correct?
I have seen YSL signs such as a green bandana and posing with individuals who are displaying criminal street gang hand signs of Young Slime Life. Yes.
Have you ever seen me throw up the YSL hand sign or any other form of YSL hand sign?
I don't believe I have.
Have you ever seen me use any of the YSL verbiage or lingo?
I don't believe I have.
No further questions.
Questions from the jurors for Investigator Miller.
Yeah, they do. They've probably written them. Some of them had 3.
Thank you. All right, ladies and gentlemen, quick break for you. Jury room, hallway. No outside research. Don't talk about the case. See you shortly. All right, Mr. Hiles, come on up here. Please get these, share them with Ms. Mignot and Mr. Pritchett. Two more. You just swing right back here. Sorry, I just hadn't read them all. Go, thanks.
After Mr. Miller's jury questions, do you not want to brief restroom here?
So my thought is, if you're resting, I have to give everyone a break anyway. And so we'd start with a quick break because then we have a bunch of things to talk about. You wait till
No,
then?
that's my plan.
Okay.
That's my plan. I just.
Okay.
As long as I'm.
All right, Mr. Hiles, did you have any objections to any of the questions?
No, Your Honor.
Ms. Mignot
No, Your Honor.
and Mr. Pritchett? Okay, let's bring the jurors back in, work through these and wrap it up. Sorry, I'm not going to ask the one that says, why do you suppose, like, what's your theory behind? That's speculation.
Which one was that?
Why do you suppose gang members still use social media?
Okay, cool. I think he would have personal knowledge as to why they do use social media.
But that's not the question.
Oh, he can give.
You could, if you think it's proper follow-up, you can go there.
All right.
And can you please have ready the photo of Mr. Robinson with the green shirt with a smiley face and the gun in the waistband?
Yes.
I think it's actually the slide that has the three photos.
I'll have it ready.
Thank you.
All right, for the jury. Judge, the president of the county court.
Thank you, Deputy Gordon. You all can be seated. Investigator Miller, you were asked or discussed some young stoner life as opposed to young slime life, and referenced it being a music label or some type of business. Explain to the jurors how you could describe that. I don't remember your words. You can use your own. Legitimate business, credible business, if it is closely associated with something that you're describing as an illegal enterprise, as in Young Slime Life?
So, Young Stoner Life, it's a record label. They do produce music. That's legal. Essentially, the music videos that they're making, as long as there's no crime being committed or an album, that's legitimate. So if they take profits of that from Apple iTunes, from concert venues, that is essentially clean money. The criminal street gang will often may be involved in both, such as also making music, also profiting from music, but also selling narcotics or committing violent crimes.
Do you have a sense, or can you estimate how many of the photographs, images that were recovered from the cell phone extraction of the phone that the state is contending is associated with Mr. Robinson, how many of those were photos taken on that phone, as in I hold up the phone and press the button and it's a selfie, or it's us, the jury, versus screenshots of, oh, I'm surfing the internet and that's a cool picture, I'm gonna grab that picture. I didn't take it, but it's found on my phone.
I can't give like an accurate percentage, but most of
Then we would object to speculation.
Okay, so if you, how about this? Sustained, objecting to my question. Were there both on the device?
There are both.
Okay. Mr. Hiles, if you'll put up the image or images we discussed during the break, please. And this should be on your screen. You shouldn't have to crane on the other screen.
Thank you.
So the question is about the firearm that is in the waistband of the person you identified as Mr. Robinson. One, can you tell simply from looking at the photo if that is a real firearm? And then two, regardless, real or not, would you characterize that as a mini AK or a mini assault rifle type gun?
Based on these pictures, I can't tell if that's a prop AK variant type firearm or a real one. It does resemble a AK variant, what commonly referred to as a Draco, a small AK rifle. These firearms are commonly chambered in 7.62.
Explain to the jurors how someone becomes what you've referred to as a documented member of a gang.
So it depends on the individual. I'm looking for, once again, several different identifying signs. So I'm looking for, is this individual throwing up hand signs? Have they given a self-admission, whether it's in an interview room or on the streets? If another individual, another member says that this person is a member, or like another person is a member, or another member, if they identify leadership, if they deny any of it and we find evidence and say their cell phone or their Instagram records, or sometimes we do search warrants and we obtain gang writings in their house or their room, children, sometimes book bags and like note writing and stuff like that. Some gang members also tattoo themselves. So there's several different identifiers that I look for, but I'm never just looking for one. Not necessarily even looking for two. I'm just looking at everything that I have collectively. Do I personally feel comfortable saying that this person is a member of a criminal street gang, or are they associated? An associate, I'm not really looking for if that individual is throwing up certain symbols or something. I'm looking for it, but if I don't see it and it's not apparent, but they are committing crimes with individuals who are documented, then I feel comfortable saying that they're associated. Then we have different law enforcement softwares throughout the states. We have a GBI gang database, which is typically more for documentation of security threat group members, also known as members in Department of Corrections who are validated members. So that would be one form of documentation. Another documentation would be like a gang profile. So different images, pictures, or reasons why that gang investigator would think that this person is a gang member. Those are the classifications of documentations.
From your knowledge and experience, what would you estimate the size of the YSL street gang to be? Size meaning number of members.
It's a lot. I would definitely estimate it in excess of 20 members for sure.
How many members of YSL have you interacted with in your professional capacity?
Well over 20. That's why I can say over 20.
You referenced a couple times someone known as Young Bands. Is Young Bands, do you believe him from your experience to be a member of YSL? And if so, is he a documented member of YSL?
I personally haven't documented Young Bands, and I personally haven't done a criminal investigation independently into Young Bands. But I have seen documentation of Young Bands being associated at a minimum with Young Slime Life.
Mr. Hiles, do you have any questions for Investigator Miller based on that exchange?
Yes. We talked about AK, mini AKs being Draco or chambered in 7.62. Are those guns that are popular on the streets of Atlanta with gang members?
Yes.
What about YSL?
Yes.
Okay. And as it pertains to the Street Gang Terrorism and Prevention Act, does it matter if somebody is documented as an associate or a member if they are committing crimes in furtherance of that gang?
No, it can be either or. It can also be employed by.
Okay. And we talked a lot about what was pulled off of social media. Why is it that gang members are still using social media when it's being pulled as evidence against them?
Well, what we often see is sometimes they will remove social media from an account. Sometimes they will go, if they think they're being watched or investigated, their account can be changed to privates, or we'll see that they erase things. In my experience with investigating criminal street gangs and social media, we have to typically get a preservation request submitted into Instagram or Facebook or any of the social media accounts fairly quickly, because once an individual thinks that we are investigating for their crime, that's when they start wiping everything and things are getting deleted. The preface of that, if they are before they commit crimes or even after, some members don't. Sometimes they brag about it on social media. Sometimes they're trying to gain even more notoriety in their criminal street gang. And I've worked investigations where individuals are calling out specific individuals of rival gangs of who they're going to target, and then broadcasting it for everybody to see, not privately.
I would object, the witness is not responsive.
Do you want to focus the answer, or do you think your question has been answered and you're ready to move on?
I think my question has been answered.
Okay,
And
next question, if any.
no other questions.
Ms. Mignot, do you have any follow-up?
Yes, Your Honor. As it pertains to
the question about the phone, Instagram records, children noting, writing, tattoos. In this situation, you are using this photograph of our client and the music video to determine that he is a member of YSL, correct?
I'm using several photos and identifying signs. So I'm looking at the totality to include music videos.
Okay, so let me re-ask my question a different way. Despite the number of photos you're using, the two identifiers you're using are photos and a music video you found on YouTube, correct?
No, my identifying signs that I'm looking for to make my assessment have been hand signs, various hand signs, the wearing of bandanas, posting and sharing with individuals that have been documented with YSL, as well as posing and shooting music videos in known YSL territory and promoting the YSL criminal street gang.
Okay, so this picture with my client in the hand sign, check one, right?
So there is one hand sign right here where he is throwing up for YSL while also wearing a green bandana and standing next to individuals who are armed with suspected firearms, throwing up hand signs of YSL. That's several identifiers. That's not just one, that's multiple.
Okay. Counsel, could you cue guns up, please?
Yes, I gotta get it from up here.
If you'd like me to.
States 39. We're gonna show you states 39 just as soon as we get it up and running.
Okay. Are we playing the whole thing or there's
No.
part of it that you,
Only a small portion, Your Honor.
okay. And that's HDMI land.
It is.
Guns up is what you wanted? Okay.
Guns up, fucking guns up, everybody's fucking guns up, guns up, fucking guns.
Okay, I've just paused the guns up video. Can you see what Mr. Robinson is wearing in that video?
Okay.
Okay, and he's wearing the same bandana in the exact same spot that you have him in the picture that was depicted in a still shot on the screen, correct?
That is correct.
All right, he also is wearing the same shirt.
That is correct.
Okay. Just one moment.
Guns up, fucking guns up, yeah, guns up. Fucking with these things, you be crazy.
I know you're
There. Okay. Do you see my client on the back of a pickup truck up in that video?
Okay.
Okay. He's wearing the exact same outfit that you have in the still shots that you said you weren't certain if they were from the same day, right?
That is correct.
Okay. Can you tell now from looking at the video that he was wearing the exact same outfit and that the pictures that you have in the still shots are just different angles of him from this video?
Yes, I agree with that. Earlier, I just stated that I did not personally crop photos from YouTube and post them on the PDF file.
Okay, so somebody else cropped these pictures that we were looking at for you?
No, there's your pictures and then there's a video. You asked me if I had made any type of clippings from the YouTube video, which I did not. I located those photos in the phone and those were uploaded into a PDF. Those aren't clippings, those are photos. So a clipping is like a snag it or a clip it aspect. I didn't take any clippings from the YouTube video as far as I only did a video recording.
Okay, so if the pictures that is depicted in what we were just looking at is the exact same day of this event and someone was just taking screenshots of it, you would count that as one encounter, right? One gang member affiliation encounter?
No, I saw several identifying signs in this video. There were several
But the
individuals.
event, if you ended up with 5 still photos on a phone, on Instagram, that were all taken from the event of filming this video, and there may be 97 different identifiers in there, but that is one event. Do you agree? One day, one part of a day.
If I saw multiple identifying signs from one day, yes, I would feel comfortable identifying someone as being associated, a member, or depending on the identifying signs that I saw.
All right, so let's talk about the evidence in this case. Thank you so much, counsel, I appreciate it. The evidence in this case that you are looking at, based on what this juror has already been presented, is the exact same clothing on the exact same day with numerous identifiers, as you would say, correct?
They've also been shown several other photos from different days of different identifying signs of membership of Young Slime Life.
Okay, so let me go back to my original question. Photographs you use, correct? Photographs you
I
use.
have used photos.
In this case, as an identifier for my client as a YSL member, correct?
I have reviewed photos of him displaying identifying signs of Young Slime Life.
Okay.
Yes.
And you used photos and you used video, the rap music video, correct?
Yes, I reviewed music videos of him displaying identifying signs of Young Slime Life.
And based on the video and the photos, you have determined that our client is a member of the YSL gang, correct?
Yes, along with other evidence.
Nothing further, sir.
Any questions from the accused based on the questions I posed to Investigator Miller?
Yes, ma'am.
Do you have any evidence of pictures or videos of me ever holding a gun?
I don't believe so.
What are the colors of YSL? Is it one color or is it many colors?
So they'll commonly use other colors as well, but primarily for specifically YSL, it's green. However, if a member is sex, money, murder, and also a member of YSL, they may utilize red and green. Whereas a member who is a neighborhood rolling 60 Crip, for example, their primary national affiliation would be blue, so they could use blue and green. But green is the specific identifying color for Young Slime Life.
So it could be green, red, or blue?
Yes, depending on the individual.
Based on what you said your indicators were, I could be mistakenly indicated as a gang member just by on 1 or 2 occasions hanging out with other people who are indicated as gang members?
It depends on the circumstances, but it really just depends on the circumstances. If you're just hanging out with individuals who are, I don't know, your family members, not necessarily getting documented by law enforcement. However, if you're stopped as a suspicious person and there's drugs or something, maybe you don't get arrested, but someone else was arrested for something, that could be a scenario where someone kind of documents something or starts documenting something. But what that individual investigator does to identify that individual is not me. So I don't know. It would have to be what I saw and what I documented.
So the indicators that you saw and documented to assess me as a gang member were picture of me holding up green flag. Another indicator that you saw or was pictured was me being in the supposed territory of this gang. Picture that you also do not know the context of. And the other indicator was, I believe you said that I was associated or in communication with other supposed gang members. And if we take that assessment with the lack of evidence of me ever throwing up any of the gang signs, and the lack of evidence of me ever using the YSL verbiage, don't you think your assessment of me being a gang member is greatly weak compared to your other assessments?
No, I think it's very strong based on the holding up a green bandana with other individuals who are throwing up Young Slime Life, who are on the territory, who are commenting or posting the same terminology. I think that's very strong gang evidence.
Even knowing that I never threw up those gang signs or used that gang verbiage.
Yes, because I look at it as acceptance. So if I'm with a criminal street gang and I'm a member of a criminal street gang and I'm with criminal street gang members and they're posting and saying something and I'm doing the same thing with them, but I didn't say anything, that is an acceptance, an accepted admittance, so to speak. So if they're accepting the same, what is being broadcasted on social media or video.
So that's acceptance and not just support. If I'm a manager and supporting an artist.
Don't interrupt him.
Yes, I would agree with you. That is supporting
that person as an artist, not what they're doing or saying, but supporting them as an individual creative artist.
Yes, I would think that would be supporting as both.
Okay. No further questions.
Thank you, Investigator Miller.
Thank you, Your Honor.
You can step down. Mr. Hiles, next witness.
Your Honor, the state rests.
All right, ladies and gentlemen, it is time for a break for you all. As I forecast, when the state rests, there are a number of matters I need to take up with the state, with counsel for Mr. Robinson, with the accused. It's going to take a few minutes, so be at ease, and I will bring you back out here as soon as we are able to continue and see if Ms. Mignot is going to present any evidence on behalf of Mr. Robinson, which she has no obligation to do, and see if the accused is going to present any evidence on his behalf, which he has no obligation to do. The fact that the state rested does not mean that it's time to begin your deliberations. There may be more evidence presented, there may not, but that still doesn't mean it's time to begin your deliberations. We have closing arguments and the charge I need to give you at the end of the closing arguments. So no outside research, don't talk about the case. We'll get you back here as soon as we can.
All right, let's do it.
All right, Mr. Hiles, how much time do you need on this break before we can talk about what we need to talk about?
Just 3 or 4 minutes.
Okay. Ms. Rivers, if we take, I can't remember if you got a break the last time we took a break. We didn't. All right. Let's be back here at 3:50 to, on your phone time to talk about what's next.
Can I set my timer for 20 minutes, Your Honor?
3:50, 3:50. That can't be 20 minutes from now.
Is that 15?
That's 10 at the most.
All right, so I'll set it for 10. I will not be late.
Set it for 9. Okay. I don't know the math you're doing.
because you have a duty under the law of Lavertu versus state. And it says the trial court has a duty to grant the motion if there is no conflict in the evidence.
But you created a conflict in the evidence by impeaching them, but it's not my role to say your impeachment was so effective that these witnesses are entirely unbelievable. And it wasn't. I'm going to find if the jury convicts that there was a basis for them to do that because you did impeach them, but I don't believe that those two witnesses are completely without credit. So the jurors are free to consider that testimony with all its contradictions, internal and imposed through your impeachment. Lavertu, no case in the annals of history of Georgia appellate law says because the defense attorney says, hey, I impeached this witness, I have a duty to say, oh, okay, then I need to grant a directed verdict.
No, because that would be a mischaracterization of my statement. My statement is you are authorized by law to grant the motion for directed verdict if there's no conflict in the evidence. In terms of count one requires that make an unauthorized entry into a legally occupied dwelling. There's no evidence before this court that Mr. Robinson made an authorized entry. And the reason is no one said they saw them go in. No one said they saw them come out. And that's Riley and Kallish's testimony. And I went over it ad nauseum.
That's accurate. So you're ignoring circumstantial evidence. And that's what's going to trip you up, at least on your motion for directed verdict. You may be able to convince the jurors that the fact that no one saw it happen means he didn't do it. But there is ample, let me put it this way, there is more than enough circumstantial evidence connecting your client to the home invasion and armed robberies and aggravated assaults and possession of a firearm during the commission of a felony circumstantially. He's put in the car by Riley and Kallish. He's back in the car when they're in it. They, Pritchett and Robinson, have stuff they didn't have before. And we know some of it belonged to the people who were in the house. So it's not direct evidence, but it's circumstantial evidence. And I'll be telling the jury that they need not concern themselves whether direct or circumstantial as long as they don't have reasonable doubt about what happened. I don't know if they're going to have a reasonable doubt. That's not the test right now. If there's no conflict in the evidence and the evidence as it stands demands a verdict of acquittal, it's not that I'm authorized. Like you said, I have a duty. I must direct a verdict as of that count. And that's true for one of the aggravated batteries, but it's not true for the home invasion because impeached testimony doesn't mean discredited by the jury testimony. Otherwise, the moment someone impeached a witness, like, okay, we're done. I guess the state loses on this one because they didn't have an unimpeachable witness. That would be curtains for almost every state prosecution.
It wouldn't be that, Judge, because in those circumstances, the state usually will have circumstantial evidence to substantiate the claims of the co-defendant, such as we found fingerprints. We checked the cell phone towers and we found the cell phone tower placed the person at the scene. That is not the evidence that is before this court. So we don't have any cell tower placing our client at Wiley Street, the location where that was. We have testimony that neither person, not Riley, and I'm only speaking of Riley because we already passed whether the victims can identify anybody or not, because that's clear. Neither Riley nor Kallish said that my client made an unauthorized entry into the property. In fact, I believe Kallish's testimony was, I don't even know if it was Rick Rare or Baby Slat that made entry into the property. And that is her testimony in court, not in her first interrogation, not in her second interrogation. So I don't know what circumstantial evidence the court is using or referencing when the court is saying that element number one is met by the unauthorized entry into a legally.
Two people made an unauthorized entrance into that house. Do you agree with that? Or you think that there is no evidence, there's no conflict in the evidence that two people wearing masks and having guns made an unauthorized entrance into that house?
No, I'm not arguing that. That's what the victim said. Right. So if we bring the victims back into this case, then the answer is yes. The two.
Right. You can't exclude some part for your argument and then bring it back in. What has been, I think, established very clearly is that there were two armed, masked gunmen. No one said it was a woman, and people have explored.
One did. Hooper, go back and look at it, Judge.
Then there's a conflict in the evidence. Keep in mind the standard. There's a conflict in the evidence. I don't think Cooper said it was armed, masked women, but if he did, That's just conflict in the evidence. There's evidence that 2 armed masked gunmen went in the house. There are 4 people in the Mercedes, then there's no one in the Mercedes, then the Riley's in the Mercedes, and then she said, who ran in? She didn't say the people who ran back into the Mercedes are people I didn't know. She said the people who got back in my car were Rick Rare and Baby Slap. So it could have been that they went to a Wendy's to get food, but that's not what the record establishes.
So I just wanted to be clear for the record that the court believes that there is circumstantial evidence that unauthorized entry was made into 1040 Wiley Street by my client on November the 8th of 2019.
Correct.
Okay. And can the court say what that?
Not my job.
Okay. Okay. The second issue is with the intent to commit a forcible felony therein. I do not believe that there's any evidence before this court that my client, 1, entered, or 2, intended to commit any forcible felony therein. In fact, we don't even know if there are more than just the 2 females in the car as we stand here today.
The only way you wouldn't know that is if you're choosing not to credit their testimony, and you're free to not credit their testimony, but their testimony was 4 people in the car, your client, Mr. Pritchett, and the 2 females.
Right, but we cannot discount their interrogation where they said they were the only 2 people in the car. But if the court is saying that's a conflict, we'll make the argument. We can understand the court is not.
How is it not a conflict?
All right, so may I proceed, Judge?
Yes, please.
I don't want to waste the court's time, and it's clear we're not going anywhere with count 1. As it pertains to count 2 of the indictment, the record is void of any evidence of Mr. Robinson, once again, entering the Wiley Street property. Count 2 is armed robbery as it pertains to Holden Carmody and a wallet. Mr. Carmody testified that he doesn't know who took his wallet. There was no testimony from Ms. Riley or Ms. Kallish, if we focus on just those 2 individuals, that Mr. Robinson was in possession of Mr. Holden Carmody's wallet. As it pertains to count 3, the robbery was regarding Christian Hooper's wallet. According to the indictment, neither Kallish nor Riley testified that Mr. Robinson took a wallet from the person of Mr. Christian Hooper, and we submit to this court that directed verdict is warranted under that count. As to count 4, this is armed robbery for Noah Walker cell phone. Mr. Robinson was not found with a cell phone. There was no testimony that he took a cell phone from either Ms. Riley or Ms. Kallish. As to count 5, armed robbery, Rebecca Mears' cell phone. There was no testimony that Mr. Robinson took a cellular phone for Ms. Mears, or from the person of Ms. Mears, or from the immediate presence of Ms. Mears. Directed verdict is warranted on that count. As to count 6, Jackson Buckingham, his shoes. There was no testimony that Mr. Robinson took from the person of Mr. Jackson Heil. I think he's Jackson Buckingham Heil, Your Honor. He's listed as Buckingham in the indictment. He testified he's Jackson Heil. So there's a conflict in the indictment. We'd ask for directed verdict on that count. As it pertains to armed robbery, Vikyat Gatani, a wallet and a cell phone is what the state alleged that was taken. And we submit to the court that there was no testimony that Mr. Robinson took, not from Ms. Riley nor Ms. Kallish, a wallet from Mr. Gatani or a cell phone from Mr. Gatani. There, count 8, Christian Riggs, a laptop, computer, keys, and wallet is what the indictment states. There's been no evidence in the record or from Ms. Kallish or Ms. Riley that a laptop computer was taken by Mr. Robinson from the person of Mr. Riggs, or that keys of Mr. Riggs were taken, or that a wallet was taken. As it pertains to count 9, aggravated assault with a deadly weapon, there is no evidence before this court that this is a count regarding Mr. Holden Carmody. There's no testimony or no evidence in the record that shows that Mr. Robinson assaulted Mr. Carmody with a weapon or pointed a weapon towards Mr. Carmody. Not testimony by Ms. Kallish nor Ms. Riley. As it pertains to counts 10, aggravated assault with deadly weapon, that is against Noah Walker. In fact, I believe Mr. Walker was the person who said that he passed out in the middle of the events, and he had Asian glow, first time I've ever heard the term, and that he was out of it. He doesn't know what happened that evening, and there's been no evidence to submit that Mr. Robinson, with the intent to commit an assault upon Mr. Noah, pointed a gun towards Mr. Noah during the robbery that took place November 8th, 2019. As it pertains to count 11, the aggravated assault with a deadly weapon was regarding Miss Rebecca Mears. Ms. Mears testified she doesn't know Ms. Kallish nor Ms. Riley either testified that they saw Mr. Robinson pointing a weapon at Ms. Mears. So we're asking for directed verdict on that count. As it pertains to count 12. I apologize. Yes, count 12. Aggravated assault with deadly weapon as to Mr. Jackson Buckingham's, known in the record as Jackson Heil. The indictment states that Mr. Robinson pointed a gun towards Mr. Jackson Buckingham. That did not occur. We're seeking directed verdict. There's no testimony in the record that Mr. Robinson was involved in an aggravated assault as it pertains to Mr. Jackson Buckingham. Count 13, aggravated assault with deadly weapon, Mr. Vikyat Gatani. We submit to the court that there's no evidence in the record and there's no conflict in any of the evidence that would support that my client, Mr. Robinson, pointed a gun towards the direction of Mr. Vikyat Gatani. Therefore, we're seeking directed verdict on that count. On counts 14, aggravated assault with a deadly weapon as it pertains to Christian Riggs. We submit to the court that there's no evidence in the record to support that our client, Mr. Robinson, pointed a gun towards the direction of Mr. Christian Riggs. As it pertains to counts 15, aggravated assault with a deadly weapon regarding Mr. Christian Hooper. We submit that there's no evidence in the record to support that our client, Mr. Robinson, pointed a gun towards or in the direction of Mr. Hooper on November 8th, 2019, as charged in the indictment. As to counts 16, aggravated battery as it pertains to Vikyat Gatani, we submit to the court that there is no evidence to support that our client, Mr. Robinson, fractured the skull, causing permanent scarring on the head of Mr. Gatani. No testimony from Riley or Kallish as to any of these counts, 1 through 16. Aggravated battery, Christian Riggs, count 17. We submit that there was seriously disfiguring of.
I'm going to save you on 17. I'm going to be granting a directed verdict on 17 because Mr. Riggs said my nose might have bled slightly into the story. And it's one of the models. He will let us know if his nose had been disfigured. So the state has failed to prove an essential element, which is serious disfigurement. Has nothing to do with who did it. So we're clear. It didn't happen. So 17, I will be directing a verdict on.
Thank you, Your Honor. As to counts 18, we have participation in criminal street gang activity. We submit that the law, let me go into the law. 1615.3.3 states that a criminal street gang means any organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal gang activity as defined in paragraph 1 of the code section. The state charged OCGA 1615.4a, it shall be unlawful for any person employed by or associated with a criminal street gang to conduct or participate in criminal gang activity through the commission of any offense enumerated in paragraph 1. So when we're talking about to establish the violation of a Street Gang Terrorism or Prevention Act, the state must show count 1, element 1, the existence of a criminal street gang as defined by statute. They must also show that the defendant's association with the gang. They must show that the defendant committed any of several enumerated criminal offenses, including those involving violence, possession of a weapon, or use of a weapon, and 4, that the crime was intended to further the interest of the gang. There's been not even a scintilla of evidence, 1, that Mr. Robinson was furthering the intent or the interest of any gang. As it pertains to the definition of a criminal street gang, based on this witness that we had this morning, he is claiming that our client is a member of the YSL gang based on several different clips of the exact same guns up video.
But isn't that a question about the sufficiency of the evidence. I mean, I don't know who has ever taken the stand to say Mr. Robinson is not a member of YSL. There are people who have said that. It may not be particularly compelling. It may be far from reasonable doubt, but remember the test you enunciated at the beginning. If there is no conflict in the evidence and there's no evidence supporting X, but there is evidence, there's an expert testifying based on these different things, I feel like he's a member. That may not be compelling to you. More importantly, it may not be compelling to the jurors, but that's different from what you've been able to say about the crimes that occurred inside the house, where you accurately say, no one can say they saw my client inside the house. The jurors have seen your client with the bandana, with guns, associated with other supposed members, holding up supposed signs. It may be that the expert's not deemed to be very credible, but this is in some ways the opposite of the good argument you were making with all those other counts, where the state's not going to be able to say, oh, wait, Judge, you forgot about witness X, who said, no, I saw Mr. Robinson in Wiley Street, or his phone was there. None of that happened. But we got to see even more pictures of your client doing alleged gang signs, flashing this and that on sort of the redirect of the investigator, because you pressed him that that's really not a lot of pictures you're talking about. So I just said a lot. But again, if the test is no evidence and there are no conflicts in the evidence, it's sort of the reverse. The only evidence in the case so far is an opinion of an expert that your client is associated or is a member of the gang.
And as it pertains to the fourth element of that, Your Honor, the state has to prove all the elements. They're not allowed to prove the first three.
Right.
So now we're at the
nexus,
the intent to further the interest of the gang. And we don't have that here. In fact, the evidence before the court is that the whole robbery, according to the testimony of Kallish, was a design by Riley. And that Riley said, hey, let's go rob these people. And according to the evidence, the state is not alleging that they're members of the YSL gang. So we would submit that the state has failed to meet at least element number 4 as it pertains to count 18 of the indictment. Possession of a firearm during the commission of a felony, count 19. According to the state's indictment, it states that my client engaged in assaulting with assault style pistol, a firearm during the commission. Your Honor, we've had so many descriptions of a weapon in this case that the state has failed to even meet the burden of saying what type of weapon was used in this case. And as it pertains to the alleged victim in that count, it's Mr. Riggs that our client is supposed to be alleged to have committed the crime against. Based on the fact that the state cannot, one, identify the particular weapon, and there was several times that the state attempted to try to have one of the alleged witnesses testify, or alleged victims testified that they could recognize a weapon, but now we have weapons all over the place. So we submit to the court that the state has failed to meet its burden as it pertains to our client on count 19, and directed verdict is warranted pursuant to the law. As it pertains, Your Honor, to count 20, we didn't go into that because count 20, although in the exact same indictment with our client's name on it, is not applicable to our client, but I just wanted the record to be clear as to why I'm not addressing count 20, because count 20 doesn't apply to our client. So if the court wants to grant a directed verdict on something that's not applicable to our client, we move for it.
You're not going to oppose it?
I won't oppose it, Judge.
Okay, thank you. All right, Mr. Pritchett, you got to hear actually a very thorough and accurate description of what a motion for directed verdict is and the standard that I have to apply in the introductory comments that Ms. Mignot made. So I'm not going to need to explain to you what it is. You're free to make one as well if you want to argue for a directed verdict as to one or more of the counts that names you. You don't have to, but if you want to, now's the time. But I'd ask you to come to the podium so that Ms. Rivers can hear you through the microphone, please.
Yes, I would like to move this court for a directed verdict of acquittal on counts 1 through 20, excluding 17, which you already said would be ruled upon. I guess to go into detail, count 1, home invasion in the first degree. The state has not proven beyond a reasonable doubt.
So
All the
I'm gonna try not to interrupt you. I did a bad job of staying out of Ms. Mignot's way while she was arguing. I apologize to her, but the standard right now is not proved beyond a reasonable doubt. It's actually an exceedingly low standard for the case. My finding isn't you've proven your case. My finding is you haven't done so poorly that it would be unfair to let the case go to the jury. That's how you win, would be by convincing me that it would be a miscarriage of justice to let the jury even deliberate on this, because it's so clear from the evidence that the state has failed. So it's a low burden for the state, a high burden from you, because it's an unorthodox request. It's to say, don't let the jury decide this. The whole point of giving you and Mr. Robinson a jury trial is to let the jury decide and not me. But sometimes I got to step in. So back to count 1.
Yes, and it is believed by me that it would be a failure of this court to allow the jury to deliberate on this count, because more than one element of this crime has not been sufficiently proven by the state. There is a complete lack of evidence that
I'm gonna interrupt you again, just because I'm gonna let you flesh out all these counts, but let me tell you what I find. I find that the state has proven every single element of the home invasion, where the challenge is who did it. I think that there is uncontroverted evidence that 2 people entered the residence of another person without authority, clearly with the intent to commit a felony because they beat some people up and took stuff. And that residence was occupied by people who were authorized to be there. They weren't squatters. The state's proven all that. Every victim in this case has said that's what went down. The big question is, well, who did it? And so we talk about alleged victims. These are all victims. They may not be your victims. They may not be Mr. Robinson's, but I'm gonna let you know right now, you're not going to convince me that the question of was there a home invasion shouldn't go to the jury, unless you can convince me right now that there is no evidence that connects you to that home invasion. Because that's really what you're going to be arguing, as to all the armed robberies and the aggravated assaults, because every victim said these guys had guns and they pointed it at us. There's your ag assaults. Every victim said I had stuff taken from me at gunpoint, and that's all listed there. So all those things happened. I believe they've been proven. Where there's going to be some fighting in front of the jury during closing arguments is, did the state come close to proving, did they meet their burden, that it was Robinson and Pritchett? So focus on the lack of evidence that you were one of those 2 people. Does that make sense?
Yes.
Because if you focus on, well, I don't know that they didn't have authority, that we're not getting anywhere.
Okay. Well, to continue, yes, it is believed that the count of home invasion has not been sufficiently supplied or backed by any evidence to which I committed such act. The evidence has not proven or in any way stated that I committed the act, down from the testimonies of the victims and the testimonies of the co-defendants. There was no consistent or any basis to say that I was the one that committed this home invasion. We can even, assess the narrative from Officer Wright that briefly describes the 2 assailants that committed that home invasion. one being slim built and of light complexion, and the other being heavy built of dark complexion. I fit neither one of those descriptions. And again, I would ask this court to direct verdict on that account of acquittal on count one. On count two.
If you're comfortable doing it, I'd ask you to lump all the armed robberies together, because I'm guessing you're gonna have the same. If you've got something unique to count 6, let's talk about it. But if it's the same argument as to counts 2 through 8, those are all the armed robberies, share with me why you think I should direct a verdict as to all of them. Because I think they move as a block. Either they're all going to the jury or none of them is.
To lump them all together, yes, I do find that the court should direct verdict of acquittal on counts 2 through 16, 2 through what it was.
So 2 through 15 is the armed robberies and the ag assaults.
You said 2 through 8, correct?
Those are the armed robberies.
2 through 8, which are the armed robberies. And I find that this acquittal should be established by this court because there is a complete lack of evidence that connects and shows that I was one of the individuals that committed this armed robbery. There has been no evidence to prove that, according to count 2, that I was the one that had an intent to commit theft or take the wallet and property of Holden and Carmody. According to count 3, there is no evidence to prove that
for each of the counts, you're saying there's a lack of evidence showing you had the intent to take that which was allegedly taken. Okay.
That proves lack of intent and or that I was the one that actually robbed the stolen items.
Okay.
And again, to support that acquittal, it goes back to just the description of the alleged assailants. Neither one do I fit. On count 9, which is aggravated assault with a deadly weapon.
And let's do the same with the aggravated assault. So 9 through 15 are sort of carbon copy counts, just replace the name of the victim.
So I would ask that the court, yes, do move in good faith a directed verdict of acquittal on counts 9 through 15, being that there is no evidence to support that I unlawfully committed an assault on any of the victims in each count. There is no evidence to prove that I holstered a firearm that day or that night or at any point in time. And moving on to count 16. Which is aggravated battery. I would, in good faith, ask the court to move on a directed verdict of acquittal on count 16 because there is a complete lack of evidence proving that on the 8th day of November that I was at 1040 Wiley Street where this incident occurred and that I did maliciously cause bodily harm to Gatani by fracturing his skull. There is no evidence that I committed such act. Skip 17. On count 18, I would move the court again in good faith for a directed verdict of acquittal on the count 18, which is participation in criminal street gang activity. Being that the testimony from the expert witness, the supposed expert witness by this court, did not sufficiently indicate that I was part of a gang. He showed 3 pictures of me, while at the same time admitting that he has never seen me throw up this alleged gang sign. And he also admitted that he has never seen me use even the verbiage of this gang, which I believe is a complete contradiction from someone who was supposed to be a gang member. He testified that everybody he has assessed to be in that supposed gang of YSL, he can at least bring forth one piece of evidence to show that they have at one instance threw up that gang sign or at one instance even used the verbiage of that gang sign. And I do not fit that criteria in neither of those categories based off his admission and what his assessment was of me. I believe it is insufficient to say that I participated in any street game activity because it has been insufficiently proven. It has been sufficiently proven that I am not in a gang. Moving on to count 19. I would like to, in good faith, move this court for a directed verdict of acquittal on the count of charge of possession of firearm during commission of a felony. There has been no evidence to show and prove that I holstered any type of firearm, nor has there been any evidence to prove that any type of firearm was ever within my reach, which are elements of this crime, which again have not been sufficiently proven and backed by any type of evidence. Again, I will move to count 20 and move this court to a directed verdict of acquittal on this count, which is possession of firearm by first offender probationer, which again, there has been no evidence to prove that I holstered on the 8th day of November or any time a firearm, assault style pistol, or any type of firearm during that day or any day, nor was there any type of firearm within my reach or around me. There has been no evidence to prove such. And so again, I would in good faith move this court for a directed verdict of acquittal on counts 1 through 20.
Thank you, sir. Mr. Hiles, I've got a few questions for you, and then if there's anything you want to add, you can do that. What is your response to Ms. Mignot's observation that in counts 6 and 12, the name of the alleged victim is incomplete and thus incorrect?
So I don't think there's any requirement that I put the individual's full name first, last, and middle. When I had the
well, you couldn't just put Fred, because
correct.
Then someone could be prosecuted 10 times for different Freds, the same Fred.
I agree with that. But when Jackson took the stand, I asked him all 4 of his names. Then he explained that because there is the 4th name, Heil, which is his technical last name, it is on a different line. And so when you had the 3 names on the first line, it appeared on his ID. It appears on his ID that his last name is Buckingham. And I think the fact that there's no confusion that he is Jackson Buckingham, and he acknowledged that.
Okay. Count 16 is the first of the aggravated battery counts. Aggravated battery can be committed when First, there's always the element of maliciously causing bodily harm to another person. That's alleged in the count. But then there is serious disfigurement or loss of a limb or at least temporary loss of use of things. What is 16 alleging?
So it is did maliciously cause bodily harm to.
Element 1.
Yep.
Element 2 is you got to pick one. Which one is picked here?
So it would be serious disfigurement. Mr. Gattani did talk about the scar.
I understand the evidence. I want to make sure that it was adequately charged. So if you look at count 17, what does count 17 say? What was the species of aggravated battery?
So it does say seriously disfiguring, but the difference is that he was alleging a broken nose. That's something that couldn't be seen. And I get, look, after speaking with Mr. Riggs prior to his testimony.
You don't need to worry about 17 because it's out. I'm just contrasting. You're claiming that 16 is a serious disfigurement allegation.
It is.
And clearly the author of the indictment knew how to include the word seriously disfiguring. They're not in count 16. And so I'm wondering if you think it is adequately pled.
I do think it is adequately pled because it does say permanent scarring. And so that's, yes, I do think it's adequately pled.
Okay. Counts 19 and 20. No firearm recovered. Not unique in the annals of criminal history. I've been looking for case law, and I'm going to ask you to get your appellate team to find some. Other than witnesses saying they were big, scary looking guns, how do we know that they were actually firearms? If you possess a pellet gun, for example, that would be insufficient for a conviction for count 20. If it turned out that Mr. Pritchett was there and they caught him and they seized the gun, it was a pellet gun, that's not good enough for 20. We don't have a gun at all. And so I'm going to ask you to I'm going to reserve ruling on 19 and 20. Just because I'd like to have some case law that says the description of the victim can be enough. Most of the cases I bumped into were murder cases, and the way you know it was a real gun is that a bullet came out of it. Right. Your last trial, there was no issue with that. Someone got shot. No one got shot here. They got whacked with the gun. So it could be a replica metal gun that would cause bleeding and fracturing of the skull. So we don't need to resolve it now, but I'd ask for some case law that 19 and 20 ought to go to the jury, even though no one has testified that it was a real gun. Okay. Those are the only questions I have. You're welcome to add more if you want, but those are the areas of concern that I have.
No, I see your concerns, and I guess I will just for the record right now, I think, and I'll get this case law, I'll talk to the appeals department, but the circumstances surrounding the events, it would be foolish. And you can look at the circumstances surrounding the events to go into a house not knowing whether someone else was armed or to hold yourself whether you are armed. To do so, to hold yourself out, to have a firearm and not be able to actually react with it.
Right, you lose that gunfight.
You lose the gunfight. And so I will note the court's concerns or
question.
The
court's question.
But that is the counter to it. And I think it does survive enough to get to a jury.
Well, it survives enough to make it through right now.
Yeah, that's what I'm, yes. Okay.
Yeah. I reserve the right to pull it at any point if there's not there's got to be case law to that effect. I couldn't find it because I was much more focused on what Mr. Pritchett had to say. It just dawned on me, and this has to have come up before. But all the cases I ran into where gun not recovered, it was a murder, and there wasn't but we know it was a gun because the person got shot 3 times. We don't have that here. Okay, so you're not pushing back on count 17.
No, I had a conversation with Mr. Riggs coming in, and he said, oh, by the way, after thinking about it all this years, I don't know if the bridge in my nose was caused by a soccer injury or me getting hit in the nose. And I just said, I'm not gonna ask you any questions about it anymore.
Okay.
I'm conceding, I don't, no, yeah.
All right.
It is not there.
Thank you. So,
Your Honor, we just have one case to cite for the court for the record.
great.
Mahone, M-A-H-O-N-E-V State. It is 348 Georgia App 491. And it is a home invasion count. States that in the case, however, the uncontroverted evidence showed that Mahone did not possess the iron he used in his assault of Willis at the time he entered the apartment. Instead, he found the iron after he made his unlawful entry, and accordingly, the state failed to prove an essential element of the crime of home invasion in the first degree.
Got it. Thank you.
Could you, I hadn't sat down, could you just give me that site one more time, please?
348 Georgia App 491. It's a 2019 case. Mahone v. State, M-A-H-O-N-E v. State.
So here's where we are. I need to rule. And yes, sir.
Before you move, can I please add something quick for the record?
Sure.
Regarding the direct verdict petition. It's just in my occurrence, it has been brought up in previous hearings. I would just like to state that this indictment purports to be invalid, being that it was not returned in open court, and that, you know, the clerk has attested to it. I have evidence that the clerk said that, you know, there are no minutes that it was purported to be returned in open court. And I believe it was on the hearing of June 27, 2023. The state also attested that no minutes exist of the indictment being returned in open court. And according to case law, for an indictment to be valid presentment, it must be returned in open court. And it must be affirmatively shown by a record entry in the minutes.
Okay.
And there needs to be a file endorsement on the indictment itself to show that it was presented by the grand jury and filed in open court. This says filed in office.
Got it. Thank you. You've preserved that argument. In James versus State at 316 Georgia Appeals 406, the Court of Appeals framed the standard for motion for a directed verdict of acquittal as follows: that it should be granted only when there is no conflict in the evidence, with all reasonable deductions and inferences therefrom demands a verdict of acquittal as a matter of law. I don't find that that is the case for counts 1 through 16, or at this point, 18 through 20 either. I appreciate the record that's been made so far by defense counsel and by Mr. Pritchett, which is that there is no direct evidence that places Robinson or Pritchett inside the Wiley Street address. This is a classic circumstantial case for that one piece. I think there is more than enough evidence for the question to get to the jury, that there is direct evidence that Pritchett and Robinson were in Riley's Mercedes and got to within a stone's throw of Wiley. Riley and Kallish get out. When Riley gets back in, Pritchett and Robinson aren't in the car anymore. We learned from both the ladies later on, they had masks, meaning the guys did. They were dressed in dark clothing. Lo and behold, the people who make entry into the house are described for the most part as wearing dark clothing, definitely wearing masks. And then as Riley's trying to figure out what to do next, who hops back in the car but Robinson and Pritchett, and then Kallish gets in the car. They all go back to the Voss Coleman address, and we know what the testimony is. The state's case rises and falls on the credibility of Kallish and Riley, with some circumstantial corroboration, like who was wearing the jacket going in, who was wearing it going out, things being thrown out of the car, etc. But that's just a circumstantial case. The fact that a piece of it is circumstantial doesn't mean that a directed verdict is appropriate. Ms. Mignot is right. Every time she said it many times, that there is no evidence that puts there's no direct evidence, an eyewitness who said, no, the guy with the monkey mask or the guy with the purge mask was Mr. Robinson. And there's conflicting evidence. These people who were drunk or high or both and under stress because they had guns pointed at them and there were people bleeding out of their heads in front of them, have different recollections of what people looked like. And that is, to me, utterly unremarkable in situations like these. And it is certainly fodder for closing argument. It is fodder for reasonable doubt, but that's not the test I apply. If I construe the evidence in the light most favorable for the state, the jurors could reasonably credit, despite their warts and bumps and whatnot, Kallish and Riley's testimony that this was a 4-person operation. And the other two aren't mystery people. They are Robinson and they are Pritchett. And there are some social media communications afterward that are problematic for Mr. Robinson, not so much for Mr. Pritchett. And I think that gets us to the jury on the home invasion, the armed robbery, the aggravated assaults, and the 2 firearm counts, assuming no gun being recovered is sufficient. I'll tell you, the gang, this is a home invasion case with a gang charge strapped onto it. And I regret not having bifurcated it before the trial started. But there is some evidence that this is gang related. It was not concocted by a gang member. At best, it was a gang hanger-oner, meaning Ms. Riley. But it was something that then Voss Coleman and Mr. Pritchett and then ultimately Mr. Robinson latched onto. And there is some evidence that doing something like this furthers the interests of the organization, that being YSL. And again, my assessment that it's not a bright and shiny gang charge doesn't mean it doesn't go to the jury, given the standard that I must apply for motions for directed verdict. The count that fails is count 17. It alleges that Christian Riggs's nose was seriously disfigured. Christian Riggs testified to the contrary. The only evidence of the nature, scope, and extent of Mr. Riggs's nose injury is that I was grappling with someone, I got hit in the nose, not even by the gun, and it may have bled. He either said a teeny bit or a tiny bit, and that's not serious disfigurement, and it's not a broken nose. But the state concedes that. So count 17 at this point, it's out. It will not go to the jury. I'm reserving judgment on 19 and 20, and you can renew these motions if there is more evidence presented. I can always reevaluate. Ms. Mignot, anything you want to get in the record in connection with my ruling on your motions for directed verdict?
Yes, Your Honor. I just wanted to get clarity from the court. If we are providing the court with case law, is that going to be tomorrow regarding counts 19 and 20? Is the court going to reconsider its ruling regarding directed verdict?
Sure. So 19 and 20 right now are going to the jury, but I am open at any point. I can take it away during their deliberations. I can sua sponte direct a verdict whenever. And if I'm legally required to do so, not because of the evidence piece, I think there's plenty of evidence for jurors to decide if they conclude that Mr. Robinson and Mr. Pritchett were the home invaders, they had what appeared to be firearms in their hands. So that's been established, but is appearing to be a firearm enough? That's the piece. And so I want to make sure we're operating in a safe space. I mean, worst case scenario, it would be cleared up at a motion for a new trial if your clients are convicted, because then everyone would have plenty of time and people with super sharp appellate brains would have time to say, you know what, Judge, you let that go to the jury. But you said during the course of the directed verdict discussion that there's no evidence in the record where someone said, oh yeah, that was a Draco. I touched it. I pulled the magazine out. There were bullets in it. It appeared to be a big, scary weapon, or to your point, sometimes it was a small, scary weapon because different witnesses saw the guns differently. I just want to make sure we aren't sending something to the jury that they shouldn't be deciding, because if there isn't sufficient evidence that it's a real gun, I don't know what that would be, that sufficient evidence. And so it's a request to everyone, send me cases, and there's no deadline. If you send your case day after tomorrow and the jury's still deliberating, I can always say, stop worrying about counts 19 and 20.
Thank you, Judge.
Okay. All right. Mr. Hiles, you had jumped up at some point. Was there something you wanted to add? Because if it's case law, don't just send it via email to everyone later. Okay. All right. We are going to bring the jurors back out before I release them for the day. Ms. Mignot, Well, let me do this. Mr. Robinson, it is time for us to have that discussion that I have forecast. Do you understand, Mr. Robinson, that you have a right to testify? And that if you wish to testify, no one can prevent you from doing so. Ms. Mignot can't tackle you and say, don't take the stand. It's going to be a decision for you to make. Do you understand that? Do you understand that in the same way, no one can force you to testify? If you don't want to testify, even though Ms. Mignot or Ms. Blake may be saying, this is your key to freedom, no one can make you testify. And certainly the state can never call you as a witness in this case. Do you understand that? Do you understand that in a moment, I'm going to ask you and not Ms. Mignot whether you want to testify? Do you understand that if you choose not to testify, I will tell the jury that they should draw no conclusions or inferences or anything at all hurtful to you in any way about your decision to exercise your constitutional right to remain silent? Do you understand that if you choose to testify, not only do you answer the questions from Ms. Mignot, which may be difficult because it's a difficult case, but they're friendly questions, but you'll also have to answer any legally proper question from Mr. Hiles or Mr. Pritchett. And those may be ones that are awkward for you and you don't want to have to answer, but you will have to answer them. Do you understand that? In other words, you'll be subject to cross-examination. All right, Mr. Robinson, do you wish to testify in your trial?
Not wish to testify, no.
I find that Mr. Robinson has made his decision not to testify with a complete understanding of his rights. And I will instruct the jury that they should draw no conclusion, inference, or any other finding from the fact that because you have no burden of proof at all, you chose not to testify. Okay. Ms. Mignot, will you be presenting any other evidence at this juncture on behalf of Mr. Robinson?
No, Your Honor.
All right. Mr. Pritchett, do you understand that you have a right to testify and that if you wish to testify, no one can prevent you from doing so? Do you understand that if you don't want to testify, no one can compel or force you to testify? Do you understand that if you do not testify, I will instruct the jury that they should draw no conclusion or finding hurtful or harmful against you? Do you understand that if you choose to testify, you don't get to just tell your story your way, but you will be subject to cross-examination by both Ms. Mignot and Mr. Hiles? You don't get to take the fifth on cross-examination. You understand that? Okay. Do you wish to testify, Mr. Pritchett?
This decision has been made right now.
I just asked the question.
At this moment, I don't.
Okay. So what's going to happen next is I'm going to bring the jury in. I'm going to ask, are you going to be calling other witnesses?
Yes, I'm in car with.
So that maybe doesn't work.
Running into any problems, I know I don't have any more like time than tomorrow.
Right. Well, you lucked out. It would be tomorrow. We wouldn't call those witnesses. But here's what we're going to do. The jury's going to come back in. I'm going to ask Ms. Mignot if she is going to be presenting any evidence. She's going to say, nope, Mr. Robinson rests. I'll repeat to the jury, okay, he has no burden of proof, no obligation to present anything. Then I'm going to turn to you to ask you if you're going to present any evidence. And your answer is going to be?
Yes.
Okay. Tell me not the content of that evidence, but the vehicles through which you will present it. Who do you intend to call as a witness?
I believe the name was Marquise Abdullah.
Okay, that was one of the names that you provided. And Marquise Abdullah is who to you? Someone you know. Okay, well, you know me too. Okay. Did you end up getting any contact information for Marquise Abdullah so that Ms. Mignot and Mr. Hiles can talk with him?
Yes, I did.
Date of birth, address.
Number, contact information, and address.
Okay. Anyone else besides Marquise Abdullah?
yes, but I didn't get their full information, so I'm gonna say no.
Okay. So, your plan, assuming he shows up, and I know it's a little complicated for you to get people to show up, would be tomorrow morning at 9 a.m., you'd have Mr. Abdullah testify.
Yes.
Okay, and because no one really got notice of this person other than on Friday you mentioned his name, can you give us a thumbnail sketch of what he would be talking about?
But it's, you know, where he was on November 8th. What he recalls me doing or, you know, participating in on November 8th.
So remember, I've already told you that you're not going to be able to use any alibi witnesses. So you're not saying that word, but if you expect Mr. Abdullah to say anything along the lines of, oh, Mr. Pritchett, whatever he's going to call you, was with me all day and all night on November 7th and November 8th, he may not testify to that.
Okay, I mean, it'll be, I mean, it's not gonna be on those lines, but it'll be referring to mainly who was at young man's apartment.
Okay. Okay, but you do not intend to rely on Mr. Abdullah's testimony to give you an alibi, that you could not have been involved in this home invasion because you were with Mr. Abdullah. Understand what I'm saying? Because that's what alibi is. So if let's say this, Mr. Abdullah said, hey, I was at Young Bands as well, and Mr. Pritchett was there. And I'll tell you, Tyrone Robinson and some guy I don't know, they left with the two ladies. But Maxx, he stayed with me at Young Band's apartment all night long. And then Tyrone came back with this other strange guy and these two girls, and they had all this stuff they had stolen. That's alibi, and that's not permissible at this point.
I do comprehend that.
Okay.
So it'll be, I mean, however it is, I mean, I don't see him saying yes. I don't see him saying in the way you structured that, I don't see him saying.
Okay. All right. What is Marquise Abdullah's identifying information?
I'm struggling to find right now, but it's here.
All right. Well, that's all right. Let's not find it right now. We'll find it after we release the jury. So what you are committing on the record to me is that at most tomorrow morning, you're calling Mr. Abdullah, and then you may change your mind and choose to testify, which you're allowed to do, but no other witnesses.
Lauren Riley calls.
So we should have Ms. Riley back tomorrow.
Yes.
Okay. I assume we can do that, but we'll work on it. Okay. Anything else? Because tomorrow is not the time for surprises. Abdullah, Riley, Pritchett at most.
Should I just name the possible though?
Anyone that you might call tomorrow, you need to let me know, so that it's really not letting me know, it's letting Ms. Mignot and Mr. Hiles know.
Okay, well, to Officer Wright, please.
Okay.
That's in Buckingham.
So this is the list you gave before. We'll talk about it after the jurors leave. And then you can let me know why you think those folks might show up. All right. Mr. Hiles, anything else before we bring the jurors in?
Are we gonna finish up all the stuff relating to witness information after the jurors?
Yes, sir.
Nothing outside of that.
Okay. Ms. Mignot, anything else before we bring the jurors in?
Nothing further, Judge.
Okay. All right. Let's bring the jurors in, please.
All right, so jurors,
Thank you, Deputy Gordon. Ladies and gentlemen, welcome back. We did what I told you we would do, which was work through a whole bunch of things that occur after the state rests. And we are not going to keep you here much longer, but we're ready to proceed with a little bit more of the case. And my next step is to ask Ms. Mignot if you intend to present any evidence on behalf of Mr. Robinson.
Your Honor, defense rests on behalf of Mr. Robinson.
Thank you. And ladies and gentlemen, as I forecast for you as a possibility, because criminal defendants don't have any burden of proof, it is not at all uncommon for a defense attorney to say, we're not presenting anything in our case in chief. I did what I did with the state's witnesses, and we're not going to be calling any witnesses. That's what Ms. Mignot has just said. And so she's rested, which leaves the accused. Sir, will you be presenting any evidence on your behalf?
Yes.
Okay. That's where we're pausing. I've had a discussion with Mr. Pritchett, the accused, about his presentation. We will start that first thing tomorrow morning. We will get to closing arguments tomorrow. We will get to the jury charge tomorrow. And then you'll begin your deliberations tomorrow. The fact that the state has rested and that Ms. Mignot, on behalf of Mr. Robinson, has rested doesn't mean it's time to start doing online research or talking to other people about the case. Please stay in your information bubble. The lawyers and I are going to stay here a little while longer because we're going to have what's called the charge conference, which sometimes interrupts your day and you have to wait around, where we're going to discuss the law that I will give you so that we can roll straight through what I just described as remaining. Whatever evidence Mr. Pritchett decides to present. And I should say this, he's fully entitled to change his mind and tomorrow morning say, you know what, I'm not putting up any evidence. Okay. Then we turn to closing arguments. The state, because it has the burden of proof, goes first and last with closings. So Mr. Hiles may choose to get up in front of you for a little while, sit back down, let the defendants through counsel or themselves say, here's our closing argument. And then he gets to have last word. Not more time than anyone else. He just can break it into two pieces. When that's done, then I'll charge you based on what we're going to talk about later tonight. And then you will have the case in your hands and in your heads, in your hearts, and you will begin your deliberations. Okay? Any logistical questions? 9 a.m. tomorrow morning. Thank you so much. All right. I would like us to handle the charge conference now. I would say early tomorrow, but I've got a meeting at 8:30 and we're not going to do it at 8 or 7:45. I shared with you all this weekend the draft charge, and we're about to dive into it. I want to confirm that you want the charge conference taken down, because if you don't, we can release Ms. Rivers and then in the morning get into the record if there were disagreements or whatnot. But we'll do it either way. Mr. Hiles, do you have a perspective on that?
Yeah, Mr. Rivers needs to get, I'm fine with releasing Ms. Rivers for the evening, and we can put any discrepancies on the record tomorrow.
Okay, Ms. Mignot, your view on that?
I'm scared to release Ms. Rivers, Your Honor.
Okay, I fully accept that and respect that. And so I don't need to go any further than that. Is a fair request. I just floated out there because every once in a while, the charges aren't what the case is all about, but there may be some charges here that are problematic. I am going to share my screen and we will look at the jury charge. As I'm doing that, let me describe how I do charge conferences. I'm going to jump through the charge to the areas that I highlighted because those are areas where I have a question or a concern or want your input. In jumping to a place, I may jump over an area where you've got a concern. And so say, Judge, go back to page 2 or wherever it is. and we'll work through it. Based on the edits that I make from our discussion today, I'll create a final charge and I will provide that to everyone as well. And Mr. Pritchett, it's going to be up on the screen for you to look at. Okay, here is our jury charge. If I can get it scrolling, the first question I had is on page 3, the charge about evidence. This case is a little different because we have a pro se defendant, and I need to flag for the jurors, and it really depends whether Mr. Pritchett testifies or not, that nothing Ms. Mignot or Mr. Hiles or Ms. Green said is evidence. And that will be true for Mr. Pritchett as well, unless he testifies. And if he testifies, I have to caveat this little bit. So I'm just highlighting it as a placeholder. If he testifies, it will be anything said by me or the lawyers or Mr. Pritchett when he wasn't on the stand or something to that effect. But certainly if you testify, Mr. Pritchett, what you say under oath is evidence in the case, including your answers to cross-examination questions. So I just flagged that for you all. That'll change. On page 6, I will be giving defendant's choice not to testify because we have a defendant, Mr. Robinson, who is choosing not to testify. We may have 2, but I will remove the highlight on that one, and that will be given. On page 9, principal need not be prosecuted. It doesn't quite fit. I know the purpose. It's why wasn't Voss charged? But that's not what this language says, because no one is saying that Mr. Coleman was one of the home invaders. He was at most a planner, and he may have been the one who reached Mr. Robinson, according to the state's theory. Not saying this is what the jury will find, but either Pritchett or Coleman managed to contact Robinson, who came over and said, I'm in. So I think the concept is a legally appropriate concept, but the standard language doesn't quite fit. I want to start with you, Mr. Hiles.
So I think the only, the principal need not be prosecuted. Sorry, that's the language, making it kind of sound like the person who actually, physically committed the crime. But if you look at the language of the charge, as any party to a crime who did not directly commit the crime may be prosecuted for the crime upon proof that the crime was committed and a person was a party to it.
But that flips it around. That would be if you had indicted Voss Coleman and not Tyrone Robinson, and all the evidence was, again, I'm making this up, is that Tyrone Robinson did what's alleged here, then the jurors would be saying, wait, you got one of the gunmen. You didn't charge him, you charged Voss and he didn't go anywhere. That's the right, this is what this says. This doesn't describe Voss Coleman.
I think the charge also goes to the fact that it's only about the defendants in front of you now. It doesn't matter that the others aren't prosecuted. And also, essentially, that it goes to the fact that Lyndsey and Lauren aren't at trial right now. I mean, I know it's been clear that they are actually charged in this indictment, but the fact that they're not sitting at trial, I think it goes to talk about, you can't consider that fact either. So I do think it is appropriate. And I understand your language, which you're flipping it with Voss, but especially considering the fact that Ms. Kallish and Ms. Riley, who did scout it out and go in and set it up, that they're not standing trial right now. I don't want that to be held against the state.
I think you can get boxed around the ears that they're not on trial now, and that's a fair argument, and can be held against you. It's just not, there's not a legal impropriety the way the state's gone about this case.
That's correct. I fully expect the defense to bring that up, and they're correct in doing so. But this principle that it doesn't excuse the alleged conduct of the other co-defendants for the fact that those two aren't at trial at this point.
But that's not what this language says. What this says is someone who didn't directly commit the crime can still be prosecuted, even though the person believed to have directly committed the crime has not been prosecuted. And that's not, Ms. Riley and Ms. Kallish are being prosecuted. They just aren't on trial. Voss Coleman didn't directly commit the crime. He's not being prosecuted. If you want to send different language, I will consider it because I think it is a legally correct statement of the law. And really the jurors ought to hear that statement of the law because they shouldn't be confused. Like, wait a minute, there's something procedurally incorrect. They may decide it's morally incorrect, and that's a great argument for the defense to make, but it's not legally incorrect. It's just not what this says. So I'm tasking you with coming up with some recommended language because this pattern doesn't fit what you have aptly described. All right? All right, moving down. We get to the aggravated battery charge. So the actual aggravated battery charge that starts on 10 and goes over to 11, I don't have an issue with that. That is pattern-ish enough, and I think it fits. The non-pattern number 50 from the state, I think maybe went to Christian Riggs, and that count's coming out. Here we have what is alleged to be permanent scarring. That's what it says in the indictment, so we can't change that. And the only testimony about it is, yes, I still have this scar, and you could see it, and I feel it. It's right there. I don't think that fits the remaining aggravated battery count, and I'm proposing not giving it, but I wanted to give you a chance to make an argument for keeping it. Mr. Hiles.
I just lost my.
It's there. Now that comment didn't need to be there anymore. So aggravated battery starts in the upper right-hand corner, goes to the lower left-hand.
Yeah, I still think the non-pattern charge is the fact that, though you might not be able to see it, it's not always there. It's covered by his head, that his hair is covering the scarring.
Okay. Ms. Mignot, your thoughts about state's non-pattern number 50?
We would take exception to it, Judge. We would ask it not be included. We don't have a serious disfigurement. In fact, there was not even a photograph by the state that was presented of the alleged victims or the victim's head from treatment or.
Right, we have a pre-treatment. I mean, there was a picture of blood coming out of his head and the gash in his head, but not here's how it looks today.
Correct, and that's what serious disfigurement would go to, not the causing of the injury.
Okay. Mr. Pritchett, any thoughts about state's non-pattern number 50?
I adopted Mr. Young's.
Okay. I'm not going to include it, Mr. Hiles. I think that it might have kind of fit for Riggs, but Riggs's aggravated battery is out. As we continue to go through, that's it. Those were the questions I had. So let me turn to you, Mr. Hiles, and ask if there was anything not included that you felt should be included or in there that you think should be out.
I didn't.
Okay.
I don't have any.
All right. You don't have to sound pained saying that. It's okay if I got it right.
I'm just tired.
Okay. Join the club. Ms. Mignot, your turn.
Just the. Did Your Honor exclude the charge about any weapons since there has been no weapon introduced in this case?
I'm not sure what you mean by the any weapon charge.
I think we might have included in our original draft, Judge,
Okay.
and I know it's late and we've looked at a lot.
No, but this is the time to do it. And that would be in relation to possession of a firearm or the armed robbery?
Hold on a second.
Sure. Because on the screen now,
I think it was our charge number 7, Judge, but I'm looking at what you had. No, Judge, we can move on from it.
okay. Anything else?
Nothing further from Mr. Robinson.
All right, Mr. Pritchett, do you have any concerns about the jury charge other than the ones we've talked about and I granted your motion?
This is my first time seeing this. I wish I would have seen it before.
So I'm gonna print it out. I'm gonna give it to you now so you can look at it overnight. And if you've got concerns in the morning, we'll talk about them. Okay?
I had one concern that I got off the top of my head I can say right now.
What's that?
It was in charge of venue.
Venue?
Yes.
Okay, that's right there on the screen.
I would just like it to be specified that the state prove factually what is Fulton County and that they own the territory of where this is led to.
I've missed that part of you. It's surfaced in a little while. That's not what the state has to prove for venue. So I hear your request, but I'm going to deny that request. I will print out the charge as it stands now, though, so you can take it with you. And if you've got anything we need to discuss in the morning, we will do that. Let me make sure this is double-sided. All right, it's working its way this way. I will get a finalized version to everyone. It really hasn't changed much from what you got this weekend. I won't be given state's request number 50. Mr. Pritchett, we need to close the loop on your witnesses for tomorrow. If you're going to call Mr. Abdullah tomorrow, you can't leave here today without leaving behind basic identifiers for him.
I found it.
You found it? Okay, I'm not gonna make you put it in the record here, but if you've got it written down, you can share that paperwork with Ms. Mignot and Mr. Heil so they can write it down. Ms. Riley will be here tomorrow. Everyone else, including Abdullah, you've got the responsibility for compelling their attendance. So you mentioned Officer Wright, who I think is now Officer Weems. The only way she's gonna get here is well, you need to figure out how to get her here. Same with Mr. Buckingham, who I think is technically Mr. Heil, things like that. Okay? But you know that. It's what I told you on Friday. I'm helping you with Ms. Riley because she's in custody, but I'm not aware of any of these other people being in custody. And so it's not my role to get those folks here. Okay?
How can I get this? How can I go about it?
Is not appropriate for me to give you legal advice on how to do something like that. Mr. Heil, Mr. Hiles, do you have any questions?
If he intends to call Ms. Riley, he also, I can give him contact for, I guess, he's gonna have to go through her attorney, because she is representing the charges.
Okay.
So, I don't know of any conversation that's been had with Mr. Keller here up to this point.
So she's been given immunity. What is her ability to say, I'm not going to testify?
I'm not saying I don't disagree with that. But to call her without, I just think it's appropriate to call her without reaching out to Mr. Keller here. He was here present.
Will you please do that? Shoot him an email, and he's welcome to connect via Zoom. I'll note for the record that Ms. Kallish testified without her attorney present, different person. And Ms. Kallish isn't in jail on other serious charges. But Mr. Pritchett's not in a position to contact Mr. Keller here. That's not your problem, that's his. But because I know you have a good working relationship with Mr. Keller here, I'd ask that you shoot him an email that it may be that his client is testifying tomorrow morning. I don't know his schedule, but he or someone else from that firm could patch in via Zoom. We can give them the Zoom link. They're also welcome to be here. I likely will ask Mr. Pritchett to make a proffer as to why he would be calling Ms. Riley, independent of her representation. Anyone who's already testified to be recalled, I need to know what the recall is for. Because if it's, you know what, I forgot to ask some questions before, that's not a basis to recall someone.
That's was my next issue, and we answered it for me. And I just, if this identifying information is not sufficient, I guess, to run a GCIC or criminal background before the testimony of the witness, I would at least ask for a little bit of time to get that done. I understand we're giving some leeway here, it's late, but I'm cool with that. The main concern I would have is if I need to.
Well, let's see what the identifying information is. Can you please give to, if you haven't slid it to Ms. Blake, can you give to Deputy Gordon the identifying information for Mr. Abdullah? Of course, it says the toner just ran out.
Do you have a date of birth?
Tell me what information, not the information, but what information? Is it just a name?
It's a name and an address for Maryland. That's it.
Okay. What makes you think Mr. Abdullah will be here tomorrow if Maryland is where he lives?
Flight.
Okay. Here's what we'll do. If he shows up in the morning, he will give you all his identifying information. If he refuses to do that, he cannot testify. And I'm confident that your crack team of NCIC runners can run an NCIC pretty quickly on him.
Yes.
And I'd ask you to share that with Ms. Mignot, whatever you're able to generate.
And just SEA. You can do me this. I'll just. It's. I'm gonna just write it down.
All right, Mr. Howes, is there anything else we need to cover while we are on the record today?
Nothing from the state.
All right, you'll be ready to go with your closing argument tomorrow morning.
Yes.
Okay, because it could be that at 9:20, that's what we're doing.
Oh, cool. We're ready. I brought the Monday board bag.
Okay.
I don't intend to use it for the first part, but the videos during the second close, I would like to use that. I'll have everything loaded on it. It's just a matter of plugging it in up here. It takes about 6 minutes for it to boot up.
Okay, and in planning for your closing, you're mindful this is not a murder trial?
No, but it's not a murder trial, but I do think we're entitled to 2 hours because it is a capital case.
Do you have case law that says armed robbery trials get 2-hour closings?
I'll get it to you.
Okay. Be thoughtful about how much time you take with the jury.
But I am thoughtful of that.
Okay. Ms. Mignot, anything we need to get on the record before we break for today?
Just some clarity as to the closings tomorrow. I have a PowerPoint presentation. I have taken pictures of some of the testimony in this case, and I have put them in my PowerPoint presentation. Maybe like a 1 minute or 2 minute or 3 second, that kind of thing. I just don't want to do anything to run afoul. And I need permission to, in my presentation, for example, if I say, well, 911 operator said, she doesn't know anything. Click 911 operator, which I don't know anything. Stop. Next slide, that kind of thing.
When you say pictures, so you have on the do not record YouTube video, recorded it, and you would be actually playing back witness testimony in your closing?
Yes, not on the do not record.
Oh.
So what happens is once the video is uploaded and posted, it's out in YouTube land and it stays in YouTube.
Okay, got it.
So in YouTube land, you can go and you can.
Yep. No, I recognize that. So you would be playing back for the jury bits and pieces of people's testimony.
Correct.
Huh.
Not long pieces, very short pieces, but to make it not come from my mouth, but to come from the witness's mouth. So I just wanted us to be able to clear that with the court because.
There's a good choice to flag that. I've never had that happen before. I'm not saying no. I'm intrigued. I like new and different things. I'm going to let Mr. Hiles think about it as well.
Yes, sir.
But thank you for flagging that. Anything else you want to flag?
That's the only thing, and I wanted to make sure that I don't have any issues, but I did not violate any rules, Your Honor. It's, in fact, there's a bunch of them out there from many
Okay.
other prior.
Do you have any understanding with Mr. Pritchett as to who's going to go first? Do you want to talk to him about for the 2 defense closings?
I have not.
Okay. Do you have a preference?
No, but I will find out from him if
Okay.
he wants me to go first.
Okay, if you two would just talk about it, and you don't need to do it right now, but before we start with closings, and we may not do closings for a while if there is evidence that Mr. Pritchett presents in the morning. I don't want to say, hey, you're up next, and then you're like, oh, well, it's supposed to be the other guy. It's just a lot easier if I say, and by agreement, Mr. Pritchett is going first for the defense. So the 2 of you sort that out, and if you can't sort it out, then the default is going to be that you go first, Ms. Mignot, because that's just been the flow.
Correct.
But it doesn't have to be the flow. There may be reasons the 2 of you agree that Mr. Pritchett would give the first of the 2 defense closings. I'm very open to doing it in whatever way you all agree, if you can't agree.
Got it.
Okay.
I like flow for jurors because sometimes changing flows mess things up. But
I leave that to the 2 of you. So you guys talk about it in the morning or today before folks go. Mr. Pritchett, I'm going to get you, my printer just ran out of toner. So I got to page 8. I'm going to go print out the rest of the jury charge. So you have that tonight. Anything else from your defense?
No, I mean, but in closing arguments, what am I limited to?
So you're not testifying. You are sharing with the jury why they should decide the case in your favor. And you do that by pointing to weaknesses in the state's case, absence of evidence, conflicts in the evidence, but you don't bring in new evidence. Let's say that you happen to know that you had a real bad cold during all this, and so your voice would have sounded funny. And there's no evidence that you had a real bad cold. So if you started telling the jury, another reason that you can tell I wasn't there is that I had a real bad cold then, and you didn't hear any jurors, you didn't hear any of the witnesses say that. That would be improper. Mr. Hiles's head will explode if you try to do something like that. Properly so. And I'll tell you, stop doing that. And if you do it too many times, I'll say you're done with your closing. So it's stick to the evidence or lack of evidence or conflicts in the evidence. And that's what you tell the jury. And so based on that, not guilty, not guilty, not guilty.
Is there any discretion if I, read from the Bible?
Facts aren't evidence.
But it depends what you read. If you are sharing with the jury an important philosophical principle, I'm making it up, do unto others as you would have them do unto you. I don't know how that fits in this case. There'd be nothing wrong with you saying, you know what, it says in whatever book that is, do unto others as you have them do unto you. Here's how that applies to this case. But you're not going to be able to read 3 chapters from the book of Matthew. But if the parable of the sower makes sense here, then you might share that with the jury, because it's not facts that are not in evidence, that Moses lived to 912 years. That would be a fact, but you get it. If it's a principle that you think is relevant to this, then you can share that. God said, never judge someone only on circumstantial evidence. Okay, you can share that with them. But if you start going too far into that, Mr. Hiles would likely object, and I would likely sustain it, because it's not a sermon. Okay? Anything else? All right. We'll see what happens in the morning. Are you good? If you don't mind keeping him up, I just need to print out a few more pages, and we'll go off the record. Thank you so much, Ms. Rivers.